excellence, integrity, in professionalism, all the values we pursue. We shall rise, we shall never falter, though the tide against us shall turn. Forward, forward, onward we go, our greater future behold. In the midst of all uncertainties, our glory still shall unfold. Forward, forward, onward we go, our greater future behold. In the midst of all uncertainties, our glory still shall unfold. Together raising our voice, against injustice we shall speak. All the toil and the labor over heroes past, forgotten they shall never be. Members young and old from far and near, meet together to harness the skills and resources. And the glory over continents. Forward, forward, onward we go. Our greater future behold. In the midst of all uncertainties, our glory still. Our greater future behold. In the midst of all uncertainties, our glory still shall unfold.
We've come this far, we have a home, bright as the stars, against all odds. We'll fight together and take a stand. With one voice we raise the rule of law. One heart, one voice is all we need to build a nation. With gender equality we will stand. 'Cause justice and the governance is what we need for innovative possibilities. From the small, we have a home, bright as the stars, against all odds. We'll fight together and take a stand. One voice to raise the rule of law. Oh Lords and voices, all who need to build a nation. Build a nation. For gender equality we will stand. 'Cause justice and the governance is what we need. What we need. For innovative possibilities. One heart. Lords and voices, all who need to build a nation. For gender equality we will stand. 'Cause justice and the governance is what we need. What we need. For innovative possibilities. Creating new frontiers, visionary leadership. We're stepping forward towards so united bond. Creating new frontiers, visionary leadership.
But I didn't. But I won't respond to. I won't criticize my boss. I won't criticize my successors. I won't do any of that. Okay.
Nigerian Bar Association, let's step forward. It's our 60th anniversary. Let's step forward. We are moving ahead. It's our step forward. This is our time. Let's step forward. We are not proud of things we have gone through past times. This is the time to step forward. Let us all stand together for the unity. Rule of love is our God. Professionalism, respect for human rights, good governance, fairness and equality before the law. Justice, integrity, transparency. Step forward. Let's celebrate Nigerian Bar Association at 60 years. Step forward for moral consciousness. Step forward. protection of the weak in the society. Stand forward for justice and equality. Stand forward. We stand for what is right anytime and a day. With a few people. Stand forward. No one is above the law. Let us rise up. We are the hope of the future. We are the hope of Nigeria. Nigeria Bar Association celebrating 60 years.
All hail the foremost lawyers bar, Nigerian Bar Association, promoter and protector of human rights and the rule of law. We uphold the dignity of all. Courage, excellence, integrity, in professionalism, all the values we pursue. We shall rise, we shall never falter, though the tide against us shall turn. Forward, forward, onward we go. Our greater future behold. In the midst of all uncertainties, our glory still shall unfold. Forward, forward, onward we go. Our greater future behold. In the midst of all uncertainties, our glory still shall unfold. Together raising our voice, against injustice we shall speak. All the toil and the labor over heroes past, forgotten they shall never be. Members young and old from far and near, meet together to harness our skills and resources for the greater good of our neighbor and the glory of our continent. Forward, forward, onward we go. Our greater future behold. In the midst of all uncertainties, our glory still shall unfold. Forward, forward, onward we go. Our greater future behold. In the midst of all.
My name is J12. Step forward, MBA. Step forward, step forward, MBA. Step forward. MBA at 60. Step forward in style. The largest bar in Africa. Step forward in style. Happy anniversary, step forward in style. Happy anniversary, step forward in style. It's not easy to be 60. We've passed through a lot of hardship. We have courage to keep pushing. It will always end in victory. Excellence and integrity, professionalism always. Hey. MBA at 60, step forward in style. The largest bar in Africa, step forward in style. Happy anniversary, step forward in style. Happy anniversary, step forward in style. MBA at 60, step forward in style. The largest bar in Africa, step forward in style. Happy anniversary, step forward in style. Yeah, happy anniversary, step forward in style. My name is J12. Step forward, MBA. Step forward, step forward, MBA. Step forward. MBA at 60. Step forward in style. The largest bar in Africa. Step forward in style. Happy anniversary. Step forward in style. Happy anniversary, step forward in style. It's not easy to be 60. We've passed through a lot of hardship. We have courage to keep pushing. It will always end in victory. Excellence and integrity. Professionalism always. Hey. MBA at 60. Step forward in style. The largest bar in Africa. Step forward in style. Happy anniversary. Step forward in style. Happy anniversary. Step forward in style. MBA at 60. Step forward in style. The largest bar in Africa. Step forward in style. Happy anniversary. Step forward in style. Yeah, happy anniversary. Step forward in style. My name is J12. Step forward, MBA. Step forward, step forward, MBA. Step forward. MBA at 60. Step forward in style. The largest bar in Africa. Step forward in style. Happy anniversary, step forward in style. Happy anniversary, step forward in style. It's not easy to be 60. We've passed through a lot of hardship. We have courage to keep pushing. It will always end in victory. Excellence and integrity. Professionalism always. Hey. MBA at 60. Step forward in style. The largest bar in Africa. Step forward in style. Happy anniversary. Step forward in style. Happy anniversary. Step forward in style. MBA at 60. Step forward in style. The largest bar in Africa. Step forward in style. Happy anniversary. Step forward in style. Yeah, happy anniversary. Step forward in style.
Good morning, everyone, and welcome back. It's day 2 of the 60th Annual General Conference of the Nigerian Bar Association. My name is Esther Awoni. Glad to have you all back with us again today. We had an amazing first day yesterday, and today we have a raft of exciting, thought-provoking panel discussions ahead for you today. And to start today's first panel session, we have one titled Shifting the Paradigm, a Virtual Judiciary Age. Now, it's a must-watch session which will focus on navigating the adaptability of the judiciary in the delivery and administration of justice in the virtual age. Now, our lead speaker for this panel is Lord Angus Glennie QC, Senator of the College of Justice, Principal and Commercial Judge in the Court of Session, Scotland. The session chairman is Oba Nsugbe QC, Senior Advocate of Nigeria. And for the panelists, we have Abubakar Malami, Senior Advocate of Nigeria and Attorney General of the Federation. He will be ably represented by the Solicitor General of the Federation, Mr. Dayo Apata, Senior Advocate of Nigeria. Also on the panel is Paula Hodges, QC, Partner at Herbert Smith Freehills. Also on the panel today is Professor Githu Mugai, the former Attorney General of Kenya. Also on the panel is Chief Mrs. A.J. Ofia, Senior Advocate of Nigeria and Partner at Obra Legal. And last but not the least for this panel is Damola Sholanke, Director of Public Sector, Microsoft.
Your Excellency, my lords, distinguished colleagues and guests, good morning and welcome to the conference session, Shifting the Paradigm, the Virtual Judiciary Age. My name is Oba Nsugbe, and I will be moderating this morning's session. It would be an understatement to say that 2020 has been a very different year to that which we all envisaged. The advent of COVID-19 has certainly made that clear. For a period of time, it literally brought the whole world to a standstill. No strata of life has been untouched by this pandemic. The delivery of justice and the practice of law certainly have not been immune to its effects, and we've seen significant disruption worldwide in this vital area which glues society together. It resolves disputes, it maintains law and order, it is a key area of government. However, one of the inherent paradoxes of COVID-19 is that whilst it has slowed down or put a stop to many activities, it has accelerated others. One such area is the use of technology for justice delivery, and in particular, the advent of virtual hearings, the important topic we want to examine at today's conference. Therefore, this session could not be more portentous. In order to do this, I am joined by a stellar panel of judges and practitioners, and indeed also from the business sector. A warm welcome to all of you, my fellow panelists. My gratitude to all of you for kindly agreeing to share your knowledge and experience in this important area this morning. As I front-loaded my application yesterday, I know that you will forgive me if I do not, in the course of the morning, introduce you as fully as your distinguished bios would otherwise dictate. It is only the strictures of time which militate against this, but your full bios are available on the conference platform. So to give you some idea of the order of events, we will begin this morning with our lead speaker, Lord Glennie. We will hear from him for about 15 minutes, and then each of the panelists will address this important topic from their own vantage points. And of course, they have different experiences that we wish to hear from. They will speak for about 5 minutes each, and I will try keep an eye on time. We will seek to interrogate this topic from a number of different vantage points. So you are aware, Lord Glennie unfortunately cannot stay for the whole of the session. He will have to leave towards the end around the question and answer session. In fact, he is in court this morning on a remote hearing, on a virtual hearing. So we can think of no better excuse than that to thank him in due course and to allow him to part ways with this panel. So I am delighted with that to welcome our lead speaker this morning. Lord Glennie is a judge of the Court of Session in Scotland, the High Court Justiciary. He is a graduate of Cambridge. He spent many years as a QC in London practicing from the Temple. Then he qualified in Scotland, taking silk there as well. He was appointed a judge in Scotland in 2005, and he principally practices in the area, or judges in the area of commercial law and intellectual property. He was promoted to the Inner House, the Court of Appeal, in 2016, and he sits on appeals in civil and criminal cases. Lord Glennie, you're very welcome, and we look forward to your delivery. Thank you.
Thank you very much, Oba. Can I rely upon you to signal if for some reason you can't hear me? But I'll assume I can be heard unless you tell me otherwise.
Yes.
Thank you. Thank you. Well, good morning, ladies and gentlemen. I'm honored to have been invited to speak as lead speaker on this topic. In normal circumstances, I might have gone on to say that I'm delighted to see so many of you in the room attending this session. But of course, I have no idea how many of you are logged in. That is one of the problems we face in this age of virtual communication. Since the pandemic hit home in the early part of this year, the judiciary, like all other elements of society in the UK and elsewhere, have been playing catch up. I can only speak about Scotland, which, as you all know, is a separate legal jurisdiction within the UK. But I suspect that what I have to say applies broadly across the whole of the UK in general terms. In mid-March, all criminal and civil proceedings in Scotland came to a sudden halt. They were in effect put on hold. Since then, strenuous and concerted efforts have been made to get things back on track. This has invariably required the use of technology and the introduction of virtual hearings. In some cases, the entire proceeding is virtual, where the judge sits at home with a screen in front of him linked to other participants, whether judges, barristers, solicitors, and so on, by virtual technology. In other cases, where live attendance is a necessary part of the process, there's a need for social distancing to avoid spreading the virus, and the use of technology is an essential tool in achieving this. I thought I would share with you some of our experiences in Scotland and some of the initiatives put forward as a way of dealing with the problems. But we have to remind ourselves what is the problem that the pandemic has caused. The main problem, it seems to me, is the risk of spreading the virus by large gatherings of people, whether or in the particular courtroom. The virus appears to be airborne, so that the main risk of infection comes from large numbers gathering indoors without adequate distance between them. But it may also spread by contact with surfaces, that's tables, door handles, paper documents, and so on. And it's to overcome all of those concerns that various strategies have been adopted and protocols put in place, largely designed to limit the number of people gathering in one place, ensuring adequate space for social distancing, and preventing too much contact with surfaces and documents. So what are those strategies and how well do they work? Let me look at civil proceedings first. I myself sit in what we call the Inner House, that's the Court of Appeal, and have direct knowledge of proceedings on appeal from the lower courts. But I can speak also about what goes on at first instance in the Outer House, that's the first instance court. No reason to doubt that the procedures will apply in the lower. Civil trials at first instance I've just about, except in urgent cases, that's cases involving children or where there's a particular commercial imperative. Interlocutory hearings continue. If a hearing is required, sometimes written submissions. If a hearing is required, it's conducted remotely, often just by a judge sitting at his home hearing on his telephone, through a conference call set up in advance by his clerk. If a full trial is necessary, for example, in case of child abduction or custody, it may be necessary to have a hearing in court, but the court is generally big enough to accommodate judge and counsel if that is required. In fact, in the cases I know about, everyone, including judge and counsel, conducted the hearing from their own homes and studies. And the priority is really to avoid witnesses having to come to court, and their evidence taken remotely, either by Zoom or by WebEx is a system we use, or some other technology from their laptop or even on their mobile phone. Though the sound quality can, of course, be variable, particularly if it's given by mobile phone. The main concern has been to ensure the witness is by himself in a room, so there's no opportunity for him to be prompted or influenced by others when giving evidence, and that he has access to all the documents to which he might be referred. Now, avoidance of external interruptions is also difficult to avoid entirely. But reports from judges who have conducted trials on this basis suggest they have not found it difficult to make an assessment of the witness and his credibility or reliability when the witnesses have given their evidence in this way, any more than they would have done if they had given their evidence live in person in court. In my practice at the commercial bar in London, particularly in arbitration, even in Scotland, evidence was quite often taken in this way, by video link or even by Skype, and there was general satisfaction that it worked. But it's necessary to think ahead to make sure the witnesses have access to all the documents they may be referred to. Otherwise, the thing breaks down. So what is critical here is organization, forward thinking, planning, knowledge of what you're going to be submitting, what documents you're going to be referred to, and so on. Now, moving on to appeals in both civil and criminal proceedings, they have gone totally virtual. We resumed appeal hearings in May and are hearing appeals almost every day now. I've not had to go into the court buildings themselves since the middle of March. We don't use Zoom for such hearings, but instead we use a system called WebEx, may be familiar to many of you. It operates in a similar way, and that's the limit of my expertise on technology issues. The system allows 3 judges, the clerk, 1 or 2 counsel on each side, all to participate effectively from their own home or in their offices. The system is designed to allow others, the press or interested parties, to listen in by prior arrangement. They're given a code to give them access as part of the commitment to open justice. And they do attend. In a hearing yesterday, we had well over 50 people who were interested in the case, but not parties to it. And though the system does not as yet provide for casual access by members of the public who might be interested, might not be interested in a particular case, but just want to see the courts in action, that's something that's going to have to be addressed in due course. In addition, each judge has what we call a virtual room on the WebEx system. It enables judges to break off from the hearing if some point has arisen or at the end of submissions to discuss the matter privately in one of their rooms before coming back into court to give a decision or resume the hearing. There are difficulties, of course. Someone may have a bad internet connection. People forget to mute and unmute their devices. They can't be heard, or some background noise can be picked up. The system takes a bit of getting used to. It's surprisingly tiring, and this is, I think, a thing we've learned with experience. It's surprisingly tiring listening to submissions and working on a small screen. So parties are encouraged to prepare and submit in advance much fuller notes of argument than they might otherwise be encouraged to do. It takes time for documents to be brought up on screen, and for the advocate, there's often an uncertainty as to whether the judges have the paper they're referring to. It's not easy for a judge to intervene to ask for clarification because you end up talking over each other. So questions are left to the end when the moment when they really mattered has passed. And you miss out on the eye contact and body language between judges and between judge and counsel, which is helpful to the process of argument and decision making. These are important matters. They have an impact on the style of advocacy that's most effective. At the bar, my own style of advocacy, this is a personal comment, tended to be conversational. You would hope to get some reaction from the bench early on in your submissions, and if the court was silent, you rather ran out of steam. That style doesn't work in virtual hearings, where the judge is reluctant to intervene as readily as in a live hearing. Equally, full-blown oratory of the old-fashioned sort, which might have worked in a live courtroom, will fall flat in a virtual hearing where oratory is heard and viewed on the screen. I suspect there's room for relearning advocacy styles and techniques. But with those limitations, the system seems to work. No doubt it's capable of improvement, but that will be a gradual process. The greatest challenge arises in high court criminal trials where the need for jury imposes additional demands. The initial problem is mainly one of space. How do you ballot a jury without having them all very close to each other in a crowded courtroom? How can you install a jury in a courtroom or a jury box while maintaining social distancing between them? One suggestion raised very soon after the pandemic first struck was that we should move on to a system of trial without juries, by judge alone. That caused, as you can imagine, a massive outcry, and the idea was dropped. So I'm not going to say any more about it, but no doubt the matter will be raised again at some stage by someone, and we'll have to wait and see what the outcry is, if there is one. I'm not going to go into all the details. The problems of balloting a jury have been overcome by taking the ballot and selecting the jury a day ahead of the trial without anyone having to turn up in court. So we have 15 jurors, they choose 15 and 5 substitutes just in case there is a necessity to change one who has been balloted. The trial itself, there's been experiments with a 2-court system and a 3-court system. Preference at the moment is for a 2-court system. And what that means in short is this: you have judge, counsel, accused, and witness, plus necessary clerks and ushers, all gather in one courtroom, while the jury sit in another courtroom with a video link, enabling the jury to see everything that's going on. The image the jury gets via this is first a close-up of the accused, second a close-up of the witness, and third a general view of the court, including judge and counsel. And the judge and counsel, for their part, see the faces of all jurors in real time, positioned above the jury box with numbers 1 to 15 to identify individual jurors by number, but not by name, obviously. And there's room for the press and interested parties to sit at the back of the courtroom. That's the court where the judge and counsel are present. The numbers are limited to ensure social distancing. And there's the usual provision for hygiene, for spraying surfaces, wiping them clean, and so on between witnesses and the like. The reports back from how this is working are positive, but at the moment there's only been a few trials, one at a time in Edinburgh, one at a time in Glasgow. And it involves extravagant use of court space. You have the 2 courts needed for every trial. And it's not viable in the long run. There's a massive backlog of High Court criminal jury trials due to the fact there were none at all for some 3 months. And there's a big catch-up to be undertaken. And the system will have to be rolled out more extensively, and that can be done only by finding additional space to house juries separately from judge, counsel, and witnesses. And one proposal being considered at the moment, I think it's been agreed in principle, and it's an expensive process, is to make use of cinema complexes. Complexes with maybe 5 or 7 screens, each one holding the jury for a particular trial, where they will sit in deliberations, they'll sit and watch the proceedings. And the proceedings will happen in the courtrooms and will be beamed by technology, if beam is the right word, I'm sure it isn't, beamed by technology to the cinema complex, where the jury will sit and watch as though they're in the courtroom. These systems place great demand on judge and advocate. As a judge, making sure the jury understands what is going on is much more difficult if you can't see them live. You can't assess their body language, you can't make eye contact with them, which is an essential part of any real dialogue. For the advocate, there's the same problem as in the appeal court, that you have to adapt your style to fit new circumstances. It's rather like, I suspect, an actor who is used to appearing on stage, suddenly into a film or on TV, having to adapt styles. The sort of oratorical flourishes that might seem to work in front of a live jury will probably not work in a virtual court. The advocate's voice will sound different through the medium of virtual technology. So be prepared. My tip would be prepared to relearn some of the skills that you thought you had as an advocate. A final thought, I'm coming to the end. Don't worry. A final thought to leave you with. Some people have suggested that virtual hearings are here to stay long after the pandemic has left us. This idea is met with resistance. For my part, I cannot see it taking over completely, but there may be some aspects which will continue to be virtual. Even before the pandemic, we became used to taking evidence from vulnerable witnesses in criminal trials by video link from different parts of the court building. And in commercial matters, we've sometimes gradually more frequently taken evidence in this way from remote parts of Scotland or elsewhere in the world. It saves a witness traveling unnecessarily for sometimes very short questioning. Recent experiences have perhaps accustomed us to it as part of the new normal. We'll see how that works out. I hope this account of our experience in Scotland will have been of interest and given you some food for thought. I, for my part, look forward to the discussion to follow in this session. We'll be interested in finding out how you in Nigeria and other countries are dealing with the problems caused by the virus. I'm sure we can all learn from each other. But I'm afraid I won't be here, as Oba has said, right to the end. I have to leave early to start an appeal hearing in Edinburgh at 10:30 UK time. That's about 10 minutes before this conference closes, or about the same time. Lagos 1 minute, Edinburgh the next, without even a flight or a change of clothes. One of the advantages of virtual hearings. Thank you.
Thank you very much, Lord Glennie. If you were coming to Lagos, we'd insist on a change of clothes, and we'd find some native attire for you to wear. That you've raised a number of fascinating points, which we will interrogate later. The Scottish experience seems to be pretty much replicated elsewhere. But the points you raise about the loss of eye contact, language, and so on, something that I think is really very key to one of the disadvantages of virtual hearing. Thank you so much for that presentation. Extremely interesting. Now, I'm going to move, if we have the Honourable Attorney General and Minister of Justice ably represented by the Solicitor General. If Mr. Apapa SAN is present, I was going to move to him. If not, I will move now to Paula Hodges, who can briefly give her response to what Lord Glennie has said. And can I briefly introduce Paula Hodges QC? Paula is a very experienced arbitration practitioner. She heads Herbert Smith's arbitral practice in London, a large department. She also took silk in 2014, a raft of the solicitor silks that have been gracing our legal practice in the UK. And she is the president of the LCIA in the UK, and she has been the president from 2019. Paula, thank you.
The voicemail of Daniel McConkey. I'm sorry I can't take the call, but if you'd like to.
I will proceed. I wasn't sure if someone else is going to intervene for a moment. Please stop me if someone else has arrived.
Please proceed. Yeah, thank you very much, Paula.
Thank you. Well, I'm delighted to be involved in the conference today. I'm only sorry not to be in Lagos. I'm missing my trips to Nigeria. So I have tried to have the conference background as some comfort that I'm actually with you in spirit. As Lord Glennie said, the pandemic has had a terrible effect on people all over the world. And I'm someone who always looks at a glass half full, and there has to be some advantages coming out. And I think it will help the dispute resolution sphere as a whole to actually get into the 21st century. I'm going to speak predominantly about arbitration. And I would say I've been really proud about how practitioners and stakeholders around the world have responded to the challenges of the pandemic and really kept the ball rolling. I suppose in arbitration, we were lucky in the sense of, because we have hearings taking place all over the world with parties, counsel, arbitrators from different countries, we've had to be flexible. We've had to embrace technology to a large extent already. But that has mostly involved electronic filings, perhaps procedural hearings taking place by video conference or telephone. But on the whole, merits hearings have taken place in person at the arbitration. But what we've seen now is that arbitrators have embraced the idea of virtual hearing and have been quite robust about ordering virtual hearings to avoid delay. And the institutions have also responded, I think, to help the arbitrators by confirming that their rules do allow virtual hearings. Various protocols have been issued. I was delighted to see the Lagos Court of Arbitration, where I've participated as counsel, putting forward a protocol very quickly. Also the African Arbitration Academy. And then the LCIA, of which I'm lucky to be president, was in the process of updating the rules when the pandemic hit. So we've been lucky enough to actually include in the new rules reference to virtual hearings being allowed. Electronic filing is now the norm. And so I think to an extent, we will not now return to the old ways. I share Lord Glenn's view that I think we won't move completely to a virtual dispute resolution system. But I think more often we will have procedural hearings at the very least taking place virtually. And there are great advantages of that in terms of efficiency, saving costs, saving the environment. And then just my last point, because I'm sure I must be running out of time now. I also hope it will help diversity, which is another thing that we've been trying to promote in arbitration. I think we've done well on the gender perspective. There's more to be done. But I think if we have virtual hearings, electronic systems, we will be able to involve more arbitrators from all over the world, have seats all over the world, and really diversify the whole system. But I'll stop there, over.
I was, yes, just...
Thank you very much.
Today is Thursday.
Can I just indicate that we've got somebody called Brian Spears who's basically we can hear on the conference line.
He had agreed to.
Brian?
Yes, well...
Can we mute Brian, please? Thank you. Thank you very much for that, Paula. That was very illuminating, and you did stick to your 5 minutes, which was excellent. Thank you for that. I didn't need to intervene. Next is Chief Mrs. Anayo Ofia, SAN. Mrs. Ofia is also an arbitration practitioner, as well as being obviously a litigation specialist. She is a former Attorney General and Commissioner for Justice for Enugu State. And interestingly, and I think apposite for this conference, Mrs. Ofia is a member of the Enugu State ICT Committee on Virtual Hearings 2020, and indeed also a chairman of the Enugu branch Appointment of Judges Committee. You're very welcome. Thank you very much. Can we have your 5-minute response as well? Thank you.
Thank you very much. Thank you very much, Leonard Essien. Let me start by saying that Nigeria has not been any exception to the impact of the pandemic, and the judiciary in Nigeria had need to reposition itself to be able to cope with the fallouts of the pandemic. And in response to this, most of the judiciaries, the state judiciaries, started up by making practice directions to include virtual hearings, which were thought to be a solution to the effects of the pandemic, so as to maintain the NCDC protocols, avoiding people clustering together. But then this agitated the legal community in the country, and there were arguments as to whether virtual hearing is constitutional or not, taking into account particularly Section 36 of the 1919 Constitution of the Federal Republic of Nigeria, which makes provision for hearing of both civil and criminal cases to be conducted in public. In response to this, the National Assembly proposed a bill to amend the Constitution, especially Section 274 of the Constitution, which entitles judges, chief judges of states, to make procedural rules for conduct of proceedings in their states. And when this happened, two states, Lagos State and Ekiti State, responded proactively, bringing an application to the Supreme Court to pronounce on the right of the National Assembly to make provision, whether that would not be invading the powers of the heads of court as provided under Section 274 of the Constitution. In any case, the Supreme Court held, because of the circumstances of the case, held that the two cases were premature, they were speculative, and they could not be taken. But that notwithstanding, the Supreme Court made a categorical statement that virtual hearing was not unconstitutional. Even though they didn't decide the issues arising in that case, but they did give that clear indication. And I'll mention specifically the contribution of one of the justices, Justice Ejembe Eko, who said that apart from what is the fact that these cases are premature, that the heads of courts, having made practice directions to accommodate virtual hearing, their acts under the Evidence Act enjoy presumption of regularity. And so we are now assured, at least in Nigeria, that virtual hearing can be proceeded with. But that is not just all. If you look closely at Section 36 and Section 36, subsection 3 and 4 of the Constitution of the Federal Republic of Nigeria, it does not define public anywhere. So I'm just taking this perspective because that is the challenge that we were having as to whether we should really go into virtual hearing or not in the country. Section 36 does not actually define public. So you can safely presume that public would just mean a gathering of people either in a circumscribed location or a gathering of people by technological means, and that will see the public and take it from there anyway. You can imagine that, that there cannot be anything more public than a virtual hearing in this context. If we reckon that there are at least 40 million Nigerians that are using smartphones these days. And if you can have 40 million key into a proceeding in court, then you cannot say that it is not public. So we overcome that constitutional doubt as to whether virtual hearing is constitutional or otherwise. But there is a little snag to that. Our rules of court hitherto seem to suggest that for a hearing to be valid, it requires physical presence of litigants and lawyers in court. Most rules of court make that provision. But I don't think that should be so, especially where we have these definitions. Now, it makes it not so easy for judges to make orders specifically without more directing that virtual hearing should be adopted for the hearing of any case. So the need for these practice directions and the amendment of rules of court becomes very evident. And that's what many courts have been trying to do in the past few years, few months in the country. Luckily, the Nigerian Judicial, the National Judicial Council had given clear and specific guidelines and regulations on that. And most heads of courts in various states have adopted that. In my state, our judicial committee on this ICT is looking very closely on it, working with the NJC guidelines. Now, the question arises, and as it does in many cases, how would virtual hearing rub off on litigants? Will they be subjected to any disadvantage? Will they be alienated? And from my personal experience as a practitioner, the impact of virtual hearing on litigants can be taken from various perspectives depending on the category of litigant. You have litigants who are digital aliens, who don't have any knowledge of digital world, and you have some litigants who are digital migrants, mastering knowledge of digital proceedings and digital native.
30 more seconds, please. 30 more seconds.
Yes, 30 more seconds, yes. So yes. With this, we would have to know how to handle them. And for this, I think the lawyers on their part will have to do a lot of work, acquiring the skills, even the judges also. We also need, let me jump a bit and say that we need to digitalize our court processes and proceedings, creating an e-registry so as to have things working, training and retraining of personnel, judges, lawyers, and reassessing the criteria for appointment of persons to the bench, making sure that they are also digital savvy to minimize the problem.
Thank you very much. I have to intervene. I was I was raptured by your presentation, so I allowed you to go over the 5 minutes, but I know that you'll have time to expand later on. We're very grateful, Chief Ofia. Yes. In fact, you're a graduate of my father's university at Nsukka, so
really?
That's partly why I gave the allowance. Now, can we now move to the business sector? We have the real privilege of having someone from the business sector who I'm sure will be thinking to himself that he's going to be very busy because of the advent of virtual hearings, and I'm sure he's right. Can we welcome, please, Mr. Damola Solanke from Microsoft, who's a director at that August company. Mr. Solanke, you're welcome.
Thank you very much, and good morning to everyone. So I will just share my screen because I wanted to sort of share some perspectives from the business sector, which I think were very, very real for us as COVID took over and the pandemic came across. So again, for us, I think one of the key things that we begin to think about is COVID sort of made 2 years of digital transformation that we were expecting to happen within the court systems happened within a 2-month window. So the pandemic really did for us what we didn't expect, which was an unscheduled pilot of technologies across different aspects of the industry, specifically in the court systems. And to just expand on sort of what I believe would be the true justice continuum that we would need would be a situation where from police investigations to making arrests to warrant appeals, and then up to the court trials and the virtual hearings, sentencing, transfer of custody, through to release and return to community. We believe that there needs to be a continuum across the entire justice system, and not just a case for virtual court hearings, but a case for an end-to-end integrated data system that integrates all the way from police investigations through the entire justice continuum that we have. I think the second point I wanted to speak to was really just thinking about how the justice operations are modernized. So e-filing portal as an example, there's a lot of work that we have done with the NJC with regards to legal mail, leveraging the case management platform that they have. But again, there's a whole lot more that, needs to be added onto that platform to really modernize justice operations. And you can see, as I'm sharing, there's document management of court files, electronic bundles. So the bundles that are taken to court, imagine a ton of papers that are printed. If all of those could be made electronic and made available to all participants as an example. Smart scheduling, where you can tell the schedule of judges and you can automatically identify which judges are available based on their schedule and availability and automatically allocate them to cases. We talk about notifications, the virtual hearings themselves and trials. Another interesting part of that is a judges portal, which we believe will be very interesting for judges to sort of quickly have a review of their cases, either on mobile or on a tablet, or get into the court. And then we talk about things about court fees and then alternate dispute resolution and online dispute resolution, which we believe are very key to modernizing justice operations. And I think, further down the line is where we begin to see technology sort of take a hold in terms of how we apply technology to a true justice platform, where we're using robotic process automation and automating key processes that are very mundane within the courts, using smart agents, using blockchain, for example, to issue court orders, so when someone has received a document, indeed they received it and that cannot be altered. Using artificial intelligence to complement activities that happen in the court, could be transcribing as an example, and there are many use cases for artificial intelligence as an example. Business process using Internet of Things to manage workflow management, track documents, and machine learning. At the end of the day, there's a ton of data that is generated within the courts. There are so many cases that can be referred to. We can leverage machine learning to learn from past cases, and then at the end of the day, we provide a true virtual courts platform that we believe that can really elevate where we're going with this conversation.
1 minute warning, Mr. Solanke, please. 1 minute warning.
And I think this is my last point. I think we believe that the law should be accessible for everyone at all times, and that is the role technology will play at the end of the day. And I think that at the end of the day, for us, virtual courts is here to stay, and is here to stay because, again, we just cannot do away with it. So thank you.
Thank you very much. Excellent presentation, very interesting. Our last speaker, last but not least, we have the benefit of a jurisdiction which is close to ours, namely Kenya. And I'm going to turn now to our next speaker, who is a former Attorney General in Kenya. He was Attorney General until 2018. He's a leading practitioner in Kenya, Professor Gitu Mugai. Professor Mugai, thank you.
Thank you very much. Wish to thank yourselves for inviting me all the way.
Professor Mugai, I think you're on mute. Can you unmute, please?
Oh, can you hear me now?
Yes, we can, yeah.
Okay, thank you. I was going to say that the few things I will say cover Kenya essentially, but they are true of East Africa, meaning Kenya, Uganda, and Tanzania. A couple of years ago, we started embracing technology in the courts, but COVID has hurried us along at a speed that we did not expect. At that time, we essentially were concerned about the movement of prisoners from prisons to cities, and the danger to the public and the inconvenience to traffic that entailed, and that was the experimental part we did then. And we started doing a few experiments with appeals so that judges could be at different places and have hear the same appeal at the same time. But since COVID, we have been forced to rev up the machine and approach the matter with more urgency. I am surprised at how well we have coped, all things being equal. Our major challenge is a challenge of technology, and it's a two-way challenge: the technology in the court and the technology within the bar. The court has had, needless to say, spread all over the Republic. It's been very difficult to mobilize with sufficient speed. However, the appellate courts were the first to be kitted out, and I have personally appeared in several matters in the Court of Appeal, and that has gone very well. The bar is been forced to get up to speed. Again, as you know, it's not very difficult in Nigeria. The bulk of our practitioners are not necessarily very well endowed with modern electronic equipment that is required to conduct hearings of this nature. So there's been a learning on the job. It's working a little bit. Cartoonists in Kenya are having a great time depicting lawyers and judges shouting across each other, "My lady, can you hear me? Can you hear me?" Because the internet and the broadband is not very good, but it's getting better and better. What has happened, and I think this is a great thing, is that the long perorations that lawyers have always enjoyed have been cut to 15 minutes each. And therefore, we have a new advocacy that is being defined. The new practice is rewarding lawyers who write better, who are succinct, and who express their ideas with clarity. Therefore, those of us from the old school who came up the ladder, you know, with advocacy before a judge, as if we were before a jury, we have had to learn. We have had a lot of discussions around the mode of presentation, including such mundane matters as how does one dress? We have seen a number of lawyers conducting the case from his bedroom without the proper etiquette and so on. But we are learning about that. And I think we now have a deportment protocol that is working. We virtually are not having any in-person hearing or any live hearings, except in criminal cases, which have also been reduced to mentions. And some of these are being done within the prisons themselves, or where there are fast arrests within huge tents where there is distancing and so on. Most of the hearings that are taking place are interlocutory motions, you know, injunctions, stays, things like that. And these are being done totally online, which means then that we have an online filing system. Now,
30-second warning, Prof, please, 30-second warning.
That has been a real nightmare, but it's beginning to work. And I personally would like to say that we look forward to 5G. 5G is coming to Kenya soon, and we hope that this will speed up the processes. But for my part, and I think the part of the Kenyan bar, COVID has done us a favor in taking our litigation into the 22nd century. Thank you.
Thank you very much. That was extremely helpful, telling us the Kenyan experience. Can I just check whether the Honorable Solicitor General has arrived as yet? If not, we'll move to the next segment of our session, which is looking a little bit more closely at some of the issues that are raised. Now, I think an important point raised by Chief Ofia is that of the importance of training for judiciary and for lawyers in this new age. I don't know how much training has gone on. Perhaps if I can start by asking Lord Glennie. Lord Glennie, you're obviously hearing a lot of matters now with virtually, as you've said, you haven't been into court since March. Did you undergo some training?
No, we didn't. I think, as in all aspects of the law, the judiciary is very overconfident of its abilities to adapt to things, and no doubt counsel the same. I think a lot of training is necessary if it's going to be done effectively. Perhaps in the sort of practice on appeals, it's less important because you are dealing with a limited range of counsel, you all know each other's style and so on. What I think is perhaps most in need of training is in the lower courts, where small applications are dealt with, very important to the individual litigant, where no doubt there's a tendency for people to get impatient, to talk across each other. I think the training really has to be in terms of adapting one's own submissions, but also making sure you don't interrupt before the right time. So it's a question of finding ways of making sure that you can have the conversation, but giving a space, I think, between each person, so you don't end up with chaos of talking across each other.
Yes, something I'm trying to avoid. Prof Mugai, did you have training in Kenya? You've spoken, I think, about the need to adapt our advocacy style. And I think you made points about the advantage now enjoyed by advocates who are succinct, have strong written skills. And I agree with you. Did you have training in Kenya? Have you had training in Kenya? Is training planned?
No, we haven't had organized training, law society-wide training, but in-house training, we've spent quite a bit of time training our younger advocates on how to make these presentations. We've brought in technical people to help us upgrade our equipment and to help us maximize how we use the equipment, but not a profession-wide training.
Yes, okay. The other area which I wanted to explore was the important aspect of access to justice, which I think obviously is a very live issue. To some extent, it can be taken care of by providing the public with links to access a hearing, but it still, I think, leaves a number of question marks as to how many people can actually take part in virtual hearings. I don't know whether you have any thoughts on that, Chief Ofia, please. Access to justice issues, because you touched upon it. Can you please unmute, please, Chief? Please unmute your system. Unmute so we can hear you. There we are, thank you. No, you're back on mute. Yeah. Go ahead.
Sorry, I didn't get it. Was that for me? I didn't get the question.
Let me repeat. It's the access to justice point which you raised. Obviously, it can be taken care of to some extent, but I think there's still question marks over how many people can actually access a virtual hearing. Is this still an issue for you?
Yes, a very much an issue. In fact, it's a very, very, very serious issue because of the circumstances we have here. First of all, the cost for many people is quite staggering. So if you have the cross section of litigants or court users that we do have here, you would have to do a lot trying to convince them about the new costs. Another one, availability of electricity, basic things. Electricity is an issue. Availability of uninterrupted network is also an issue. most of the time, like what was said about Kenya, you find that people shouting, "Can you hear me? I cannot hear you. Can you see me? I cannot see you." And these are interruptions about of the network flow. The network providers that we have been discussing with are giving assurances that they are going to be working in teams with other people to make sure that this is available. So that kind of access is there. And I had also mentioned basic access about poverty for a great number of people. The larger population here are not well off to be able to afford the facility, the devices to help them engage in virtual hearing. But that should not deter us. I mean, when we started e-banking here, when we started smartphone use here, everybody was complaining. But right now, everybody is getting onto smartphone. So by and by, we're going to get there. But it is a challenge right now.
Thank you very much. You're absolutely on point, and that's extremely helpful. The way in which you've approached it is something that is a challenge that can be overcome. And indeed, in due course, we will overcome the challenge of access. Can I ask Paula about issues such as confidentiality and security, particularly in arbitral proceedings, because are virtual hearings as secure as an in-person hearing where you can check on who's in the room and make sure that people who shouldn't be there are not there?
You identify a really important point, because arbitration on the whole is confidential. At hearings, all the attendees are supposed to be visible and announced. There are steps, of course, that you can take to try and avoid any breaches. So a number of the hearing centres, including our IDRC in London, have worked to develop a very secure platform. They've tried a number of different providers. When I did a merits hearing a month or so ago, we used an upgraded form of Zoom, which I have to say worked extraordinarily well. On the other hand, my own firm, Herbert Smith Freehills, is still not convinced that Zoom is secure enough, but I managed to get permission to participate if someone else hosted. So it's important to work with the host, that they then only send access links to the people that are supposed to be involved. And then, of course, you have to make sure you've got the right people in each of the rooms. So everyone's in the hearing room, but only the arbitrators go to their breakout room, and the right parties go to their breakout rooms. I think it's also essential that at the start of each part of the hearing, the arbitrators ask lead counsel to confirm who's on the line for each of the parties. And where you have people in remote locations, witnesses or other clients, participants, that they also come on camera briefly and confirm who's in the room.
Yes, and how do you ensure that a witness isn't being coached?
Well, what we did in the merits hearing I had was the witness, you can install wide angle lenses and all of that, but all we did was get the witness to stand up and show that the room was empty and that the only documents in front of him, they were all men in that case, were the hearing bundles, no notes. And they had to confirm that at the start of each new section. And to be honest, that worked reasonably well, I thought. Thank you.
Last point for you is one around enforceability of awards in arbitration. Obviously, the old style is that we have to sign the awards, so the awards does the rounds and eventually gets back to the institution. No doubt we're moving to e-signing, but what about issues of authenticity and enforcement? Are we going to run into setting aside issues?
Again, a very valid concern. So I'll give you the example of the LCIA when we were looking at updating the rules. We have included provision for electronic signing of awards, but have put in a sort of safeguard that that has to be acceptable under the rules of the seat of the arbitration and in any country where you plan to enforce. that doesn't help you with non-authentic signatures, but what we are encouraging arbitrators to do is also sign the award in original copy and courier it as well to the institution. So at the moment, we're feeling our way doing both. All I would say is in another case where I've just received an award, this didn't relate to a virtual hearing, but one that took place some time ago in Asia. The arbitrators actually asked the parties whether they wanted electronic signature or not. But actually the parties said they preferred original signatures, even if it took longer, because certain funds are held by a third party. And there was concern that that third party could raise objections if it didn't see authentic signatures. So these are issues that I think we're going to have to work through very carefully.
They're not issues that have to be carefully handled. Thank you very much. I think that's excellent advice. Moving to a different area, and I think I'd like Lord Glennie to speak about this, and also we can please hear from our Microsoft director. Now, the point that was raised was about tips or advice for those of us in the legal community as we grapple with this new world in such short time. Lord Glennie, what advice would you have? What tips would you pass on to both judges and advocates who obviously are attendees at this conference?
I think I'm not sure whether the tip I'd pass on is a positive one, so much as making sure you're aware of the disadvantages. I mean, the virtual hearings have a lot going for them. They can be done, provided you have the access to the internet and so on, but they can be done efficiently. But you've got to recognize that the problems I mentioned before about lack of eye contact, body language, and so on is a real problem, and the difficulty of knowing whether the judge is actually looking at the same document as you want him to look at. So it's a question of maybe going slower, but not so slow that you irritate the court.
Yes.
But making sure you perhaps make your submissions in bite-sized chunks and try to allow enough time to make sure the point has got through. Whenever you bring a document on the screen, recognize that it takes actually a few seconds, perhaps 10 seconds, before the court will all have it in front of them. It's that sort of thing which avoids the little irritations. But also, I think, as I think the professor was saying from Kenya, the importance of getting rid of the old-fashioned sort of oratorical style. It doesn't. I don't think it works. There may be some judges before whom it still works, but it's got to be much more of a focused, short, focused, well-prepared approach, which I think is the key to success.
Thank you. I think that's probably the end of me as an advocate with that kind of advice. Mr. Solanke, please, can we have your advice? You are the technological whiz. What's your advice, your tips to judges and advocates?
I think, yes, so from my quarters will be, one is to allow for time for preparation. Sometimes the use of technology requires that you just give enough time to all the participants to get used to using the technology, and also just be patient when the technology is being used. Obviously, with time, that will become easier. The other thing is instructions should be passed beforehand, before a lot of those sessions start. The other will be, there should be a lot of training and change management. Obviously, training and change management is going to be very, very important as technology begins to become mainstay in our courtrooms for virtual hearings. And then clarity on the procedures should be shared beforehand, before the hearing starts, so everyone understands what the procedures are, because technology is now being used, and then just test the audio and video connections before the hearing starts. I think to some of the other points where you might have participants who might not be able to join via video, audio only into some of those sessions are available depending on the type of case that is being heard. So I think these would be my key tips that we should sort of think about as we sort of look into using technology for virtual hearings.
Thank you very much. I understand now we're joined by the Solicitor General, which is excellent. Can I just check that he is online now? Welcome, Mr. Akpata Essien. Whilst he's just, I think, acclimatizing, let's move on. The challenge, Chief Offiah, you talked about whether we are really ready in Nigeria for this advancement, and you talked about the challenges, Leonard Silk, that we face, particularly the infrastructure challenges. It's going to take a huge investment. That's the reality, isn't it? It's going to take a prioritizing of the justice sector. And the justice sector needs so much doing to it to bring it up to speed, to embrace this, and it has other pressures on it. So what would your view be about what we really need in Nigeria to take us to where we need to be for this? Can I please ask you to unmute, Chief? Thank you. Please unmute. Thank you.
Thank you. Now, I think, first of all, we need some sort of policy changes to be able to recognize and accept the fact that things have changed and we have to be doing them in a new way. We also need an overhaul of our legal framework to make provision for some of the things that are coming up in virtual hearing, the manner of receiving evidence. For instance, a typical issue, visit to locus in quo. How do you handle it in a virtual hearing without having to move to that? So we need to look at our Evidence Act to have a new way of visiting it, maybe using three-dimensional or by geoformatics and so on, to bringing objects for inspection by a court, stuff like that. So we need a lot of changes in our legal framework. And we need a change in mindset for everyone, not just for people in the legal community, but also for court users and other related institutions. We need to overhaul our registries, the Lands Registry, the National Archives, and so on, so that they'll have a direct link with the judiciary to be able to access some of the documents, and you would not need to go to the Evidence Act for certification and production of primary documents and so on and so forth. A lot of things need to be done. So all these changes, but as I said, we can't jump into all of them at a time. It's a gradual process, but once we have the mindset that we're in, then we will be in and we'll continue to move and improve.
Thank you very much. You covered a lot of ground and flagged so many issues. The best way probably is to approach it is in bite-sized chunks and possibly take it stage by stage. Maybe we start with the less significant procedural hearings and try to make those virtual before we start to move to the more weighty, substantial merits hearings and challenges. But you're absolutely right that we have to embrace it. And that mindset you talk about, the question is, are we ready for a change of mindset?
I think so. We could have a hybrid for a start. I mean, if you start your proceedings, start to finish, you could have a hybrid, take some of the proceedings virtually where it's possible, and take some of them physically, observing the protocols for the thing where that it becomes necessary for a start, until we're able to develop apps and platforms that will enable an all virtual hearing start to finish. In fact, some of the platform providers that we're talking about, we've been discussing with, are saying, well, for now, we have apps and platforms for this, but we are working on this other aspect to provide. I asked one of them, how do you now, after e-filing, payments and so on, how do you do service, e-service of originating processes in particular, because of the provisions in our rules and in our laws and decided cases on them. So how do you handle that?
You're definitely, Leonard Silk, you're definitely ready in Enugu. Can I please check on the situation in Kenya? Prof, this could be transformative, couldn't it, really? If we approach this in the right mindset, this could be transformative.
I believe so. I believe, for example, that there is very little to justify a return to long oral submissions on appeals, whether in the Supreme Court or in the Court of Appeal. I think we have a system now that shows that we can be more efficient by having electronic filing, electronic hearing, and only in the very rarest of cases, in my opinion, is there any justification for a hearing. I can tell you, for example, what is happening now. If you want a stay from the Court of Appeal pending your appeal, you have no interaction with the judge at all under our current system. You file before the registrar accepts it, orders, gives directions on service, gives directions on preparation of a summarized brief, and then places all this before the three judges. And then you get a notification in the mail that your ruling is ready. And you read it, and it has an electronic signature from the registrar, and you're good to go. And it saves so much of judicial time.
Yes, saves money, saves time, saves a lot of very valuable judicial time, as you've said, where our judges can be doing something else with that valuable time. Thank you very much, Prof. So we now have reached a point where we can attack questions from the audience. Can I just please check whether we have the Solicitor General online first? We may just want to hear from the Solicitor General. Mr. Pata, you're very welcome. I can see that you've joined us. Would you like to give a response from your vantage point as a senior public officer?
Good morning.
Good morning.
Sorry, I've been trying to link up. Good morning. Yes, I've been trying to link up. I think I would rather start with because I've not been able to track what has been said. But I would just go from the perspective of the Federal Ministry of Justice, which is the legal advisor to the federal government, at the same time, the largest chamber in Nigeria, if not in Africa. You will recall that the Honorable Attorney General some time ago, I think it was in April, said that one of the major lessons from COVID-19 is that the Nigerian justice sector must seriously leverage on technology in the improvement of its capacity and for the facilitating fair and speedy administration of justice. That information technology is a tool which we majorly going to use to cover the lost ground. And in doing that, we in the Ministry of Justice set up a 14-man post-COVID Justice Sector Reform Committee, which is to assess and identify challenges and impact and the impact on COVID-19 pandemic on entire justice system and make appropriate actionable recommendations. And the recommendations we made was for immediate, medium, and long-term measures for addressing such challenges. The issue of virtual hearing is no more in contention. But what we are trying to do is presently in the Ministry of Justice to identify the appropriate ICT infrastructure that engenders put an effective justice administration and make recommendation for its implementation. Now the question is, border more on the area of criminal procedures. The issue of the advantages, I'm sure you must have discussed this, which is the convenience of participation from various locations, the cost efficiency, I think I heard you saying that, then the sustainable decongestion of correctional services. I would really like to discuss more on the correctional services. We are really sitting down with the Nigerian Correctional Services to sit down to see possibility of a virtual hearing in the prisons. You will know that 97% of the prison inmates in Nigeria, the total inmates, are awaiting trial. And there's a very serious need for us to look into that area to ensure that at least there's some form of a decongestion of the prison. So presently we are sitting down with the National Correctional Service and see how we can use the ICT in leveraging prosecution through from the prison services. And not only that one, we also think that there are some address, that's the lack of gadgets and know-how. I'm talking of generally on the issue of virtual hearing, lack of gadgets and know-how in the operation, the power supply, and the poor internet connectivity, the internet security. I think I had somebody discussing about internet security, and also parties who are unprepared or who are poised to frustrate the justice process. You have to believe one fact that we need to change our mindset as to we learned through going to court in the traditional way of bringing in witnesses and all. But now we're changing those perspectives. If we're going to change the perspective, then we need to change our mind. And while we are doing that one, we also have to consider the issues for the judges, for the court clerks, the court registrars, and also for the lawyers. I think that those are issues which I've considered very, very.
Thank you very much. Thank you very much.
We are going to do. Thank you.
Thank you very much, Honorable Solicitor General, and thank you for joining us. I'm sorry you had some technological challenges, but we were very, very fortunate to have your presence. Thank you. Can I now move to some questions from the audience? We have a question. What is the NBA doing to ensure that the whole system is digitalized? Now, I don't know whether that is an NBA issue, but that is one of the questions that is being asked. Another question is that around the e-service of originating processes and the digitization of the system. I think that keeps recurring. So perhaps if I can go to Chief Ofia, you, I think, have spoken already about this. Do you want to say, add a bit more about what the NBA should be doing about this issue, if anything? And again, please unmute, Leonard Silk.
Yes, yes. Yeah, I did suggest that because of the peculiar problems we are facing with having on cost of virtual litigation and internet availability, I suggested that both the NJC and the NBA as a body should jointly approach network providers to talk it over and make sure that these things are available at affordable rates for the general public, not just for lawyers, but for court users and litigants. It's going to be a very big problem if they don't. And secondly, there needs to be a policy change on the part of the government. I heard the Solicitor General He is the national coordinator of justice reform sectors, and I'm the facilitator for Enugu State Justice Reform Team. And I know that we're doing a lot of work to sensitize people, to get people to buy into this. But you see that the problem, the complaints keep recurring. Wow, costs. Wow, availability of this. So the NBA as a body has a big say. Then the NBA also has the facility to arrange trainings, training and retraining. They can build it into the conferences that we have, the law weeks. In fact, in Enugu here, the ICT committee is going to weigh into the Enugu NBA annual conference here. And the major topic is going to be preparedness for fair hearing. We're going to have a lot of trainings, and each person actually is doing his own bit. My office, for instance, we are mounting trainings for judges and court registrars on our own as our contribution to that is Obra Legal, Obra Foundation. And we encourage other MBA members to be doing the same thing, training and retraining. So the MBA has a role to play at the higher level and also at the lower levels.
Very, very important points. One last question from the audience. It takes us back to the issue of constitutionality. And as we have the Solicitor General here, I would be very grateful for your thoughts, Learned Silk, on the constitutionality issue. Has it been put to bed?
Yeah, it's absolutely, because incidentally, the Lagos, if you recall, Lagos State and Ekiti State invoked the original jurisdiction of the Supreme Court, and I was representing the federal government, the Attorney General of the Federation, and then it was put that the issue of virtual hearing is on, the issue of unconstitutionality was put to rest.
Yes.
But be that as it may,
but does it need a, forgive me for interrupting, do we need a constitutional change?
Yeah, I think it will only emphasize the issues of when there's a synergy between the legislature, between the executive, and between the judiciary. There are issues. If you go to Lagos, you see that they've gone into the issue of practice direction. There are some practice direction from a different jurisdiction in Nigeria, which we can look together. We can sit down together with the legislator and look at it. And have a, just like what we're doing in the plea bargaining, having a regulation. Why can't we look at it? I don't think we should throw it out, regardless of the fact that the Supreme Court has already put the matter at rest. We can still look at those practice directions and see whether we can have a uniform document that we can call our own in Nigeria.
Thank you very much indeed. I think that's very, very helpful. So we have another 5 minutes. I'd just like to give all of you a chance for a 30-second last speech or observations. So can I start, please, with Prof in Kenya, please, our guest?
I think what this confirms is that we will never go back again. This is the future, and it is here. And the sooner we learn to practice around it, the better. And I think it's not only for big law firms, city law firms, it's not only the Supreme Court and the Court of Appeal. This is the new normal for every court. And I think it will make our profession, it is really a revolutionary movement in our profession, and we should embrace it.
Which is why the conference, I'm sure, is called Step Forward. And I think that is opposite. Paula, last observations, 30 seconds.
I agree we're not going to go back. And in the arbitration space, given that it is such a global form of dispute resolution, I hope that we will help in all countries across the world to bring that process forward, which then will help the courts and the judiciary. And I'll just go back to a point I made at the outset, that I really hope that this will enrich the process as well from a diversity perspective. Obviously, we've all got to learn, but we can get around these issues with the right preparation. and the right forethought.
Thank you very much. You make very important points, I think, about diversity and the opportunity for more people to get involved in arbitration. Mr. Sholanke.
Yes, I think my last words would be virtual courts are here to stay. Virtual hearings are here to stay. Technology is the enabler, and we need to adopt that. There needs to be a lot of training and learning, and we need to be open to that. But I think that will be it for me. And Microsoft is here to again continue to support the country and the justice industry, and empower the justice industry to do more.
Undoubtedly, Microsoft as a large technological company has, I'm sure, a very important role to play. Honorable Solicitor General, please, can I turn to you for your last observations in 30 seconds?
Okay, thank you. As the whole world continues to contend with the pandemic, we are all constrained to adapt and adjust to the disruption it has caused our daily lives. And one of them is the issue of a hearing of court matters, administration of justice. The word itself is dynamic. So what we need to do is to move with the tide, and in moving with the tide is to also use what we consider as pandemic as our own, as a golden opportunity to move forward. Thank you.
Thank you very much. Last word to Chief Ofia. 30 seconds, please.
Yes. Like others, I would say that the pandemic has posed a new problem in our judicial system. But we must embrace it and approach it. I'll give the example of the Honduras in Central America. They have a lot of hurricanes, and they had to build a bridge. They had a Japanese company build a bridge over there, one of their reasons, believing that they have conquered the problem of hurricanes and sweeping away their bridges. And this was a very good bridge. But there was hurricane Mitch that came. After that hurricane, the bridge stood, but something happened. The water changed its course. So there was a new problem, and they had to tackle the new. The same thing will apply to our judicial services here. New problems keep coming. Today is pandemic. Tomorrow it could be anything. So we must have the mindset to continue shifting the paradigm of our solutions to the problems facing judicial services. That's my last.
Thank you very much. Thank you very much. An excellent note to end on. It only allows me now to close this particular session. Can I extend my grateful thanks to all of our panelists? You've been excellent. I've really enjoyed your contributions, and by and large, I've managed to keep you to time. My thanks to the audience, very engaged. We have so many questions, so many issues being raised, and I think that's a tribute to the panelists that we've had this morning. And then finally, thank you to the team that works behind the scenes, always forgotten, but for us, absolutely essential, making sure that this session worked to plan. Thank you. Bye-bye.
Obviously, virtual judiciary can be very transformative. It's achievable, of course, with the right mindset, as many of the panelists pointed out, and of course, also with the necessary investments being made in supporting infrastructure. We're now going into a 15-minute intermission, and when we come back, we have 3 breakout sessions. The first session is a very interesting one. It asks the question, who is a Nigerian? And it's a debate on national identity. Now for this panel, we're going to have His Excellency, Governor Nyesom Wike, Executive Governor of Rivers State, but he will be ably represented by Professor Zacchaeus Adango, SEN, the Honorable Attorney General of Rivers State. Also on this panel, we're going to have Wale Akoni, SEN, Managing Partner at Wale Babalaki & Co. We're also going to have Dr. Obi Ezekwesili, former Vice President of World Bank's Africa Division and co-founder of the Bring Back Our Girls campaign. Also on this panel, we're going to have Salamatu Husseini Suleiman, the immediate past ECOWAS Commissioner for Political Affairs, Peace and Security and a former Minister of Women Affairs and Social Development. The moderator for this panel will be Mr. George Etomi, founder and principal partner, George Etomi and Partners. Now for the second panel breakout session, it's titled Rise and Shine. It's a panel of diverse leading legal practitioners on career pathways and development for young lawyers. Panelists on this session include Oyetola Muyiwa Atoyebi, Senior Advocate of Nigeria, Managing Partner, Omoplex Law Firm. We also have Makund Da, Partner, White & Case, Reginald Aziza, Legal Counsel, Chevron and Doctoral Candidate, University of Oxford, will also be joining us. Also joining us will be Adedoyin Pierce, General Counsel and Company Secretary, Siemens Energy Nigeria Limited. Now the moderator for this panel discussion will be Wala Joseph, Head of Legal, Eco Electricity Distribution Company. Now for the third panel is titled Security and Extrajudicial Killings, another very key and important panel today, a discussion on national security challenges and extrajudicial killings. The session chairman will be Chibuke Nwokeku, Senior Advocate of Nigeria. We also have a lead speaker for this panel, in the person of Chief Mike Ozekome, Senior Advocate of Nigeria, Managing Partner Mike Ozekome Chambers. Panelists include Ali Malik, Senior Advocate of Nigeria. We have Monday Onyekachi Ubani, Principal Partner at Ubani & Co. We also have Aisha Mohammed and Ikide Egelua. Anyways, so another quick note to our delegates. Please remember that for each of this session, there's an email that's been sent to you by the Nigerian Bar Association, and there's a link for each of the 3 panel sessions. So just go to or click on any of the link that you want to participate in for the sessions you want to participate in, or you could just go to the MBA website and just click on each or any of the links that most interest you. So we'll just go into a quick 15-minute intermission. Also, before I go, just a quick appreciation. I would just like to quickly appreciate and recognize some of our gold sponsors for this event: Paul Usoro and Co., Aluku and Oyebode, Templars, Banwo, and Igodalo. Thank you.
Using judges or being timid.
This conference affords us the opportunity to review how we operate.
Not toy with the independence of the judiciary.
With well over 12,000 delegates in this conference, this is by far the largest gathering of lawyers on the continent of Africa.
Dear learned colleagues, as we overcome these trying times and settle down to a new normal, Law Pavilion celebrates the resilience of our esteemed clients. We have unveiled a new ecosystem of legal service delivery in Nigeria, so you can harness the silver lining of opportunities that lie within this crisis. Introducing the new Law Pavilion Prime 5.0, now available online for mobile phone users, fortified with court forms from all jurisdictions with pre-filled sampled forms, AI-assisted document review system, Microsoft Word plugin that enhances your legal drafting advantage right within your Microsoft Word. Manage your law firm remotely with our case management system. One more thing, get access to millions of potential clients through our new industry-leading Lawyers and Law Firms directory. Experience the new normal in legal service delivery today. Visit www.lawpavilion.com/experience.
Hello, it's that time of the year again.
And we at Solo & Co are here for you.
What's more interesting is you can order in several ways. You can come to one of our stores in Abuja, 40 Dublin Street, Wuse 2, or in Lagos at the Law School campus or at Landmark Tower. You can also go online, www.solohan.com.ng, and place your order there. There's a wide range of products. All our products are there. You can order from there, or hit us a DM on Instagram or message us on WhatsApp.
When you order any of our products, we deliver to you within 2 to 4 working days. Or you can as well pick up at our head office in Abuja.
When you buy any of our products, we give you a complimentary photo shoot. We're saving you the time and the hassle of going helter-skelter trying to find a photographer. We have the best for you. Shop at Solohan.
Post-COVID-19, economies are being reset. And the true definition of wealth is now an intangible intellectual property. The required innovations for restarting the economy and governance rely on the maintenance of rule of law through equal and efficient access to justice. Law Pavilion, in partnership with Telnet, presents the following innovative solutions, redefining a new ecosystem for justice delivery in Nigeria. Law Rights. This is a mobile application that displaces the old practice of consulting family and friends first for legal advice by making all necessary information available anytime, anywhere. You don't only get to know your rights, you can easily report a violation or consult a lawyer in a jiffy, among other things. The Law Rights app, in conjunction with the Case Manager Assured, provides the lawyer advanced tools to properly manage his clients, briefs, tasks, and entire law firm. The Case Manager Assured integrates with the Law Pavilion Prime, an online repository of case laws, regulations, precedents, forms and agreements, and rules of court. This makes it possible to achieve so much in so little time. It is the reliable legal research companion. Now it also boasts of e-laws of Lagos State, as well as legal textbooks and journals. It's a complete e-library for today's lawyer. E-registry removes the stress involved in filing a matter in court registries, as this can now be done seamlessly from anywhere, anytime. Court Manager Assured automatically captures documents from the e-registry and helps judges monitor progress of matters from a single dashboard. Oh, one more thing. The Court Manager Assured uses artificial intelligence to help judges review lawyer submissions and documents, making administration of justice easier, faster, and much more efficient. Now, that's the new ecosystem of legal service delivery. Visit www.lawpavilion.com/experience.
Move on. It's playing. No, they are not showing any.
Welcome everybody back to the breakout session, day 2 of this conference, the 2020 Annual General Conference of the Nigerian Bar Association. Today, we will be dealing with the question of who is a Nigerian, a debate on national identity. After 60 years of nationhood, Nigeria is still grappling with various issues ranging from tribal, ethnic, communal, and political strife to economic instability and to a faltering apparatus. The citizenship/indigenship argument continues to abate without resolution. The nation now finds itself in the middle of an increasing clamor for outright secession by some of the ethnic groups. And the time has now come for us to re-examine the basis under which we have our national identity. We will look at issues to do with the tribal character and quota system. We'll look at the rights of women and children in our federation. Do we need to tweak some of these age-long concepts by which the national identity has sought to be platformed? Or do we need to strengthen them? The arguments can go on till the cows come home. But the truth is that something is not working right and we need to fix it. Today, we'll be joined at the session by very eminent Nigerians, distinguished in every regard of the word, and nationalists in every sense, and people I'm proud to be associated with. The Nigerian Bar Association is truly honored and grateful to have them help discuss this very thorny issue. First would be Mr. Wale Akoni, Senior Advocate of Nigeria. He's a managing partner at Babalaki & Co. He became a senior advocate in 2006 and is recognized in the Who's Who Legal as one of the top performing lawyers in the continent. He is also a member of the INABA, as we call it, and is the chairman on the Lagos State High Court Civil Procedure Rules Review Panel and Committee, chairman on judicial appointment and bench relations of the Nigerian Bar Association. Welcome, Mr. Wale Akoni. I also have one of the most eminent and visible Nigerians, Dr. Obi Ezekwesili. She was once a candidate for the office of president of this great country. She is an economic policy expert and a senior economic advisor at the Africa Economic Development Policy Initiative. She was a Richard von Weizsäcker Fellow at the Robert Bosch Academy and is a founder of the Transparency International. Dr. Ezekwesili was vice president of the World Bank's Africa Division and is former Nigerian Minister of Education, Minister of Solid Minerals, and so many, many, many things. So you're welcome, Dr. Ezekwesili. Also on this panel is another very notable, very visible, and very well-respected Nigerian, Mr. Peter Gregory Obi, the former governor of Anambra State and immediate vice presidential candidate for the last 2019 elections under the banner of the People's Democratic Party. He's also a very successful businessman. He comes with a combination we would really love to see because he has the private sector experience, also has public sector experience, and we will see how this has impacted on his citizenship issue. Welcome, Dr. Obi. We also have one of my very good friends. We work together in the ANAP Foundation, coming with regular bulletins on our COVID response. Salamatu Husseina Suleiman, she's the immediate past ECOWAS Commissioner for Political Affairs, Peace and Security. And prior to this time, she served as Minister of Women Affairs and Social Development under the President Goodluck Jonathan regime. She is a scholar, so she obtained her master's degree from the famous London School of Economics. You have good company there, Salamatu. And she is also, and she also served once at what was then Nile Merchant Bank. So you're welcome, Salamatu, and we know we're going to have a lively conversation. Last but not the least on this panel is the governor of Rivers State, but is ably represented by Professor Adango, who is the Honorable Attorney General and Commissioner for Justice in the state. We all saw him yesterday, so I need not give him any elaborate introduction. You're welcome, Dr. Adango. How are you doing? Good. So let me just go straight to the session. I'm going to give each one of the panelists between 5 and 7 minutes to give an introductory remark about their understanding of the subject matter. And then thereafter, I will throw specific questions on them. So let me go straight to you, Dr. Wale Akoni. Now, what's your take on this?
Okay, thank you very much. I'm very glad to be here. It's my association, and where we pride ourselves as leading the thought and the discourse in Nigeria, and I'm very pleased to be here. Now, this issue is it's very, very topical. I will try to stay away as much as possible from politics of it, and I will try to. I'll leave that to others, and I will try and stick to the legal issues as much as possible. I will try and give a legal framework for what we're trying to discuss. The legal framework on citizenship and federal character is to be found in the Constitution. For citizenship, Chapter 3. Chapter 3 of the Constitution sets out the citizenship criteria for Nigeria, and you can be a citizen of Nigeria under three strands. First is you can be a citizen of Nigeria by birth. Now, that really talks about if you or your parents or grandparents were born in Nigeria before independence. That is one aspect. If you were born after independence and either of your grandparents or your parents were born in Nigeria, they are indigenous to one of the areas in Nigeria, then you are a citizen by birth. Then there's citizenship by registration. That deals with foreign women who are married to a Nigerian. Foreign women who are married to a Nigerian can register as Nigerian citizenships, as Nigerian citizens. There's also a second aspect, that is for people who were born outside Nigeria, whose either of their grandparents were Nigerians. Then, that is, if your parent isn't a Nigerian, but your grandparent is a Nigerian, then you can register as a Nigerian citizen. The third aspect is for people who naturalize as Nigerians. That's basically for foreigners who have lived in Nigeria for a long time and they are found to be of good character. And they are able to show that they can contribute to the growth and development of Nigeria. So that's the basic framework there. There's also that already gives you one of the issues that will come up for discussion today, that isn't there a gender disparity, because it allows foreign women who are married to Nigerian men to apply to be Nigerians by registration. It doesn't allow foreign men who are married to Nigerian women to apply for registration under that aspect. But as I said, that's I'm just trying to give the framework generally. There's now the issue of federal character. We all know federal character came into our vocabulary in Nigeria sometime in 1978, when the 1979 Constitution was being considered by the Constitution Drafting Committee. Basically, it was to see how we could get national loyalty in a multi-ethnic society. Now we all know the history of Nigeria. Nigeria came about by, some people say Nigeria is a geographical expression. The entire state of Nigeria, we're asking ourselves, are we really a nation or are we a geographical expression? We started off with kingdoms all around the country, all around the space that became Nigeria. Then the British came with their colonization and entered into treaties with different aspects and different kingdoms. And then later, it was by force of arms. And they now broke Nigeria into, they put the space together into the northern and the southern protectorates, which were then united by colonial fiat in 1914, by amalgamation, and now the entity called Nigeria was created. And then in Nigeria, we all know that there is, we have over 250 ethnic groups speaking probably over 500 languages. So these differences have led us to our people to probably stay more with their ethnic groupings and their regions, rather than give their loyalty to a nation and as an expression. Now, in 1978-79, the issue of the federal character was now put in the Constitution for the first time. Now, I'll just go straight to the 1999 Constitution, section 14.3. Interestingly, it is contained in chapter 4 of the Constitution, which ordinarily the Constitution says is non-justiciable, such that if there's anything that is not followed in that part of the Constitution, you cannot go to court to enforce it. However, the issue of federal character is different, because it specifically sets up a federal character commission, which actually is an executive body, which is supposed to deal with issues of federal character. And I think it's something that I need to read out. Section 14.3 says the composition of the government of the Federation or any of its agencies and the conduct of its affairs shall be carried out in such a manner as to reflect the federal character of Nigeria and the need to promote national unity and also to command national loyalty, thereby ensuring that there shall be no predominance of persons from a few states or from a few ethnic or other sectional groups in that government or in any of its agencies. Now, it's very clear that the Constitution sets the framework for this, and it's important that whatever we're discussing is captured in that. I think the questions are whether we've implemented it correctly, how has it happened, how has it gone, but I think that is what we need to look at here and discuss.
Thank you, Wale. Thank you. Professor Dango, I'll call you in now at this point. So can we have your opening remarks, please?
Let me start by conveying the deepest apologies of His Excellency Nyesom Ezewonwike, who would have loved to be here but is not able to make it virtually because of other pressing state engagement. So I'm actually speaking on his behalf. The way I see the topic, it suggests that there is a clash between citizenship and indigenship. In other words, the question is, why do Nigerians prefer to identify with their tribal origin rather than with the Nigerian state? For me, I have constructed my presentation around two fundamental theses. The first presenter has alluded to the first one. The first thesis is that the pre-colonial and colonial history of Nigeria did not favor the development of a sense of national identity. Indeed, it actually favored the development of a sense of tribal identity, and I will show that. The second thesis is that the practice of Nigerian multi-ethnic federalism has compromised the fundamental principles or the core values of that federal arrangement as negotiated and agreed upon by our founding fathers, which were one, that no region shall suffer domination or dominate any other, and that two, each constituent unit shall be encouraged to progress at its own speed and pace according to its own natural resource endowments. These two core values have been violently compromised. Now, to the first thesis, in the beginning there was no Nigeria, and the first panelist has dealt with that, so I won't dwell so much. There was no Nigeria. What we had were empires, kingdoms, chiefdoms, city-states, and so on, made up of distinct ethnic nationalities. The total number of these nationalities has always been a matter of controversy. The 250 represent the closest approximation of Nigerian ethnic nationalities. These nationalities were different, both in historical origin, in their language, in their way of life, in their traditional political leadership, in every sense of the word. Now, religion also added another dimension to the diversity of the Nigerian society. It was on this fragmented and divided society that colonialism was imposed by Great Britain. And incidentally, very incidentally, colonialism was imposed in staggered fashion, as if to reinforce the diversity. First, it was Lagos, the decision of Lagos in 1861, followed by the Niger territories that later became the Niger Coast Protectorate, and then lastly, the Hausa Fulani territories and all the communities in the basin of the River Niger and River Benue. And so by 1900, we had three major blocks: the colonial protectorate of Lagos, that was southern Nigeria, and that of northern Nigeria. The first amalgamation was in 1906, when the colonial protectorate of Lagos was merged with the protectorate of southern Nigeria to form the colonial protectorate of southern Nigeria. Then we now had the northern protectorate. At that time, there emerged two Nigerias. One looking towards the Middle East, the other looking towards the West. These two blocks were later forcefully brought together in 1914 in the historic amalgamation exercise, without the participation, negotiation of those directly affected by it. In other words, Nigeria emerged by colonial fiat. Now, what is the reaction? Although amalgamation represents the most historic event in Nigeria, it has also suffered the most resent from Nigerians. Indeed, I can quote that Awolowo had referred to it. Awolowo had said that the entity that arose from that amalgamation was an abominable, disruptive colonial heritage. And the Yorubas have always maintained their right to decide whether or not to be part of the amalgamation exercise. To the north, the 1940 amalgamation was a mistake. The Jaws have also queried the amalgamation as denying them their sovereignty to decide their own fate. The result is that the nations and entities brought together in 1914 never perceived themselves as members of a common society, and that is the bane of Nigerian problem. That is why we don't have a sense of national identity. What you have is indigenation. And fundamentally, Britain never set out to build a nation. The amalgamation was informed by two fundamental principles: economic consideration and then administrative convenience. So they did not pretend to help us to build a nation. They just brought us together forcefully in order to secure their own economic interest. And so that is the first problem. The second problem has to do with the practice of our own federalism. There are essentially two forms of federal arrangement you find. You find a national federation or a multi-ethnic federation. National federations are usually single nation entities where the state boundaries do not coincide with any ethnic boundary. US, for instance, is such an example. Ours is a multi-ethnic federation where state boundaries coincide with ethnic boundaries. And multi-ethnic federations are usually designed to empower and reconcile conflicting ethnic interests. And so ethnicity lies at the basis and at the heart of Nigerian multi-ethnic federalism. But it is important to note one fundamental point. The founding fathers of Nigerian federal arrangement agreed on two fundamental core values of Nigerian federalism. First, that no region shall suffer discrimination. No region shall suffer domination, nor shall any region dominate another. Two, that each constituent unit should be allowed and encouraged to develop at its own pace. And so every form of domination of one group or another strikes at the very foundation of Nigerian federalism. And it's very, very arguable that we've suffered domination right from time of independence up to date. What that has done is that it has alienated several ethnic communities from the Nigerian state, thereby making indigenship a very attractive option. And that is the bane of Nigerian society. So what we need, in effect, is to return back to basics. Try and breathe life into those two fundamental bases of our own federal arrangement. Prevention of domination, encouraging the constituent units to develop at their own pace, so that we can at least form a nation. Until justice is enthroned, indigenship will continue to prevail over citizenship. I'm not seeking to rationalize it, but I want to show how we came to where we are and what we need to do to move forward. So justice is the fundamental basis. We need to give equal opportunity to all the constituent units so that they can make progress. Now, there is indeed an attempt by some to believe that you can forcefully bring distinct ethnic nationalities together, and then by using a center-dominated federal arrangement, ensure success. That is not correct. You cannot supplant ethnic allegiance by national allegiance unless you build national allegiance on top of ethnic allegiance. And the only way you can do it is that there must be room for self-expression. I want just to quote a statement made by a very leading author in West African politics. That is Mr. Otto Lewis. And his idea is quite instructive for me. Hear what he said. He said, any idea that one can make different people into a nation by suppressing the religious or tribal or other regional affiliations to which they themselves attach the highest political significance is simply a non-starter. National loyalty cannot immediately supplant tribal loyalty. It has to be built on tribal loyalty by creating
we can have other contributions as well. Thank you, Dr. Obi. Please, can you come in at this point? Dr. Ezeoku, can she come in? Is she there? Yes.
Can you hear me now?
Yes, we can. Thank you.
Yes. Excellent. Thank you very much, Mr. Moderator, and thanks to the NBA for inviting me to participate in this very important conversation. I think that the previous speakers have, in one way or the other, given a very necessary context to the conversation around nationhood and country and identity. And so I wouldn't try to repeat some of the historical antecedents that they have laid out. What I would do is to start from the premise that having been handed by 1914 what is a country, as was the case in many other parts of the world, what eventually became of us. What was necessary was for us to gain the independence, which came in 1960. That independence was an important milestone for the multi-ethnic nationalities that make up Nigeria, now knowing that the force that brought people together into a country, a construct of a country, are gone. The next thing would have been a conversation around our shared values, our common vision, and our common identity. There was a failure to transit from country that had gained political independence to agreeing a set of common values, a sense of shared vision, and a sense of common identity based on the ideals of a social contract that would bind the citizens and the Nigerian state, a social contract that would bind Nigerians, whether north, south, east, or west. That did not happen. So we missed an opportunity there. Another opportunity that we missed was the military adventurism. Military adventurism put paid to a semblance of a shared value in terms of the embrace of the federal system of governance that enabled levels of autonomy for independent thoughts for how to pursue regional development. That abrogation of real federal structure was an important milestone again that affected the emergence of Nigeria from country to nation. And then we got another opportunity, which was sad that we had the Civil War, the genocide in the Biafran Civil War. When it all came to an end at the conclusion of the war in 1970, the country yet had another opportunity to negotiate a set of common values, agreed vision, and a common identity. We again missed that important opportunity. And so what have we built? We have built on a sandy soil where basically it has been a rentier state, a state that is open to capture by any set of people that manage to dominate the rest and gain ascendancy into leadership. What that has done is that it has made us so dismally different from a country like Singapore, which is also a multi-ethnic society with the Malay, the Chinese, the Indians, the local Singaporean, and many other identities that or multinationals that forged that country. But because of the presence of a certain kind of leadership that enabled a conversation around the idealism of being a Singaporean and the fact that it enabled them to deliver what the raison d'etre, that is the basic purpose of being country, of being nation, of having a government does. It is to consistently improve the quality of life of citizens. The Singaporeans delivered the benefit of belonging to their citizens. It was therefore not difficult for the Singaporean citizen, regardless of what strand of the society they came from, to identify themselves proudly as Singaporeans. That is not the story of Nigeria. Another set of points to make is that we have seen that in the search for nationhood, if it happens in a bloody way, and in, say, the United States of America, or in, say, Rwanda, there always must be, ultimately, a dialogue that leads to the presence of what we call nation formations. In the case of Nigeria, we did not have that kind of dialogue amongst us, especially considering that the society began to forge along disparate purposes with each group thinking that it is in an unacceptable
marriage with the others. So what is it that Nigeria has produced because of the failure to aggregate nation formation? What Nigeria has simply produced is a deep structural problem for itself. And a structural edifice that is in trouble requires a structural solution. It does not require a paint or a coat. It requires that the edifice be deconstructed and reconstructed on the basis of agreed values, shared vision, and a common identity. What I believe we are lacking now is...
I'm going to ask you to hold your thoughts there. I'll bring in Mr. Peter Obi. I'll come back to you. So, Mr. Peter Obi, go ahead.
Can you hear me? Hello, can you hear me?
Yes, I can. Go ahead.
Okay. Well, let me very respectfully observe all protocols and sincerely thank the leadership of this revered body and the organizers of this event for the honor of inviting me. While I share the views of the various speakers, especially the last speaker will be about reconstruction of the structure, I think we have to look at this collectively as the people. The title of this section is very apt, especially now that COVID-19 have challenged us like every other nation to look at the corporate existence as the nation and not as a tribe, because it's not affecting one tribe or the other. Countries that are grouped, I'm talking about looking at the economic sustainability now. Countries that are grouped as developed, developing, and underdeveloped nations, and not as tribes or anything. So economically today, Nigeria as an entity has a problem that requires and affects every tribe and every section. It is not about religion or this or that. If you look at just on Monday, our Nigerian Bureau of Statistics say that our country second quarter GDP declined by 6.1%. That is on the back of already 1.something% in first quarter, and I'm sure the similar thing will happen in third quarter. So we are going to go into a second recession within 4 years. There's no section of Nigeria that is affecting differently. It is Nigeria as a country that is going to go into a second recession. You can say it's occasioned by this and everything. If you look at economic problems we're facing today as a nation, we have 100 million Nigerians living under poverty, higher than even the two most populous nations in the world combined, China and India. This is not peculiar to any tribe. It is across the country. People in my village who are going through this. If you go, we have today 15 million children out of school. It is not peculiar to any tribe. It is across Nigeria. We have 20 million young people in their productive age doing nothing. When we talk about unemployment being 27%, if you combine it with underemployment, you're looking at 40-something%. In fact, we have about 43% urban unemployment. It is not peculiar. If you go to Port Harcourt, you will see them. If you come to Lagos, you will see them. If you go to Kano, it might be worse in one place or the other, but it goes across as a nation. And the reason why you're seeing this is that, yes, it's good for us to look at each tribe and religion and this, but we've abandoned what is collectively. So we have, because of this various arguments, we have now stayed where we have a consumption economy instead of a productive economy. And in terms of sustainability, it's impossible because you have high consumption, waste, rent seeking, corruption, everything that makes it impossible for an economy. Today, as a nation, we're owing $90 billion, which is now making it impossible that all our retail revenue are being used to service debt. It is not peculiar to any tribe or anybody. It is, so for me, if for us to look at where we can look at our history, look at our problems like this, it's for us to look collectively, because there's other countries who have gone through this, who are doing things differently. While they're way to readjusting this and readjusting that, we now have to collectively as a nation, look at how we can make our economy productive. We have to move it from consumption to productive by having a coordinated and articulated policies, expansionist policies that will be rigorously implemented and monitored. We need to look at how we can get massive support to our micro, small, medium enterprises in order to create jobs. They have to empower our people. Because if you do this, you can be able to start building an economy that will cut across everywhere. We now need to move our economy from being public sector led to private sector led, as it is across all nations of the most developing and nations that are doing well aggressively, and it has to cut across. This will now reduce our today irresponsible borrowing and waste and everything, because there will be more efficient use of our resources. We need to look at issues of cutting down the cost of governance. It cuts across. It has no tribe. There's too much waste. We have to imbibe in physical discipline that will help us to start building an economy that will grow while we're talking about, so that we can get the place to move. If you look at why we say we have different, we're not the only place we have ethnic problems. Indonesia have ethnic problems, very diverse ethnic problems. But if you look at what Indonesia has been able to do with a population of 250 million over the past few years, while still grappling with the ethnic problems. I can go on and go on. You have Vietnam, we have ethnic problems. They've been able to build an economy with the same background where they are growing over 6%, while their population is growing about under 1%. You have it in Bangladesh. You can come to Africa, look at Egypt, Ethiopia. Ethiopia is a multi-ethnic society. But look at Ethiopia in 2010, their GDP is 30 billion and a per capita of $340. Today, they are 91 billion with a per capita of now almost 1,000. So they've done 3 times their per capita. Today, every Nigerian wants to fly Ethiopian airline. We want to do this. They have a problem. But what we do is that we have abandoned what we should be doing, even while as a multi-tribal, religious, anything group, and focus on building a nation while solving other problems. We have now, because of our own transactional system of operation, turn it into ethnic nationality, this, that, and that. It's like that every other country. I can go on and give you several countries that are going through the same problem trajectory and are building their economy. And like I said,
for now, and I want to bring in Salamatu Suleiman. I need your own perspective. She's joining us, by the way, from the Abuja studios of this conference. It's being housed at the NBA Secretariat. Salamatu, you have the floor.
Affairs. Thank you very much. Standing on existing protocol, may I make a small correction on my CV. I actually served as Minister for Women Affairs under President Musa Yar'Adua and subsequently served as Minister of State for Foreign Affairs under President Goodluck Jonathan. So let me start by congratulating the MBA for the very thought-provoking theme of this year's conference, Step Forward. I think it has been aptly coined to stir national consciousness and stimulate discussions on how to move our country forward despite all challenges, particularly the current pandemic, the health and other insecurities, plus the economic recession. Lawyers by training have always been taught to multitask and approach issues from different perspectives. Therefore, there is no better body than the MBA at this time to step forward, take a lead, act as agents of change as we aspire to change the narration of our great country to become a leading nation in all ramifications, not only on the African continent, but globally. Having said this, I must also express my deep disappointment on the way the MBA handled issues leading to this conference, which did not adhere to our quest for rule of law and due process. I think as a leader in the society, setting standards and examples, stepping forward, we should do better and we should lead by example. We should in no circumstance refuse to listen to others and even disenfranchise members of our association because we think they are going to take a contrary view. Having said that, I want to look at a Nigerian from a different perspective. I want to look at the different types of Nigerians we have, what an ideal Nigerian should be, and how we can collectively together work towards achieving that. The Nigerian, by constitution, has already been eruditely explained and by the other panelists. So I look at the types of Nigerians and I start with the masses, which constitute over 50% of the population. These are the majority, marginalized, deprived, and left to wallow in poverty and ignorance through the actions of the political class and the elites. They are the ones always willing to vote upon the promise of a better tomorrow, but promptly abandoned after elections until the next political cycle. Then I want to look at the political class and the elite because these two groups have common goals and objectives. They want to amass as much wealth as possible, some through hard work and some by hijacking national resources. They want to send their children abroad to be educated, to travel around the world for business, for pleasure, and to generally lead what they see as a good life because they believe here they have no access to the kind of things they want. And they leave the majority living in poverty with no access to good education or healthcare. Then we have the Nigerians in diaspora, who are Nigerians in different professions, left for foreign countries for varying reasons. Most of these Nigerians believe their country is inadequate to meet their needs, either professionally or socially. While some of them are holding very high-level jobs in these countries, some are leading demeaning lives and trying to survive. Then we have the nonchalant and inexposed Nigerian. We shouldn't think it is only those who have not traveled that are inexposed. We have a Nigerian who is living in this country. He is an elite, he is relatively educated, he may be a professional, but he's totally disconnected from what is happening in the country and only leaves his environment when traveling abroad. The only thing such a Nigerian knows is what he sees on the news media or social media, and that is what he teaches his children about his country. He does not vote unless it is very convenient to do so, but he's eager and quick to complain when things are not the way he wants them. There are other various categories of Nigerians, too numerous to mention, comprising decent groups of people engaged in various professions, doing their best in their own ways to move the country forward, but without much impact because the magnitude of our problems are too much. Now, since the majority of Nigerians, and we adjust this to be over 50%, are in the category of the poor and the helpless, the danger of the gap between them and the ones perceived to be rich creates a very serious threat to socio-economic growth, peaceful coexistence, and general peace and security of our great country. It is therefore critical to reflect on how to redress this situation moving forward. Numbers themselves are a strength to any nation, provided those numbers are productive and they are adding value. We can no longer think that the problems of the majority do not affect us, so long as we can look out for ourselves and our families. The quest for good life is not bad. The quest for education is very good, but it must be available for everybody if our nation is to succeed. We should remember that for Nigeria to get the position that we are today, there was a lot of sacrifice by others. Some supreme sacrifice, if I must say. Readily coming to mind are, of course, the likes of Chief Obafemi Awolowo, Ahmadu Bello, Nnamdi Azikiwe, Tafawa Balewa, and so many others. COVID-19, as His Excellency, the immediate past speaker said, has shown us a lot of lessons, and I hope we learn from them. It showed us that when the chips are down, everybody goes back to their roots, and all nations shut their borders. So if your country is not prepared, then you are going to suffer along with it. Therefore, it's very important for us all to have a common goal, a common purpose of moving Nigeria forward. Now, who is an ideal Nigerian? I think an ideal Nigerian should be a committed, loyal citizen who is guaranteed certain basic amenities by his country, and in return, faithfully serves his country, always putting national interest before personal, being his brother's keeper, and constantly striving to advance the cause of Nigeria. How do we achieve this? I have mentioned a number of things that I think are important as we think stepping forward. We must, first foremost on the list is leadership. We must get the correct people to deliver. We must get the right people at the helm of affairs at all facets of government, be it executive, legislature, judiciary, and at all tiers. Fortunately, Nigeria is blessed with very rich human capital, both at home and abroad. We have professionals all over the world doing excellently. These elites and professionals can no longer afford to adopt this sit-down-look attitude, as they call it in Nigeria. For as long as the best don't come forward, we'll be saddled only with those who offer themselves, no matter how their quality. Then I talked about awareness creation, behavior change.
I'm going to stop you there so I can begin to look at some of the specific questions. I'll come back to you, so hold your thoughts.
I wanted to talk about...
Wally, let me come back to you. I've been getting questions from the audience, and one of the burning issues is this as a state of origin versus state of residency, especially as it affects women. And I want to be specific on the legal profession. We've had this very uncomfortable situation in which women who are married to men from other states work, become high court judges, serve loyally and diligently, and then when it's now time for them to become chief judges, they are suddenly reminded they're not from that state. And in fact, there's one burning issue going on in Cross River State. They even cited security reasons for not allowing it. It's embarrassing to the profession. I wonder if you can comment on this.
No, thank you very much. The Constitution specifically prohibits the discrimination of any person
in respect of government appointments and things like that, and even just generally by virtue of the fact that the person's gender or place of birth or circumstances of birth. So legally, strictly speaking, legally, all these issues ought not to be, because you're a Nigerian and you're supposed to be able to live freely and work freely anywhere you live. Now, there are the specific issues concerning women. As I said earlier, there's the federal character issue also has a state level, because in every state as well, you are supposed to follow those principles that are laid down in the Constitution for ensuring that there's no domination of one area from the other. Now, the issues arise when, as you said, a woman is married to someone from a different state. She's living with her husband and has worked all through. And then when the opportunity arises for her to get a very plumb top job, now the state now remembers that she's actually not from there. The truth of the matter is that it is a purely political question. It's I don't think we can deal with it on the legal front. It's a purely political question. Now, one can look at it from the view that the top positions, one can say, are supposed to be shared, quote unquote, among the indigenes of the state. And when someone is not an indigene of the state, the question now arises that, is that person supposed to partake in the largesse? All this in inverted commas. However, the question is that this person has always been there, working, serving that state all the while. It is at the point of giving her an appointment that she probably deserves, is then they remember that she's not actually from that state. She's not from Cross River, she's from Akwa Ibom. Then we now start to hear that she's a political risk. All the while when the person was serving in that position, she wasn't a political risk. It's when she wants to become CJ that the now question about her being a political risk now arises. As I said, it's all politics, and I think that is really what we need to address in matters like this. There's no legal basis for these issues. Now, the Federal Character Commission has some guidelines which it has put in place. There's somewhere in there that I saw that talks about married women in particular and says that they are entitled to continue to claim their state of origin. Now, the question is that, I mean, I'm aware of situations where also it causes problems because people take advantage of these sort of issues. A person who comes into a state because she's married and she becomes a judge, for instance, and based on the fact that she's married to an indigene of the state, when there's a promotion to the Court of Appeal and there's a vacancy for that state, that person is very eager to still go on and say, I'm claiming my husband's state. But when they now get to appointments to the Supreme Court and a vacancy arises in our own state of origin, now she remembers and says, oh, actually, I'm from that other state. I want to go and take it. So all these things, as I said, it's political, it's personal interest and all that. And I think we need to, as a nation, sit down and agree on principles that we're supposed to use. Clearly, there shouldn't be discrimination on the basis of where you come from. But at the same time, there's this issue which is the basis of all this discussion, trying to share national resources amongst everyone so that we ensure that nobody feels discriminated against or feels that they've been dominated.
Thank you very much. Let me bring Professor Adango here. In your opening remarks, you talked about the importance of indigenship, why it's working or why it's not working. But the question I want to put to you is, what should we do to have a sense of belonging to a nation without necessarily losing our fundamental identity?
Thank you, sir, for that question. I think that part of the problem lies in our constitution. I will refer to it briefly. If you look at section 147 sub 3, which deals with appointment of ministers, provides that the president shall appoint at least one minister from each state who shall be an indigene of that state. And when you look at the Federal Cathedral Commission's guiding principles, it also emphasizes indigenship. And for us, this is not quite right. And part of the point I'm making is that we should begin to look at residency rather than indigenship as a basis for enjoying rights and privileges in this country. But on the main question, I think what we need to do is to enthrone justice. Because as long as a particular ethnic group feels a state, you cannot secure their allegiance. Citizenship is not just an abstract legal concept. There is an emotional and psychological content to it. And that psychological content means that the citizen holds and is not proud of that state, although he's technically a citizen, but there's actually something wrong with that citizenship. And so we need to create equal space for every ethnic nationality in this country so that we can feel a sense of belonging. As long as there is cry of marginalization, cry of domination, cry of neglect, even inciting an execution of federal projects in one part of the country or the other, you don't expect national loyalty or national identity. It will not work. We need to enthrone justice. We need to enthrone justice. I ask you why. Am I Nigerian when I cannot boast of one federal project in my state because my state is controlled by an opposition political party? Am I Nigerian when my child cannot secure admission to university outside of his own locality because the university is located outside of his same state? Am I Nigerian when I cannot be appointed chief judge because I am not an indigene of that state, even though I've rendered services to that state over the years? Am I Nigerian? Am I in Nigeria? These are questions we need to address. And what lies at the bottom of all these questions is justice. We need to provide room for self-expression to all the groups. As long as we want to continue to ignore the fact that we are multi-ethnic and plural, we cannot solve the problem. We need to accommodate, reconcile, and empower all ethnic nationalities. That is the only way Nigeria can work.
Okay, thank you. Thank you. So let me bring in Obi here. Obi, the simple question, you alluded to countries like Singapore, who have somehow found strength in their diversity. You've been in government, you've been out of it, you fight for human rights, you fight for women's rights. What do you think we should be doing specifically to steer this nation on the path of true nationality, using Singapore and other East Asian countries as veritable examples of how we can find strength in diversity? Obi.
Well, thank you. Number one thing is that we have a structural deformity on our hands. The structural deformity is in this agitation that you continue to hear about the regions and the states and the challenges of really contesting for the resources that comes from oil. We cannot be a rentier state forever. The centralization of our federalism killed initiative in our society, and it's been a race to the bottom since then. We have to correct the structural deformity. And the constitution that was handed over by the military has not done that for us. And so we have to have a citizens-led constitutional process that would enable all the regions of this country to have a conversation around their shared values, their shared vision, and then forge a common identity. That is number one. Number two, we have to look at what we currently have on our hands. Would the person in Southern Kaduna who is open to any form of abuse be willing to have a conversation on the Nigerian identity as easily as they would if they knew that the Nigerian state would protect them regardless of any differences of opinion or tongue or language or ethnicity? What is important is that we have to agree, even now, that the sanctity of human life is a basic minimal norm on which we all agree, so that we can end this concept of equal opportunity suffering. When the Southeasterners suffered as a result of the Civil War, the rest of Nigerians looked in the other direction. When it was the turn of the South-South to suffer, the rest of Nigerians looked away. When our brothers and sisters in the middle belt scream of marginalization, the rest pretend that it doesn't matter to them. When things go on, say the June 12th in the Southwest, others pretend it doesn't matter to them. Equal opportunity suffering takes everybody out. And so the principle of justice has to be a major minimum on which we all agree as a society. And number three is that in this society, the idea that a certain segment of the society can behave with impunity and that the principle of the rule of law is negated at all times. The only people who pay a consequence for bad behavior in Nigeria are the poor. There cannot be economics of justice and then you say you're building a society that would thrive. There is no identity in a society, there's no common identity in a society where impunity reigns. We cannot have the Nigerian Bar Association be in this society while impunity reigns. Bad behavior must have a consequence. The incentive that this society has given to people to behave badly when they have deep pockets, when they are connected, it's really egregious. And it is clearly something that undermines the idea of a common identity. And number four, we must, as a people, understand that the office of the president is merely the highest political office in the land. The real highest office in the land is the office of the citizen. Citizens are the one with the power to determine what their shared values are, what common vision they see, and what common identity they would defend. Because after all, identity is personal and identity is social. Often, people would not want to accept a social identity out of which they find no benefit. Today, with the level of pernicious poverty that our citizens suffer, where Nigeria, a country that started off the block at the same time with Singapore, is operating at less than 4,000 income per capita, and with it being called the poverty capital of the world, compared to Singapore at almost $60-something thousand. The disparity is too much for anybody to have that social sense of identity that their country is actually gone beyond merely being a territorial place to which they have allegiance by virtue of having a passport or having an ID card, to being one that they have an emotional connection to. Most Nigerians today have no emotional connection to the identity in Nigeria. And that's what we must change. It is time, it is really time for us to have that conversation.
The whole idea behind the federal character, the quota system, was for inclusiveness. It was designed, as it were, to get every Nigerian to feel that they belong and must subscribe to a federation that they're willing to defend. But it would appear that in its application over time, many people are beginning to wonder if we've not emphasized sharing the national cake more than actually building a viable country. We're losing some of our finest brains abroad. And I ask you the question, what can we do? What's something innovative we can do to ensure that we begin to build a human capital that works for us, as opposed to be a breeding ground where we develop some of the finest brains only to export them abroad? What's your take?
Is that for me, George?
I can't get Peter, but Salamatu, go ahead. Go ahead.
Okay, thank you very much. Honestly, with all sense of responsibility, I think we spend time chasing those things that put us apart rather than focusing collectively on those things that can move us together. I will say the problem you are posing, one of the key ways to get around it is quality education for everybody in the country. It is achievable, it can be done. Education is key because it has ramifications for all other things. Why am I still here today discussing? Is because I had an opportunity to get a good education. And that came from a system that was established in this country, the system of unity schools. But people have forgotten about that. It has been bastardized. It is no longer on, but that system of unity schools, bringing children from all over the country, putting them under excellent learning conditions, has produced leaders that have contributed in no small measure. If you look at people who have done well in this country, you can find a high percentage that pass through unity schools. When you have everybody having the same quality education, having the same competence, you don't have to worry about quota system. It doesn't even exist. And then the indigenship, this one that you're talking about, when you have people who have connected from way back, and they are experienced, they are learned, and they are the ones in charge of making laws for this country, you don't have those people sitting down to bicker under which local government somebody comes from, what is somebody supposed to do. They will look for things that will move our country forward. So we need to come up with innovative and good quality initiatives that can move us further from where we are today. I feel highly inspired recently by the Economic Sustainability Plan being initiated under the office of Mr. Vice President with participation from the public sector. It is themed Bouncing Back. If you look at that plan carefully, that plan, if implemented very well, will reposition Nigeria, take us out of poverty, take us out of pettiness, take us to where we are supposed to be as a country. Why we are still petty is because so many people are still suffering. I agree with some of the views expressed by some of the previous speakers. You can't have a majority of your population being under the poverty level, and then you are calling yourselves professionals, experts, you are in different countries. And those who are going to other countries, they have seen what has happened with COVID-19 and also with Black Lives Matters. Is it not better for you to stay in your country and develop it than to go elsewhere where you are treated as a second-class citizen and you are constantly under the threat of somebody putting his knee on your neck, both psychologically and physically? So I think there are a lot of things that we need to think of, and we need to move ahead rather than spending time discussing issues that divide us as a country. Let's commit to have a very, very good educational program in place for everybody. Let's commit to have other, what do they call it? National investment policies that take care of women and the youth. Under education, I will particularly mention the education of the girl child. Educating women in this country will take us beyond what people can imagine. Because of the role the woman plays as the bedrock of the society, you can imagine what will happen if mothers are more educated in the rural areas. In terms of hygiene, that is already improved. In terms of early marriages, that is already reduced. In terms of bringing up children with the proper concepts and helping them through school, that is already improved. In terms of earning income and adding to the family, that is also already improved. So these are the kind of things I think we should collectively think about. as we try to move our country forward. I would also like to mention the role of private sector participation.
Again, I'll come back to you to round it up. Let me get back to Peter. Now, Peter, let's go back to this whole issue of the things that unite us more. Those factors that don't know tribe, tongue, religion, those things that make us human. How do we get them to the center of national discourse so that we can all subscribe to it and then begin to build a nation that works for everybody? Peter.
Can you hear me very well? Can you hear me? Hello?
Go ahead. Go ahead.
Can you hear me?
Go ahead.
Okay. You see, like I said in my presentation, if you look at what divides us most today is that we operate an economy that is based on consumption, based on sharing. If you turn it around to an economy that is based on productivity, which what it is that people's talent and hard work will match up their opportunity. You stop sharing. And that is the basis of when people talk about restructure, because if the people who produce soil are the ones who are benefiting from it, the rest can use their brain and do this. So for us to be able to do that, we need to focus on, I'm a citizen of Nigeria. I live in Abuja, for example, and I'm sure that while living in Abuja, I can be able to achieve whatever I can within my hard work, within my talent, without being bothered whether, oh, somebody will say, I'm from the Southeast, I'm from this. The same thing goes with the issue of what we are talking about, election, place of residence and all that. I reside in Lagos. So if I work hard in Lagos and make a living in Lagos, whatever there is there in Lagos, I can compete with it. We have Nigerians who live in the UK, who are members of UK Parliament today. We have them everywhere. So if you move from consumption, because that is our main issue, sharing. So we're always bothered about who is going to get this year and who is going to get this year. If it's productivity, you find out that it will dynamically change. It's in my speech in this, I was asked to talk about economic sustainability. And I've said, all the countries we have used as an example by various speakers, if you look at what united them more, it is when they've grown their economy. The multi-ethnic people in Ethiopia is not complaining the way we're complaining here or Indonesia on this, because you build a society where there's what you can call a level playing field. That is what we don't have in Nigeria. So there's profiling. Where am I coming from? Where am I going to? These are things we need to start building. We need to start looking at how do we get together as a nation? How do we work as a nation? And then those who are leading us, like Minister has said, is now saying, well, listen, let's, even in selecting our leadership, let's look at, while even if we are going to do it by zoning or anything, every zone have competent, quality people that can help us to build a nation. There's a lot of other things we need to do, but I'm coming from the point of 100 million people living under poverty. It is not peculiar to any tribe. I have people in my village, like I said before, who are living under there. They want opportunity. Another opportunity that some of them have been to school. The system called Nigeria need to support them to do something.
Contribution. Now we've been having some questions from the audience, and I'd like to put it across to you panelists. Please make your answers very short. First question goes to you, Wale. Some are actually by way of comments, so please bear with me if they come out the way they do. One of them is asking, should we ban state of origin? Does it help us at all?
Well, I don't know whether it's the real problem is not in simply, the solution is not just banning state of origin. There are so many other fundamental issues. I mean, as the Honorable Attorney General reminded us earlier on, the Constitution itself talks about indigenship. And that's the only place in the Constitution that the word is mentioned. It says that a minister should be appointed from each state. That person must be an indigene of that state. Now, that already sets the tone. So if you say state of origin, let us ban it. Yes, you ban it, but you will still come back to the problem, where does the person come from? If we say, okay, what we'll be using is residency, yes, it would help. But the truth of the matter is that, and I think I agree largely with His Excellency Peter Obi on this, that when we lift our country out of poverty, lift our people out of hardship, people tend to care less about all these issues if he knows that whether he's in Lagos, he's in Abuja, he's in Kotangora, or in Abakaliki, he doesn't really matter. He will get whatever he's entitled to because there's enough to go around. So much has been produced. Everybody is benefiting generally from it. There'll be no problem. But until then, all these things will be cosmetic. You remove state of origin, you remove indigenship. Oh, we are still primordial. We believe in our ethnic affiliations. And it is only when we see ourselves as part of one united nation that peace and justice reigns, that we will stop thinking like this.
Professor Dango, let me just take on the point where Wale left it, peace and justice, and you emphasize that, peace and justice. The worry I have is that a lot of, one of the questions here is that this whole issue of sharing is cascading down to the point where it is actually creating a fracture that's going to the very root of the country. So much so that you leave a quarrel at the center, it goes to the state, from the state to the local government, from the local government to the villages and to families. Where does this all end? What's your
Thank you, sir. Yes, sir. Thank you, sir. Thank you, sir. I think it takes us back to the fundamental basis of our federal arrangement. Like I said before, the second core value, or what I call the underlying principle of Nigerian federalism, was that each constituent unit should be encouraged to develop at its own speed and pace according to its own resource endowment. That fundamental principle of our federal arrangement has been violently compromised. And in its place, what we have is a center-dominated federal arrangement where every governor has to run to Abuja to get a share of what actually came from his own state. And so if we continue along that trajectory, it will never work. What we need to do is to allow the constituent units of this federal system to explore the possibility of raising a substantial part of what they need to run the state. Their argument is that because of the Civil War and because of the fact that during the First Republic, the regions were quite powerful. So we need a very strong center to more or less pull all the constituent units together. That has not worked. We need to explore new ideas. The moment we diminish attraction to Abuja, the moment the states can sit back and think of how to explore new avenues of raising resources, the competition for federal power will diminish. And once there's reduction in the clamor for federal power and control of federally collectible resources, Nigeria will be a more peaceful state to live.
On this question of education, Salamotu mentioned that education is one of the key things we should do to.
I think I got it right now.
Towards nation building, and I think everybody agrees with her. You were once Minister for Education, and this policy of cut-off marks and co has always been part of our educational system. Again, people worry. A policy that was designed initially to be inclusive, it's becoming exclusive and is actually promoting mediocrity. What do we do with our educational system to marry the desire to be inclusive, but at the same time don't sacrifice excellence?
Yes, other societies have had to solve this problem of disparity in performance. And the way they have done it is not to compromise and to do a race to the bottom, which is what we have done with the approach we took. And that was part of why in the education reform that I was leading, we were moving in the direction where you would not have a race to the bottom. But what you would do is that you would accelerate the kinds of policies and programs that would enable those who have been falling behind to quickly accelerate and be able to reach up to the level that others are operating at. What we have done now is that we have through those kinds of policies improperly operationalized, we have ended up with policies that's taking everyone on a race to the bottom. So what we do need to do is to do a catch-up in policies, and we had programs that worked toward that. We must not take people to the least common denominator. It does not help in the development of any society for us to dump standards down because we have a group that we need to raise up. We must add different kinds of policy measures that quickly accelerate the opportunity as well as the performance of those who are not caught up to the standard that makes them not to be as competitive as the others. The second thing to say is that in this conversation that we're having, I think it's very important that we do not leave without understanding that a structure that's not functional is not going to maximize the opportunities that an eclectic society like us has. We must agree amongst ourselves that there are certain common denominators that have to be agreed and negotiated. I think that part of the problems, that the one key problem that we have that has been following us is this refusal to have a proper conversation after the end of colonization. We really did not have the kind of conversation that is citizens-led. This is the era of citizens. Citizens of Nigeria now demand that there be a conversation that enables us to agree certain common denominators that we see amongst us, and then to identify what the differences are, and to negotiate those differences, and to determine the way that our nationhood would form itself. We are yet a country, we're not yet a nation.
Let me bring you on that note, a conversation. Some say convene a national conference. That's one of the questions that I find here. But I know you're an economist, and I know you have a passion for innovation and development. What is your take? How do we move this country forward? Address our fears, address the issues of trust, and yet continue to build a nation that works for us.
Is it me? Hello? Is that question?
It's for you. It's for you. some technical issues with him. So let me go to you, Salamoto, if you can. Oh.
Okay, George, the same question?
To Peter, let me come to you, Salamoto. Yeah, just along the same lines. I know I asked you to hold your thoughts. I want you to give me a landing as to the way forward. We need to have a conversation. National conference, national discourse. What practical things should we do? I noticed that in our very little corners, we do very well. When we run our private companies, we don't do tribe, we don't do tongue. But once we elevate it to the national level, we suddenly begin to find our differences. So what in practically should we be doing as individuals and as various units to advance this question of nationhood?
Thank you very much. I think for me, the most critical will be changing our attitude. We heard a lot about behavior change communication during COVID. I think we need to escalate that to all issues and all groups in Nigeria so that we think collectively as a country. Most of the issues that we're discussing and thinking if probably we had a new, another arrangement, it may be better. It may not necessarily be so. Look at what is happening at NDDC. You will leave one problem to fall into another one. You will think because the whole thing is in our attitude. The whole thing is in our approach. The whole thing is based on individual selfishness. The country currently is made up of people who think principally of themselves and their immediate families before thinking of the general good of the country. So as a starting point for me, if we can all go back to having that common push. Let's look at, what do they call it? Education and dropping of standards. If everybody has access to quality education and everybody gets quality education, who do you need to drop standards for? I came from a system of benefiting from Unity School, which I always say is a good concept for Nigeria. There are many, many more potentials like myself that are untapped because they don't have the opportunity. They didn't get the opportunity that I got to go and study, get good education, and participate. So if we all think collectively of changing the narrative, look at how far the private sector came out when there was threat of COVID and we thought we were all going to die. Look at the millions that came out and were put on the table. What if we have the same attitude towards improving education? Healthcare, of course, is primary, but when you improve education, it will have positive impact on all other things. Why can't the private sector have a commitment to improve the quality of education in this country? People have actually now given up. Everybody is looking for money to send his children, even if it is to Ghana, to go and get good quality education. But there was a time when
Peter, let me get your contribution, and then we're going to round up this very lively session. Peter,
okay, can you repeat the question again?
For about another 2 minutes.
Can you repeat the question again?
The question is, how do we emphasize the things that unite us in very practical terms? They say we need a conversation. It is true. Should it be another national conference? Should it be in the things we do? But
we have had enough of, let me start by telling you we have had enough of conversation. We have enough reference from previous conferences that we can go and look at. What is lacking is that you need a leadership that can drive national integration. What you see today in Nigeria is cumulative effect of leadership failure over the years, not having a leadership that is nationalistic and willing to bring in place a level playing field and allow for productivity that I keep emphasizing. Let the man in Rivers produce whatever he can produce and keep it and pay us taxes and let it be all across everywhere. It is not a rocket science. The richest state in America is not oil producing. It's California. It's more driven by knowledge and agriculture. And we have people who can do it, states that can do that. Everywhere you see today, we can disagree with people. Knowledge today is far more important than everything. If we invest in education, states across local governments can invest in education and educate their people. Just last week now, you could see the value of Apple being 2 trillion, 2.2 trillion. That is higher than the GDP of entire Africa put together at 2.1. So we can bring all those things that are critical. As long as you have a system where people stay in Abuja and share something, you're not going to get the place to move. We need to get this place where people's hard work, talent will match up their opportunity, and you can cut it across everyone. Once you have it, most of all these big currents will not be there. And then we'll start dealing with due questions on everything. I lived in the UK. I didn't know where I came from. There was no issue of ethnicity because I was able to do what I was doing and run my businesses and pay my taxes and everything. So many people who are doing it, but here, everywhere I move, I have to think, oh, maybe I'm from Southeast or maybe I'm from here. But we need to have a political leadership that care for Nigeria as a nation, work for Nigeria as a nation, know that the security of people in Northeast is as important as security of people in Southwest, that what Southeast need is critical. They need maybe a route to the sea to do their export. You develop all this and you have a country, and that's it.
Very wonderful session to an end. I want to, before I close it up completely, read some of the tweets that have come in from our very respected Moise Banire. He says, the quota system and federal character must go if we want to promote nationalism. The origin of it lies in reversive discrimination in the United States, which is never an eternal concept. Again, until we eliminate all those discriminatory practices and give pride of place to merit and competence, the nation can't grow, and nobody will have any sense of nationalism or patriotism. Thank you, Moise, for that. Some anonymous attendee, I don't read anonymous stuff, but Nina Oko says, apart from calling out the leaders, what does the led have to play to reposition our identity as one Nigeria? In other words, we too, the led, should understand the role we need to do. Joseph Oko says, why are we not talking about religion, the biggest problem of Nigeria? Our leaders use it to exploit and divide us. I think everybody agrees with you, Joseph. Kenneth Obugo, we've answered your question. You talked about national conference, and the agreement is that we need a conversation no matter the form it takes. And there are compliments for every one of you panelists from various bloggers here. And I would want to add my voice to those compliments. And just before I round up the session, I want to thank, I must say, the section on legal practice of the Nigerian Bar Association. They have put this session together. It was initially meant to be their hot topic for their conference that should have held in May. The NBA works through its sections, and when we hold these conferences, the sections and various fora come together to give us the content that we give out to you. I take the point Salamatu made about the NBA itself living up to its responsibility. We are not going to run away from that responsibility. We should be a body that should be a receptacle for all shades of opinion. We should not be afraid to listen to opinions that do not necessarily agree with us. If the NBA does not live up to that, I wonder who else will do that. And the question continues, very hard questions continue. We are all proud to be of one form of ethnic origin or the other. And one of my good friends says that no matter how much of a national identity we want, we cannot be ex-Yoruba, ex-Igbo, ex-Ijaw, or ex-anything else. We should, even within the context of building a nation, be proud of our origins. So I ask, and I join others to ask, are we ready to do away with the federal character principles, or should we modify it to make it work for us? The same issue is on this issue of state versus residence. What would internal migration mean for us? Should it go unchecked? What can we do? And where again do we place this issue of our married women? There's so much to discuss, but in all of it, as COVID-19 has told every one of us, the great leveler, the great disruptor, our common humanity and the common values that make for that, to enhance those common humanity are the ones we should be looking at. Equity, justice, peace. It starts from each and every one of us. For us to subscribe to Nigeria as a nation, we must be true to ourselves. If we're not true to ourselves, we cannot contribute anything meaningful at the national level. On that note, I want to thank every one of you who has been a part of this great conference. The Nigerian Bar Association will continue to play a leading role in the reshaping and the reform of this country. Thank you, panelists. Wally, thank you very much. You've been so wonderful. We jumped on you at last minute, but then, you know, we don't give our own a chance to breathe. Same thing with you, Professor Adango. Thank you for ably representing one of our own as well. And please give our compliments to the governor. Thank you for having me. Ezekwesili. You will be remembered for good in this country. You've done so well in everything you've put your hand in. You're honest, you're straightforward, and we're all very proud of you. Peter Obi, I know relentlessly you will continue to build and build and build. We are all proud of you. Thank you for accepting our invitation. You are all great nationalists. And then to my friend Salamatu, our work continues because we are very practical. We work together. We don't know tribe. We don't know tongue. We don't know religion. We just look at what we can do to raise the standard of the common man who is now looking up to every one of us, the elite, blessed by God to lead them correctly. Thank you very much.
A very big thank you to all the speakers from the 3 breakout panel discussions. Now, the conversation on citizenship versus indigenship certainly gives us as Nigerians, and even more our policymakers, a lot to think about in terms of how we want to foster that sense of belonging for every Nigerian. Now we're going to go into a 10-minute break intermission. After that, we'll come back for a 1-hour training session for young lawyers. This is aimed at equipping them with some valuable skills needed to thrive better as legal practitioners in the 21st century. Facilitators for that session will be Mr. Femi Oyedipe from Glimpses Legal Training and Mr. Emeka Albert, NLS class of 1989. Annual General Conference of the Nigerian Bar Association.
Shall we pray? Almighty God, our Creator, we pray you to be with us in all our deliberations and to direct our endeavor so that we shall continue in all humility to glorify thy name and do that which is right and just for our profession, its members, our fellow man, and our country. In Jesus' name we pray.
Up next, I'm going to call on
as already indicated on our program, would be handling a topic known as thriving as a legal practitioner in this 21st century, and of course and beyond, knowing the COVID times that we're in. The people who will be anchoring this session, facilitating this training, are Mr. Olufemi Oyedipe, who is a legal practitioner first and foremost, but also the CEO of Glimpses Legal Training Services. Mr. Oyedipe, you're very welcome. He will be presenting and basically explaining to us how we can survive as legal practitioners in these times. Also presenting a specific special product is Mr. Emeka Albert. Mr. Emeka Albert is the chairman of the Nigerian Law School class of 1989. Interestingly, this class came together to prepare a specialized product, which I'll leave Mr. Albert to introduce to us. We would leave all questions and answers to the very end of the sessions. Please keep your questions and answers coming in, and we'll see them in the chat. Thank you. Over to you, Mr. Oyedipe.
Good afternoon, everyone. Thank you for inviting me to speak on something which is very relevant and apt today. It's all about stepping forward, which is more apt than ever before. A year ago today, nobody ever thought that the whole nation was going to be locked down. And so affecting both legal practitioners and all businesses, the question is, how do you survive? And I've been asked to speak about young lawyers who are seeking employment, who are already in employment, and young lawyers who want to settle. And when you say a young lawyer, who is a young lawyer? Is it in terms of age? Is it in terms of qualification? But the truth is that a young lawyer has nothing to do with age. It has to do with your experience in practice. And we cannot talk about young lawyers talking about supervision from senior lawyers. Somebody wrote recently and said, you cannot fight today's war with yesterday's tool. It is obvious that in Nigeria today, we're trying to fight today's war with yesterday's tool. We have to imagine that things have to be done differently. We're in a new normal. Courts are sitting virtually on some of the issues, and it's all across the world. One of the things I have to talk about towards the end of this discussion is how you key into office practice and how you manage your office management activities. And this is all about client care. And let's talk about lawyers seeking employment. A young lawyer seeking employment comes out from law school and he expects to work in a corporate environment he is not prepared for. He's only been taught in law school. But the question is, they keep saying that young lawyers are not happy. And it's all about how much they expect and what they expect from the profession. The question is, what do you have to give to the employer when you join the profession? You don't have an experience, but yet you want to be put in a very key position. I know if a young lawyer who was looking for a job, and the question was, what do you have to give that others who are looking for this job do not have? And the gentleman said he's been writing about receivership and bankruptcy since he left law school. And interestingly, the firm wanted to set up that department. So the young lawyer was able to present his, what I would call, playing activities, and that got him a job. So the question is, as a young lawyer, what do you have when you're seeking employment? It is not what you're taught in law school that will get you employment. It is the value that you have that will get you employment. So it's not about you scoring first class or anything. We saw all that play out in the past few years. And in a recent conference, young lawyers were complaining that they are not well treated by senior lawyers. But the question is, what value are you bringing into the firm? But the truth is that a lot of these young lawyers have good education, but the question is they have not been properly mentored into what they should say when they are going for interviews. And every graduating lawyer who has passed through that tough examination expects to settle into the job. It is not easy for a young lawyer, a new wig, to jump into the Supreme Court and start presenting arguments. You might be brilliant, but the question is, have you been properly mentored? And that comes down to how a young lawyer is properly mentored by a senior lawyer. So a lot of these discussions will still be playing around what the senior lawyers are doing to encourage the young lawyers. The truth is that every young lawyer is educated to take up jobs, but not all lawyers have the skills required by most employers. Most law firms have their own internal culture. They have the way things are done. They have the way letters are written. The young lawyer is not aware of it. And who is going to train him? So it boils down to lack of training. And so what happens between law school and when you get employment? You have to know what to do when you get into that employment. And let us look at lawyers who are presently in employment. A lawyer in employment who has a loose relationship with his boss, doesn't know how to do things, is not well prepared for the job. The question is, are you well supervised? A lot of young lawyers have loose relationship. I know a lot of firms who allow young lawyers to use their letterhead to do jobs, but they are not well tutored in how those things are done. And the question is, are they well supervised to work in a loose relationship? And how do you thrive as a young lawyer? You have to be innovative. You have to convince your principals that you can do things properly. The principal wants a good culture in the firm, but you've not been taught how to do those things. So the question is, how do you engage in an area of interest that you've only been taught in law school? What you're taught in law school is probably 10, 15% of what you're going to learn in practice. You will not be taught in law school how a judge reacts to your unprepared attitude when you appear before the judge. Some courses will not tell you whether the judge wakes up from a wrong side of the bed or whether you are ill-prepared. Some people speak with force, some people speak slowly, so you've got to listen. So these are things that we have to allow the young lawyers to incubate when they are working with us. But how do you cope if you're looking for employment? What do you need to have? I spoke about the young man who spent a lot of time between when he was called to bar and when he got his job in writing strictly about receivership and bankruptcy. As a young lawyer who has just left job, what is your area of interest? Are you just looking for any job? Are you prepared to go into litigation? Do you know anything about medical negligence? Do you know anything about personal injury? A lot of people don't know these things because these things are not taught in a classroom setting. A lot of these cases are not taught in a classroom setting. So the question is, what do you do with your time? So what we are saying is that, how do you cope in today's legal field? How do you cope? What do you know about mining law? Mining is taking the center stage in a lot of discussion nationally. What do you know about unfair charges by banks, except beyond what you've read in the newspapers? These things are not taught as classroom stuff. But the question is, these are things that will come up in day-to-day legal instructions. So let us look at some of the principles that we expect the young lawyer to know. It's not just about seeking employment. It's just not about working in a law profession. And it's not just about getting good pay. Everybody wants to join the top law firms, but there are issues here and there. There are things that you have to have as your skill. What are the skills that you possess as a young lawyer that will make sure that will make you succeed ahead of others? So what I want to do briefly is to look at those principles before we now look into lawyers who are looking for employment, who are trying to set up law practice. Because everybody wants to be a partner. You see, we have all sorts of one-man practice. People practice from their homes. What are the settings in all these law practices? What are they meeting the standard required by the Legal Practitioners Act? Are they meeting the standards required by the principles that encourages you to give client care to your clients? What do you do with clients that you instruct, that instruct you? What do you do with jobs, with cases that you've gone to court? We were speaking to some lawyers recently, and I asked them, what do you do after coming from court? He said, I just give the client a copy of my judgment. Why? Why would you just give the client a copy of your judgment? Is there a legal advice attached to that copy of judgment? Is there a legal advice as to the merits of the document you've given to the client? So these are some of the issues that are not well dealt with when we're talking about young lawyers. Every young lawyer requires supervision from the senior partners. We were talking about file review recently, and we were asking a lot of senior lawyers, how often do you review all these young lawyers? A lot of them have never carried out file reviews. Some even just have meetings when you have litigation in court. Some only have maybe once in a week meetings with all their lawyers in one setting. No, that is not how file reviews work. If the young lawyer runs into problem with the way he's running a file, then the problem comes onto you. If people start suing lawyers for negligence, then there will be problem. People do not talk about indemnity anymore because it is not compulsory in this day and age. But the truth is that a lot of clients are going to be asking for indemnity when they are giving you some specialized cases. So let us look at a lot of things about file reviews. How often do you carry out file reviews of your offices? How often do you call in the young lawyer randomly to ask him, how many files are you conducting? Let me see those files. A lot of senior lawyers are accused of just neglecting the young lawyers. They just follow the seniors to court. What exactly do they do in court? Are you watching or listening to how the judges present their trials? No, that's not what you're supposed to do. You're supposed to contribute into what is going on. So there should be a synergy, there should be a relationship between the senior and the young lawyers. We're talking of the young lawyers, they are the ones that will take over the profession tomorrow. But what are the key skills that they have? A lot of them do not have key skills, and which means that they are lagging behind in the way they should take over the profession. If we senior lawyers allow the young lawyers to continue to operate the way they are, then the profession will run into a serious problem in future. It simply means that we have to pay more attention to what the young lawyers are doing, because they are going to take over the profession tomorrow, and they are complaining. Recently, the SLP had some seminars, which I was able to go to people here. We're talking about morale boosting. A lot of young lawyers feel out of place with the way the practice is going. During the last election, a lot of complaints were made as to how the young lawyers reacted to the election processes, and a lot of them were apolitical. They didn't want to vote. The reason is that the morale in the profession is low, and we've got to encourage them. So what we tell the senior lawyers is that there has to be some key issues in your firm which will encourage the young lawyers to get involved in what is happening. And what we are saying is that you walk into a law firm, you stay in the practice for 8 hours a day. What have you contributed to the firm? How much profit have you made for the firm? From the jobs you have done, how much can we calculate that you have earned for the period that you have worked? And these are issues that are not properly put in. Only few firms have the right software to monitor what young lawyers do in the firms. The question is, you cannot allow these people to operate. They are young, they are inexperienced, they need mentorship. You cannot allow them to operate a loose relationship in this kind of profession. The profession is key to nation growth. The profession is key to have Nigerians survive. Clients' life depend on some of these issues that are discussed in court. Clients' life depends on how these files are conducted. So the question is, do you walk into the firm as a senior and you allow the files to just lie down there? The question is to walk into the place. If the young lawyer has about 30 files, you ask him to bring 10 random files, and you go through each file one by one. You look at corrective actions that have to be taken in those files. You look at whether those files are being conducted properly. And these are issues that are not done by a lot of firms. You don't just sit in a meeting, discuss cases with them. No, it doesn't work like that. You've got to do random sampling of all the files. You've got to ask them questions about why have they chosen a principle of law in conducting a case. because if anything goes wrong with that file, it comes down to the name of the firm that they are working for. And that is the key issue. If there's an issue relating to indemnity or negligence, it comes down to that firm. And that means that we can start seeing clients who are suing lawyers for negligence, for things that do not relate to the knowledge of law. Simply relates to whether I'm informed regularly about my case. It simply relates to whether I was given a merit assessment of my case. When cases are taken, do you do a clear merit assessment? After every court case, does a lawyer write a merit assessment of whether the case will succeed or fail? If a new law comes out, have you written to your client to tell them that, listen, a new law has just been released. It's going to affect the way we are doing things. And these are the merit assessments. Recently, everybody has been shouting about CAMA. But I doubt if anybody had written to the churches to say, listen, you are my client. These are the new rules that have been placed in CAMA. And these are the ways it will affect the way you are running your church going forward. These are the implications of what we were presently doing. And these are the things you have to change. And if the client refuses to change, it is your duty to point it out to the client that, listen, if you don't take these corrective actions, it can land you into problem with the Registrar General of the Corporate Affairs Commission. So these are simple things we need to let the clients know in terms of merit assessment. For instance, there was a new law about VAT. A lot of lawyers ought to have written to their clients to say, these are the ways your life will be affected by the VAT implication or stamp duty. And as lawyers, we've got to be very careful with the way we run things. What are the prevailing issues that the young lawyer ought to be aware of? Number one, they inform their clients later about critical issues. You take a case today, ideally within a few days, you should do a client care to the letter, explaining the details of the case. You should do a letter to him explaining how much it might cost. These are some of the things that are missing from the relationship that the lawyers have with the clients. In other words, we give inadequate advice and clientele. We have a couple of people who are trying to work within the Lexel standard in Nigeria. And the truth is that I've seen some of the analysis by some of these reviewers, and we found out that even lawyers themselves, the senior lawyers, the partners, do not peer review each other. Every lawyer should ideally send his own files to another lawyer. Can you help me review this file and see that I'm not taking the wrong step in the way things are being done in this firm? There's nothing wrong in peer reviewing each other. We have to do it because that is why the client has instructed us. So how do we carry out merit assessment? Is it regular? How often do you do your merit assessment? And do we have complaint procedure in the firm? The young lawyer will not know anything about complaint procedure. It is the duty of the senior lawyer to put it down as a standard practice in the firm, that the firm has a complaints procedure. And this is the truth. In a lot of European firms, especially in the UK, it is duty bound that you must give a client care within 7 days. How many days do we give a client care to the clients? How many days do we do all these things to the clients? And then there's the issue of absence of file review process by the seniors. And then how do you review the junior ones? It is not just by looking at their files. You've got to call them in and let them do a moot presentation of what they are doing in the firm. And these are things that will encourage them to put in their best into whatever they are planning to do. And that gives them a growth. It gives them a lot of encouragement in the firm. And we want to quickly, just before I round up, we want to talk about trying to set up practice. Everybody wants to set up practice. Go around the corners, you see AA and Co, this and Co. There are quite a number of one-man practices. You can't blame them because they can't get a job, but they have to earn something for their lives. But the truth is that who is supervising them? Is there somebody around the area? Is there somebody they have an association with that can tailor them into doing things properly? There's nothing wrong in them setting up because they are doing it because the law allows them to set up. But the truth is that they will start on a wrong footing if they do not have somebody who is mentoring them. So they must have a good procedural steps for good practice. In other words, they must inform their clients of issues. But when they are setting up, they do not have all these things at the back of their mind because the truth is that they do not have a mentor. So it is our duty to ensure that we stand in gap for them. We put them through. We give them training. If they require retraining for some of the jobs they are taking on, then you have to give them the proper channel to get that training. Thank you very much.
Thank you very much, Mr. Oyedipe. Questions have been coming in, but we would reserve them to the end. People have also asked for these slides, and we're assuring you that the slides will be placed adequately on the website for your review. So we'll call on Mr. Albert now to take us through his own presentation, and then we'll leave 10 minutes for question and answer. Thank you.
Thank you very much. May I please stand on the established protocol? Thank you for this great opportunity to present what we have. The legal profession is a great and noble profession, and we should do all that we can, just like we have been urged to step forward. So the class of 1989, we are going to use this presentation to explain how we have stepped forward to share what we have and to encourage you to do just like we have done. Well, our topic here is the legal practitioner in the 21st century, how the legal practitioner in the 21st century can leverage on digital disruption. So that's the slant from which we are coming. Digital disruption is something that we are all very familiar with. It's going on all over the world. Both in Nigeria and all over the world globally, disruption is taking place, and disruption is something that we have to basically live with as members of this profession, and find a way to cope with disruption and be on the right side of disruption and not on the wrong side of disruption. So next slide. I want to start with the good news that the legal profession has a lot. The legal profession has a lot for us. There's enough business for all of us in this profession. Like the statistics says, the profession is soon to become $1 trillion industry. And that is despite the fact that 77% of, just to take a sample of the United States, 77% of people in the United States do not get legal help with their legal issues. And there are statistics to that, and you well know that the figure will be much higher in developing nations like Nigeria and other developing nations. So that means that there's a lot of opportunity for us to build this, to grow this profession, and to reach out to the underserved. So next slide. The legal profession globally is heavily being disrupted. This has been going on for quite a long time. Next slide, please. This has been going on for quite a long time. You can see on the slide the different companies that have been disrupting the profession, especially in the United States. LegalZoom, Nolo, all those companies have come in, Ravel Law, Casetext, and then IBM, of course, with ROS, the AI tool that functions like a lawyer. There are so many of these tools, so many of these resources that do the work of a lawyer, And so the global law has responded to this disruptions. And also in Nigeria, we also have disruptions. And we can see, the different companies that have been disrupting the profession in Nigeria. Legopedia is there, Law Pavilion is there, Law Companion, different ones, And then the class of 1989 has also joined the disruptors. The class of 1989 has also joined the disruptors. And that is very, very interesting for us because that is just adding to the numbers, and it is not a case of too many cooks, but this is going to do well for competition. This is going to do very well for the resources and the value that the profession is going to get. Now, somebody will say that every year we say the same thing. We said this last year, we said it 2018, that is true. That is true. But you will also agree with me that this year, the answer is different. I mean, in this COVID era and beyond, our response to technology and technological disruptions should be different from what it was last year. And you know the story, I'm sure, of Albert Einstein, who gave the same exam, that's the same exam he gave to a class the previous year. He gave them the same exam the next year. And his assistant worried why. And he said, this year, the answer is different. After COVID, lawyers need not to be told that our attitude to the legal profession, to legal disruptions by technology should change. And that's why our class we have stepped forward to share with you what we have. Now that also reminds me of, you may ask and say, how does technology affect law? I mean, why should I worry about technology? I should be worried about law. I should be worried about what the courts are doing. I should be worried about the laws, the cases, and so on and so forth. What's my business with technology? Technology is a disruptor and is disrupting every profession, and the legal profession is not immune to that. And to give you an insight, let me just share a short story of what happened in Ghana some years ago. And we learned that there was a conference where in-house counsel of very big client organizations were brought to the stage, and they were queried why briefs that were supposed to be meant for African law firms were going to global law firms. And they answered that global law firms are really jeopardizing African practice because they have deployed cutting-edge technology. They've come with excellent customer service. They've come with specialization, effective specialization, and African law firms don't do these things, and that's why the briefs go to them. And it will shock you to know they were asked, what's the average income that an African law firm earns, vis-a-vis a global law firm when they are paired to do a job? And they said that the African law firm, on an average earns about $30,000, whereas the global law firm earns about $700,000. So that should put it in perspective for us that we cannot toy with these disruptions because, the global law firms have realized that and have built and set up their law firms to be able to take advantage of, these disruptions. So that quickly brings me to what our class has stepped forward to do. Having stepped forward to invest time and huge resources to set up this platform, if you look at the slide, we call it a knowledge-based platform, the knowledge-based platform of a class of 1989. This platform, has e-learning, e-mentoring, e-alumni, and e-CLE all integrated into one. If you go to nlsalumni.org.org, you will see, you'll be able to register and sign up into this platform. It's built for lawyers. It's not for our class. We just step forward, to do what we consider was needful to be done for the profession. So this platform, it's going to have all of these modules, and I'll quickly try to explain the modules so that you will know what you're going to get. You have the e-learning, and that is a tool for law school students to constantly interact with their lecturers. That's we can call it a knowledge-based platform for law school students that serves as an extension of the classroom, the law school classroom. And our aim here is to reveal the power of the internet to law school students by enabling remote learning, remote collaboration, and all of those things, remote tutorials and so on. Because the internet is so powerful, and it is relevant, it is important that law school students discover that right from from school before they step into practice. So the next one, the e-mentoring application or the e-mentoring module provides remote mentorship opportunities for lawyers. Mentorship, like apprenticeship, is very involving. It is very involving. The saying that goes that if you tell me, I'll forget. If you teach me, I will, slightly remember. But if you involve me, I'm going to, be able to replicate what you have done. So that's the idea of mentorship. Mentorship has been missing in this profession for so long, and it is very interesting to have it back, albeit remotely, using the platform of the internet. And on mentorship, we are going to rate mentors, rate mentees, and we are going to feature, highest rated mentors and highest rated mentees, and that's going to encourage everybody to participate and share what they have. Then we also have the e-alumni platform. This enables lawyers to find their classmates for reunion and networking purposes. Several class alumni associations are going to spring up from here, we're sure, and it gives opportunities. It gives opportunity for alumni members to also come together to contribute to the growth of the Nigerian Law School, our alma mater. We will also recognize very active alumni groups, on the platform as we go along. Then the e-continuing legal education platform is the master stroke. I would say, the class of 1989 were an accredited MBA CLE service provider, and we're partnering now with legal experts and seasoned practitioners, to grant lawyers access to a large repository of resources, video resources, audio resources, text-based resources. Thousands of resources will be in this repository, and once you subscribe, you'll have access to them and be able to retrain yourself and upskill yourself and practically recreate yourself. So we are going to also feature the best 10 users of the platform as we go along. The platform is an intelligent platform, and it has analytics, to constantly, read the activities of different people on the platform. So that is, in a nutshell, our platform. Then we have also launched what we call Masterclass Video Competition, because we believe that there are very skilled lawyers, very good, well-trained professionals between ages 5 and 15 post-call who are not known. And we want to use this particular program to find them and bring them to the fore. So please, if you fall within this category, 5 to 15 years, if you're a smart and savvy lawyer and you are very knowledgeable in your area of practice, please step forward and participate in this competition. It will be an opportunity for you to show the world what you've got. So again, talking generally, we have succeeded in creating a platform, and a platform is just like this platform that I'm standing on. And a platform is nothing, much more than what you put into it or what you put on it. So you can see other global platforms, Google, Amazon, Facebook, they just build platforms, and the richness of Facebook is the postings that individuals do from all over the world. The same thing for Twitter and different, platforms that we know. So this platform that we have built is just a framework for all of us to work together and fill it up with resources. And we'll fill it up with resources, legal experts, specialists. Please, we are calling on you, using this forum to call on you to please, let's contribute resources to fill up this platform so that it can be a veritable tool for upskilling members of the profession. We've done a bit, we've stepped out to do a bit, so we're calling on you to please step forward to do your bit. And also we're calling on every member of the profession to not just sign up, but please ensure to use the platform. We hope to work with the Nigerian Bar Association to maybe begin to enforce mandatory continuing legal education requirements, because right now we have a platform that can measure the activities of different people, and they can use those figures to be able to enforce. So we're calling on everyone to use and to contribute to the platform, and so that we no longer become victims. We'll no longer become victims of disruption, but rather we ride on the disruption, to success. I just want to end by saying this, that disruption is not a bad thing if you find yourself on the right side of disruption. Disruption is this. What leads to disruption basically is knowledge. Knowledge leads to disruption. Knowledge leads to innovation. Innovation leads to increased productivity, and productivity leads to growth. It could be economic growth, it could be professional growth, it could be personal growth. So we have a duty to ensure that we have a major pool of resources for members of the profession to feed on, so that they can grow, so that their economic base can grow, their professional skills can grow, they can grow. So that's basically what this is about, and we trust and believe that everybody will hear the rallying call and step up. The young lawyers, those 5 to 15 years, we are basically counting on you to populate this platform with resources. We want you to compete against the seniors, compete against the experts, the known experts. You are the unknown experts, but we are setting up this platform so that you can become known. You could be just 5 years at the bar, but we know that if you are skilled, if you are knowledgeable, it will show. So take a chance and step forward so that the world will begin to see you for who you are. So on that note, I want to say a huge appreciation to everyone. We are very, very, very grateful to all those that have collaborated with us, the resource persons who have collaborated with us, our partners. We are grateful to the class of 1989, our trustees, our advisory board, and of course, the ESCO, the guys who do all the work. I just stand here on their shoulders, basically, to speak on their behalf. So we are very, very grateful. Then we are also very grateful to the chairman of the TCCP and his able team for seeing the potential of this and giving us the opportunity to share this with the whole profession. We are grateful to members of the profession who have struggled through. Please remember that this year, the answer is different. After COVID, I mean, in this COVID era and going forward, our response to technology should not be just an interest. We shouldn't just show, a basic interest. When you show an ordinary interest, your response will be just convenient. You give a convenient response. But when you are committed, then you will do whatever it takes. So on that note, I want to say thank you. Thank you to the organizers. Thank you very much for the opportunity.
Thank you very much, Mr. Albert, for that. I think this afternoon we can say that we have truly been equipped for the new century and beyond. Mr. Oyedepo kindly shared with us aspects that we need to note in relation to good file review, case reviews, mentoring, particularly the younger ones, a good complaints procedure within the firm, and general training. That mentorship came up again in relation to what the class of 1989 has produced, where to make things easier in this century, the mentorship can be remotely done so that we do not have an excuse as older lawyers. So in relation to the knowledge-based platform that the class of 1989 through Mr. Albert has shared with us today, e-learning is very key and should be taken on board. E-mentorship, e-networking, particularly of alum societies, can also be something that could be fostered. And also, there's a special product which I see that the more young lawyers are already excited about, which is the video competition, the masterclass video competition. And with that, I would go on to just pose the questions that have been raised on the platform. Firstly, in relation to the video competition, everyone is eager to know the link. So Mr. Albert, kindly let us know what link there is to that. And everyone has commended, this innovation. I've also seen comments saying that in relation to the mentorship, that the Women's Forum have already initiated their own e-mentorship role. So I guess that keys in very well with what the class of 1989 has been doing. A question or a couple of questions to Mr. Oyedepo that came in relation to the fact that Mr. Oyedepo haven't teased out all what you have in relation to what needs to be done in practice. People are wondering, what is the need of spending 5 years in school? This is from Kingsley Iwejo. Why not just have a different approach like it's done in the USA and Australia, where you have 3 years in school and 2 years law attachments in a firm? Because you're first and foremost a legal practitioner, we would like your views on that. And tied to that question also is a question that says, if the problem is mentorship, as has been posited, shouldn't this be a concern for review of the legal education system? So we would like your views, Mr. Oyedepo, in relation to those two questions. I don't know if you got those questions, or do I need to repeat them? Okay, fine, thanks. And I think it would also be helpful, just based on the comments that have come in through, what you meant by morale in the profession being low, because there appears to be a debate amongst young people as to whether it is low or what precisely you meant by that. Thank you. If any other questions come in, we would let you know.
Yes, thank you, moderator. The question put across is that why spend 5 years in school if you still have to go through all this training? The truth is that education is key. You cannot do away with education. It's impossible. Everywhere in the world, education is key. You've got to be taught all the principles of law. Even in England, you still have to spend about 3 to 4 years in the universities. Some do combined courses, some do straight law courses. If you do combined courses, you come back to have top up so that you can have a graduating legal degree. And after that, you still decide whether you want to go to bar or you want to be a solicitor. So you still have all that, and it's the same thing in Nigeria. The only difference is that Nigeria still allows people to go to the university with their West African school certificate, whereas in England, a lot of them still go ahead to get their higher school certificate, which is the A-levels. So education is key. Practice is different. Practice, you as a lawyer, you're a professional. And it's the same thing like engineers, it's the same thing like surveyors. You've got to have the key skills in practicing the profession. And you cannot be taught everything in law school because you cannot determine what you're going to meet when you get on the field. Every case is different. You can have precedent, you can review precedent cases to enable you know how to handle a case, but every case is unique. Every client is unique and they have to be treated differently. And so that is the essence of practice. So what you meet in practice is different, and practice is all about profession. The legal profession is very, very important in the sense that we're talking about people's, the outcome of a case can determine whether a person goes down into jail or whether the person becomes free. So these are some of the things. So what you're taught in law school is actually the legal principles. That is education, that is learning. But when you get into practice, those are professional routes that you have to follow to become an expert. And that is why cases are argued in court. So you've got to be taught things like your litigation skills. How do you present cases in court? How do you draft documents? How do you construct contractual papers? So that is practically different from what you're taught in school. So in that wise, I say that spending 4 or 5 years in school is still key because that is proper learning. And then what you get there enables you to know how to handle professional matters when you become a professional. And somebody's talking about reviewing the educational system. That is for the professional people in education to say. Whether you spend 2 years in school, for instance, in Buckingham, they spend 2 years and they combine everything, compress everything, and 2 years, 24 months, you get your LLB. But you still have to go to law school. And anything that is missing from that program, you have to get it when you go to your law school. And even after the law school, in England, you still have to go for training contracts. In Nigeria, you don't go for training contracts. So I don't really think that the educational system here is very long or very, it's different from countries to countries. So I think, from law school, people set up their law practices. You cannot do that from England. You can't go and set up your law practice after getting enrolled. There are procedures to set up your practice. So each country has its own unique procedure. And whether morale is low or not, well, I'll tell you one thing. When you leave law school and you get into the profession and you don't know anything, your morale will be low. So what a lot of firms do is that they allow people who are in the universities to be doing their part-time holiday work in the firm, and they get them enrolled, they get them employed. But how many people can you employ? But what we are saying is that morale will be low as long as a young lawyer is left on his own. Even if you're in a good firm and you are left on your own, it's impossible for your morale to be steady. It's impossible. You've got to be trained in that profession. You've got to be taught how to open files. These are things you're not taught in law school. Somebody has to supervise how you write advice letters to clients. Somebody has to supervise how you break down your cost when you are billing a client. Somebody has to supervise how you bill a client. Somebody has to supervise at what point do you collect fees from the client. Somebody has to supervise what sort of merit assessment you give to the client. So these are issues that the seniors are bound to provide to the junior ones. If these issues are not provided for, then it means that the junior ones are left on their own. And once you run into a mistake or a judge cautions you or the client gets dissatisfied with the way you're conducting a file, then your morale will be low because the client is not talking about your legal knowledge. The client is only saying that they have not been properly advised. They have not been, their cases have not been handled properly. They have not been informed very well or professionally how their cases are conducted. I just received a text now. Somebody was asking, what are the things that you do in practice? I tell you, a lot of lawyers that I spoke to don't even give file closing letters to clients. At the end of each case, you've got to write a letter to the client. Your matter has ended. Most lawyers don't do it. The client just walks out of the firm. So what we are saying is that things have to be done properly. If you look at the legal practitioners' rules of procedure, you find out that there are a lot of general terms that are used. Clients have to be treated properly. What does this mean in the profession? Writing a file closing letter is treating your client properly. How many lawyers do that? How many lawyers give the client a questionnaire at the end of the matter? How many lawyers, what do you do to the file when the matter has ended? So these are the reasons why we still talk about mentorship. So the number of years you spend in mentorship would determine how you learn the rope. For instance, somebody doing ordinary litigation might just think that litigation ends there. But when litigation becomes a different ballgame, or when there are conflicting judgments from different courts, then you've got to know how to advise your client. So these are some of the things that we put across to the profession, and we encourage senior lawyers to say, listen, for instance, in some of the electoral cases, there were 3 or 4 conflicting cases in Oshomole's case, and a lot of junior lawyers will not know which one to follow. So the question is, does it mean that if I read Law Pavilion or Legopedia, I will find the solution there? No, you cannot find the solution there. There must be a senior lawyer to tell you how to approach such a case. So the number of years is not really the matter. It is the quality of advice you give to your client that is key, and that is the reason why the client has instructed you. Thank you very much, Ms. Moderator.
Okay, just based again on the comments that have come in, just to announce to everyone that the slides shared by both Mr. Oyedikpe as well as Mr. Albert have actually been placed in the e-conference bag, which are for all participants on the conference website. So if you just access the e-conference bag, you would find the slides in there. I don't know if Mr. Albert would like to share in relation to the video competition, which everybody is quite excited about.
Yes, the registration link is on a flyer that's also that's in the bag. And I'll say here, it's bit.ly/e-CLE videos. Again, bit.ly/e-CLE videos. That's the short URL for registration. We also have a Telegram group where we're discussing, people are asking questions and getting, responses. There's a questionnaire there's a Q&A document that's going around also that's being shared, answering questions regarding the modalities and everything. So there are phone numbers to call, all that's on the flyer. So please, we're expecting interested participants to get in touch with us.
So the key is the e-conference bag. It has all the information required. So just before we thank our facilitators, any last words you have in relation to the 2 trainings that you have shared? Mr. Albert, I'll start with you, and then Mr. Oyedikpe.
Thank you. Well, my last word is that knowledge is going to put us on the right side of disruption. Ignorance caused the slave trade. Please don't forget. The Europeans had mastery of the technology of that time, which was the compass. It was the navigation technology at that time, and that's how they landed at our backyards. And you know the story. Many of our forefathers ended up as slaves because of mastery of technology. Slavery is going on right now in other forms because people are leveraging on technology. We are calling on every lawyer to refuse to become a slave because of ignorance. We are pumping out knowledge resources on the platform. Go and get them and be on the right side of disruption so that you can ride on disruption to success and not become a victim of disruption. Thank you.
Yes, my last word is, like I said at the beginning of the presentation, we cannot fight today's war with yesterday's tool. You have to go back and learn your digital. You have to be digital, learn digital stuff. Zoom, as basic as it is, you must know all the procedures. You must know basic things as sharing documents. And as a young lawyer, Zoom, Classroom, Google Classroom, all these things are key, just like Mr. Albert has said. But my own point regarding young lawyers is you have to thrive as a young lawyer. It's not just about your salary, it's about getting the profession right from the beginning. And until you get it right, you will continue to do things your own way. The truth is that Nigeria is growing. Nigeria is no longer Nigeria of yesterday. People are going to be suing professionals for negligence. I'm aware that a lot of medical doctors are being sued these days. We, the lawyers, are the ones conducting those cases. So it will come down to us because clients are also going to be encouraged to sue us. In the US, if you fall down on a tourist in a tourist attraction, you see people writing to you, do you want to start a personal injury claim? It's all over the place. We're going to start having it in Nigeria. Some years ago, nobody knows about Instagram. So lawyers have to learn the tools. You've got to be digital in all your skills, and you've got to get mentorship from a willing senior. You cannot detach yourself from that experience. It is not the number of years you spend that makes you good, but the number of things you learn. But you cannot say that education is longer than necessary. No, every day you spend learning, you consider it as part of the reasons why you have joined the profession. Thank you very much.
Thank you very much. On that note, we thank our participants and delegates for joining us in today's session. And we want to thank immensely Mr. Femi Oyedipe and Glimpses Training Services for the knowledge, skills, and sharing with us this afternoon. And also Mr. Emeka Albert, as well as the entire class of Nigerian Law School 1989. It's been insightful. It's been worthwhile. We look forward to learning more from you as we take on all the counsel, as well as also subscribe to the product. Thank you and have a good rest of the afternoon.
Another big thank you to the facilitators of this training session. I'm sure young lawyers and indeed the experienced lawyers found that very useful. We'd like to inform delegates that the State of the Nation session, initially scheduled for 1:30 p.m. this afternoon, has been moved to 2:30 p.m. This afternoon. Now, the State of the Nation is a stimulating exchange on the state of the nation. And of course, on that panel is Professor Yemi Osinbajo, SAN, GCON Vice President of the Federal Republic of Nigeria, and Right Honorable Femi Gbajabiamila, Speaker, Federal House of Representatives. They'll join us after they exit the Council of State meeting. So we'll be waiting for them for that to start at 2:30 p.m. today. Also, after that, we're going to, around about 30 minutes to the end of that particular session, we'll also have 3 other breakout sessions. One titled Our New World, the Digital Economy. This will center around the realities and the impact of living in a new digital age and economy. Panelists for that session are George Dunker, President of ECOWAS Bank for Investment and Development. We also have Uzoma Dozie, CEO of Sparkle. Also on that panel is Mobola Johnson, the former and first Minister of Communications Technology. Olubenga Agbola, co-founder and CEO of Flutterwave, will also be on that panel. And Issa Ali Pantami, Minister of Communications and Digital Economy, also feature on that panel, and the moderator for that panel will be Ayo Ogunkomi, partner at Oak Advisory. The other panel that also will run parallel to that is an interesting one titled No Means No. This will deal with gender-based violence and the scourge of rape and sexual harassment. Panelists include Abimbola Akeredolu, SAN, partner Banwu and Igodalo. We also have Sheikh Nuruddin Lemu, Nigerian Islamic scholar and pedagogue. We also have Titilayo Vivo Adeni, coordinator, head of Lagos State Domestic and Sexual Violence Response Team, the DSVRT. Efa Chukuma, founder Project Alert, will also feature on that panel, and the moderator will be Olawale Fakunda, Attorney General of Ekiti State. And last for that, the third panel session is entitled The Equality Gap, and it focuses on changing the status quo against stereotypes in the legal profession. Panelists are Honorable Dame Linda Dobbs. We also have T. Ayuba Haruna, Commissioner for Commerce and Industry, Kebbi State. Bayo Obumarada Ayomide Alabi, Partner Africa Primera Legal, will also be on that panel. Terry A. Mazer, Chair of the Women in Law section of the New York State Bar Association, will also feature on that panel. Also will be Dr. Femi Elias, former UN Assistant Secretary General, Visiting Professor of International Law, Queen Mary University of London. And the moderator for that panel will be Dr. Nkiru Balungu. She's the founder and managing director of RDF Strategies. She's also the founder and chair of the Africa Women on Board. Thank you.
Okay.
Inform you about one of the foremost publications we have in the field of practice in Nigeria, produced by the Nigerian Bar Association. And I'm speaking about the Nigerian Bar Association section on legal practice journal. This is both a professional and an academic publication of the section that speaks to various practice areas. The contributions and the papers that have been captured in these journals since inception have contributed immensely to the development of the law, to academic research, and to case management in firms, as well as the decisions of various superior courts. In this latest edition, which just came off the press last week in time for the NBA 2020 conference, we have articles that cover fields of criminal law, electoral law and practice, labor and employment law, telecommunications law, medical law, constitutional administrative law, and several other fields. It's the 6th edition in the series. This is a duly accredited journal for academics, accredited journal and reference material, even for court advocates. I want to recommend this if you do not have it in your library, and you can also pick up the previous volumes from the NBA SLP Secretariat. You can place your order by calling Bonuade on 081 66 41 3698, 081 66 41 3698. Or you can just send an email to info@mba-slp.org, info@mba-slp.org. And you can order a copy from the Secretariat. You can also discuss how they can ship it to you wherever you might be located. In view of the pandemic, this would have ordinarily been available to pick up at the conference venue, but being a virtual conference, you would have to place an order and it will be definitely shipped to you. I want to encourage everyone who is here not to miss this opportunity. You can go away with this and you can continue to build your library and build the level of intellectual contributions we make to our judgments in court as well as to academic papers. Thank you very much and have a wonderful conference.
My name is Bisi Fayemi. I am a women's rights activist, gender specialist, policy advocate, and writer. I bring you warm greetings from Ekiti State, the land of honor, where I'm the First Lady and have been engaged for quite a number of years now on a number of initiatives to mitigate sexual and gender-based violence. I thank the leadership of the Nigerian Bar Association for inviting me to address this year's conference. I am humbled and thankful for the opportunity. Every day, we open our newspapers and we read about a woman or girl who has been sexually abused. Gender-based violence is no respecter of age, class, or educational background. Why should we care about violence against women and children? We should care. We should care because it destroys lives, it destroys families, it devastates communities. It diminishes the capacity of women to fulfill their full potential. It also affects our economy. Women who are victims of violent sexual crimes are afraid to report for fear of stigma, blame, and rejection. As is the case in many other parts of the world, when the cases are reported, the victims are put through so much, and it takes such an effort to get a conviction. The process leaves the victims feeling assaulted all over again. When there is no justice, they do not get closure, and the healing process takes so much longer. With no sanctions for violent sexual assaults, a culture of impunity continues to thrive. And that is why today, here in Nigeria, we are faced with a sexual violence crisis of unprecedented proportions. And the recent COVID-19 lockdowns have exacerbated a condition that has already been extremely problematic for some time. Patriarchal norms and values, which fuel a sense of entitlement to women's bodies, violent conflict, kidnappings, drug abuse, poverty, alcoholism, juvenile access to pornography, cultism, and several other factors all drive sexual and gender-based violence in our communities. I would like to talk to you all about the critical importance of political will in ensuring that legal and policy frameworks mean something in the lives of ordinary people. And I will share some of the work that we have been doing in that regard in Ekiti State. The administration of my husband, His Excellency Dr. Kayode Fayemi, Governor of Ekiti State, takes gender-based violence very seriously. Ekiti State has a comprehensive gender-based violence law, which makes provision for a multi-sectoral and interagency GBV management committee to monitor the implementation of the law, and I chair that committee. I'm pleased to say that over the past year, the Ekiti State Gender-Based Violence Management Committee, which is a coordinating mechanism in Ekiti State for GBV issues, has been able to achieve a number of things, and I'll mention just a few. First of all, we were able to see the speedy passage of the revised Ekiti State GBV law, October 2019. By harmonizing the previous Ekiti GBV law of 2011 with the 2015 Federal Violence Against Persons Prohibition Act, known as the VAP Act, Ekiti State now has a much stronger GBV law. Another thing we've been able to accomplish is the passing of the Compulsory Treatment and Care for Sexually Abused Minors Law of 2020, the first of its kind in Nigeria. This legislation was signed into law by His Excellency the Governor on the 5th of June, 2020. Another accomplishment that we are proud of at the Ekiti State Gender-Based Violence Management Committee is that through the Office of our Attorney General, the Sex Offenders Register of 2013 was reactivated in 2019. In addition, Ekiti State now has a name and shame policy, which publishes the names and photographs of convicted sex offenders in Ekiti State. At this point, I would like to pay tribute to our Attorney General in Ekiti State, Honorable Wale Fakponja, who I usually describe as the best Attorney General in Nigeria. We thank him for his passion. We thank him for his dedication in ensuring that we have many of these laws and policies in place. The Attorney General has also introduced what is called a Victims Charter, which outlines the rights and victims of survivors of GBV in Ekiti State. We also have a range of services in place in Ekiti to respond to survivors of gender-based violence, such as a state shelter where we can look after women in distress and their children on a temporary basis. And recently, we opened the Moremi Clinic, which is a sexual assault referral center. It was opened on the 23rd of June, and it is a one-stop free clinic for GBV survivors across Ekiti State. We also have a survivors fund, which again is the first of its kind in Nigeria. And our GBV law makes provision for this fund. And since the establishment of this fund, we have managed to support at least 155 women with various initiatives to ensure that they can rebuild their lives. Examples of these initiatives include assistance with renting accommodation, payment of school fees, and other needs as determined by the survivors themselves. During the COVID-19 lockdowns, all our GBV frontline responders in Ekiti State managed to support women, regardless of how difficult it was during that time. They managed to support them with medical attention, with provision of shelter, with legal aid and food palliatives. I'm also pleased to note that our coordinating mechanism for GBV issues in the state has been supported very robustly by a network of NGOs who provide frontline services on GBV issues in the state. Most of them are members of the GBV committee, and they work in partnership to ensure effective service delivery on GBV issues in the state. In addition to what I do in Ekiti State as the First Lady, I'm also the chair of the Nigerian Governors' Wives Against Gender-Based Violence Working Group. This is a group that was established in June 2020. It is a working group of 21 governors' wives from across the country, from all zones. And we decided to come together to address how we could tackle GBV issues in our respective states. Like most Nigerians, governors' wives have been concerned about the spike in sexual events, particularly during the COVID-19 lockdowns. We also managed to influence the declaration of a state of emergency by the Nigerian Governors Forum in June 2020. And since the governors declared this state of emergency, we have seen a change in terms of political will. Our governors in their different states have been working very hard to ensure that they treat GBV issues very seriously. So for example, since the declaration of the state of emergency, the VAP Act has been passed in Bauchi State and Akwa Ibom States, and we know that other states are still working on their legislation and they will be passed before the end of the year. I would like to call on all members of the NBA to intensify efforts in combating sexual and gender-based violence in Nigeria as a body and as individual members. Please let us join hands to ensure that we have adequate legal and policy frameworks in place at state and national level, and that the much needed political will and accountability to make these instruments work is in place. It is important that we center our anti-GBV efforts on the needs of survivors and not on protecting perpetrators. While suspects are entitled to a defense, you are all lawyers, so that's your job, you have to defend suspects. We believe that any actions that shame, intimidate, or silence GBV survivors must be seriously frowned upon. We should criminalize perpetrators of violence, not the survivors. I salute the NBA for creating space for women within the organization to allow them to work together and to express themselves. I thank all the female lawyers who are at the forefront of providing much needed support and services to GBV survivors, particularly through organizations such as FIDA. Nigerian citizens, especially women and children, are counting on your leadership. These spaces are an effective training and mentoring ground for the kind of leaders we need in the country. We need more women in politics and decision-making at all levels. And I hope some of you will take this up at some point. I know that as men and women of the law, you are bound by the limitations of your profession. And there are certain things that you can do or you can't do or you won't do. However, I want you all to be passionate about sexual and gender-based violence. I want you to have a sense of outrage and a yearning for urgent action and change. Together, we can make this country safe. Let us all be determined that we will not allow a culture of sexual violence, abuse, and exploitation to consume the lives of half of our population. We cannot afford to descend into a society where no woman or girl is free or safe enough to walk the streets. Please let us work together. Let us end this pandemic. Thank you once again for giving me the opportunity to address you. Thank you for listening, and God bless.
This conference affords us the opportunity to review how we operate.
Not toy with the independence of the judiciary.
With well over 12,000 delegates in this conference, this is by far the largest gathering of lawyers on the continent of Africa.
Dear learned colleagues, as we overcome these trying times and settle down to a new normal, Law Pavilion celebrates the resilience of our esteemed clients. We have unveiled a new ecosystem of legal service delivery in Nigeria, so you can harness the silver lining of opportunities that lie within this crisis. Introducing the new Law Pavilion Prime 5.0, now available online for mobile phone users, fortified with court forms from all jurisdictions with pre-filled sample forms, AI-assisted document review system, Microsoft Word plugin that enhances your legal drafting advantage right within your Microsoft Word. Manage your law firm remotely with our case management system. One more thing, get access to millions of potential clients through our new industry-leading lawyers and law firms directory. Experience the new normal in legal service delivery today. Visit www.lawpavilion.com/experience.
Hello, it's that time of the year again.
And we at Solo & Co are here for you.
What's more interesting is you can order in several ways. You can come to one of our stores in Abuja, 40 Dublin Street, Wuse 2, or in Lagos at the Law School campus or at Landmark Tower. You can also go online, www.solohan.com.ng, and place your order there. There's a wide range of products. All our products are there. You can order from there, or hit us a DM on Instagram or message us on WhatsApp.
When you order any of our products, we deliver to you within 2 to 4 working days. Or you can as well pick up at our head office in Abuja.
When you buy any of our products, we give you a complimentary photo shoot. We're saving you the time and the hassle of going helter-skelter trying to find a photographer. We have the best for you. Shop at Solo.
Post-COVID-19, economies are being reset. And the true definition of wealth is now an intangible intellectual property. The required innovations for restarting the economy and governance rely on the maintenance of rule of law through equal and efficient access to justice. Law Pavilion, in partnership with Telnet, presents the following innovative solutions, redefining a new ecosystem for justice delivery in Nigeria. Law Rights. This is a mobile application that displaces the old practice of consulting family and friends first for legal advice by making all necessary information available anytime, anywhere. You don't only get to know your rights, you can easily report a violation or consult a lawyer in a jiffy, among other things. The Law Rights app, in conjunction with the Case Manager Assured, provides the lawyer advanced tools to properly manage his clients, briefs, tasks, and entire law firm. The Case Manager Assured integrates with the Law Pavilion Prime, an online repository of case laws, regulations, precedents, forms and agreements, and rules of court. This makes it possible to achieve so much in so little time. It is the reliable legal research companion. Now it also boasts of e-laws of Lagos State, as well as legal textbooks and journals. It's a complete e-library for today's lawyer. E-registry removes the stress involved in filing a matter in court registries, as this can now be done seamlessly from anywhere, anytime. Court Manager Assured automatically captures documents from the e-registry and helps judges monitor progress of matters from a single dashboard. Oh, one more thing. The Court Manager Assured uses artificial intelligence to help judges review lawyer submissions and documents, making administration of justice easier, faster, and much more efficient. Now, that's the new ecosystem of legal service delivery. Visit www.lawpavilion.com/experience.
gives me great pleasure to give this message to our association on the 60th anniversary. So I've been told, but I have my own correction on that. I think we've come a long way. And at the same time, we've made great strides. Some things we've done very well and we've improved. Some things we have scored below pass mark. But then that is life. You know, you expect up and down. This new executive, I hope, will bring us upstream to be where we should be at the time in creation, because now is the time of the youth. So I can only wish them the very best of luck and hope they will build on the good lessons of the past. For the annual conference about to commence, I wish everybody good deliberation and a happy time.
There is no doubt that this is groundbreaking. Mr. President promoted female inclusion and gender equality in all bar activities. He appointed females in external board. He put forward women and nominated them to represent the bar at both state and national levels. This has resulted in the fact that for the very first time, there is a significant number of women in political appointments. The resuscitation of the hitherto comatose MBA Women Forum in September 2019 and the full support for the forum and to the forum to the extent that the MBAWF is now standing tall amongst the sections and fora is very laudable. This has enabled the empowerment of many female lawyers in Nigeria, resulting in remarkable achievements. A female became the General Secretary of the MBA at the last election in June after almost 40 years. Another female became the first female Vice Chairman in the Ibadan branch, MBA Ibadan branch, after 66 years. It is the vision of the MBA Women Forum to address matters of interest to female lawyers, make female lawyers an influential voice in the society, and encourage female lawyers to have a global outlook, perspective, and reach. This icon of gender parity has enabled the forum achieve all this. With all this and more, the time will not permit me to mention the executive and council members and thousands of vibrant female lawyers have unanimously agreed to give Paul Usoro SAN, the 29th president of the Nigerian Bar Association, an icon of gender parity, an advocate for gender inclusion, the award, Ambassador of Women's Rights Award, in recognition of his exemplary leadership and dedication towards empowering female lawyers for success. Nigerian female lawyers, please celebrate Paul Usoro SAN. Mr. President, the icon of gender parity, the advocate of gender inclusion, will celebrate you. Women lawyers in Nigeria celebrate you. The ambassador of women's rights, recognition given to you. You are celebrated. Thank you. I'll now call on Professor Joy Ezelo, who is coming in virtually. She's the Dean of the Faculty of Law, University of Nigeria, Nsukka, and a distinguished council member of the Nigerian Bar Association Women Forum, with so many other titles in the UN and many others, to join me in presenting this award to Mr. President. Joy Ezelo. Well, if we cannot connect to Joy now, I'll do the presentation. Mr. President, we're waiting for Professor Joy Ezelo, Dean, Faculty of Law, University of Nigeria, Nsukka, a distinguished member of council, one of our foremost gender advocates, She's representing us at the United Nations. She's one of those foremost people who will speak up. Joy Ezelo, OON. If Joy cannot be connected because of the IT technical issue, Mr. President, the Nigerian Bar Association Women Forum presents Ambassador of Women's Rights Award to you, Mr. Paul Usoro, SAN, President, Nigerian Bar Association, 2018 to 2020. In recognition of your exemplary leadership and dedication towards empowering female lawyers for success, this 27th day of August, 2020. Thank you very much, Mr. President.
Thank you so much.
Well, we'll give Mr. President the floor to make a few remarks.
Very distinguished ladies and gentlemen, I'm actually overwhelmed by this award. This was not an award that I was expecting. I believe that what I have done is what I ought to have done, what indeed ought to have been done even before my time. And that is to resuscitate the Women's Forum of the Nigerian Bar Association. I feel proud, though, that I did play a significant role in bringing that association or that forum back to life. It is one of the 2 active forums of the Nigerian Bar Association. And I feel particularly proud of the developments and the milestones that this forum has achieved under the leadership of Professor Oluyemisi Bamgbose, Senior Advocate of Nigeria. It's interesting that I have been named an ambassador of women's rights, because that's kind of suggests that I have to be going out and doing the role, playing the role of an ambassador. But my chairperson, I want to say that I'm also very happy having to be an internal ambassador. In other words, to be working with the forum, and in whatever capacity or whatever that the forum might want me to help them on, I would be very available. In other words, my role does not necessarily have to be limited to being an external representative. I am also very happy to work with the women in whatever programs that you would do. If I had the time, I would actually talk about why this is very important. But suffice for me to say that this is one of the critical, foundational forum for the Nigerian Bar Association. It is actually a forum that, if well developed, and I am happy that I have a very able and competent hand to develop it, if well developed, it becomes something of a cornerstone, not only for the association as a whole, but really for Nigeria. Don't forget, in our native land, we have the saying that if you bring up a woman, you bring up a community, a village. And that is representative of the role that women play in development generally. And if we help in our own little way in having to bring up the women, then we are also in our own way helping to develop a community. And I wish the Women's Forum very, very well. I would not be president of the Nigerian Bar Association in another couple of hours. But my role as an ambassador and as a servant of the forum, in any way that you might wish me to be, will continue well beyond my office. I also want to express appreciation not only to my very able and competent chairperson, whose appointments I feel absolutely proud and fulfilled that I had made, but I want to also extend my appreciation to those around the chairperson. And that includes the Executive Council and of course the Governing Council, made up of very critical and important, accomplished. And that was one of the things that I was looking for. I needed women of accomplishments, women of distinction, and I had them. And then of course your secretary, who has been exceptional in helping you to run the Secretariat. Those are very critical persons that I must also acknowledge. And I thank you so much for making my tenure quite a success as far as this area is concerned and in other areas. And congratulations on your recent memorandum of understanding with the New York Bar. That by itself is very exceptional. It is something that I'm hoping you're going to develop. Your mentoring program, and I'm just mentioning some of the things that you have been doing. Mentoring program, that is something that a lot of women will benefit from. Incidentally, mentoring is not only for young ladies, it's for literally everyone. And I'm sure that the women folks will feel very satisfied.
Thank you.
Finally, thank you so very much, my chairperson. And please give my association to the Governing Council and to your EXCO. Thank you so very much.
Thank you. Nkiru, please, I'll hand over to you. We are done with the ceremony. It's a good time to go into our topic, equality gap.
Post-COVID-19, economies are being reset. And the true definition of wealth is now an intangible intellectual property. The required innovations for restarting the economy and governance rely on the maintenance of rule of law through equal and efficient access to justice. Law Pavilion, in partnership with Telnet, presents the following innovative solutions, redefining a new ecosystem for justice delivery in Nigeria. Law Rights. This is a mobile application that displaces the old practice of consulting family and friends first for legal advice by making all necessary information available anytime, anywhere. You don't only get to know your rights, you can easily report a violation or consult a lawyer in a jiffy, among other things. The Law Rights app, in conjunction with the Case Manager Assured, provides the lawyer advanced tools to properly manage his clients, briefs, tasks, and entire law firm. The Case Manager Assured integrates with the Law Pavilion Prime, an online repository of case laws, regulations, precedents, forms and agreements, and rules of court. This makes it possible to achieve so much in so little time. It is the reliable legal research companion. Now it also boasts of e-laws of Lagos State, as well as legal textbooks and journals. It's a complete e-library for today's lawyer. E-registry removes the stress involved in filing a matter in court registries, as this can now be done seamlessly from anywhere, anytime. Court Manager Assured automatically captures documents from the e-registry and helps judges monitor progress of matters from a single dashboard. Oh, one more thing. The Court Manager Assured uses artificial intelligence to help judges review lawyer submissions and documents, making administration of justice easier, faster, and much more efficient. Now, that's the new ecosystem of legal service delivery. Visit www.lawpavilion.com/experience.
My name is Olusegun Abimbola. I'm the chairman section on legal practice. And may I take a little bit of your time to inform you about one of the foremost publications we have in the field of legal practice in Nigeria, produced by the Nigerian Bar Association. And I'm speaking about the Nigerian Bar Association section on legal practice journal. This is both a professional and an academic publication of the section that speaks to various practice areas. The contributions and the papers that have been captured in these journals since inception have contributed immensely to the development of the law, to academic research, and to case management in firms, as well as the decisions of various superior courts. In this latest edition, which just came off the press last week in time for the NBA 2020 conference, we have articles that cover fields of criminal law, electoral law and practice, labor and employment law, telecommunications law, medical law, constitutional, administrative law, and several other fields. It's the 6th edition in the series. This is a duly accredited journal for academics, accredited journal and reference material, even for court advocates. I want to recommend this if you do not have it in your library. And you can also pick up the previous volumes from the NBA SLP Secretariat. You can place your order by calling Bonuade on 081 66 41 3698. 081 66 41 3698. Or you can just send an email to info@mba-slp.org. info@mba-slp.org. And you can order a copy from the Secretariat. You can also discuss how they can ship it to you wherever you might be located. In view of the pandemic, this would have ordinarily been available to pick up at the conference venue, but being a virtual conference, you would have to place an order and it will be definitely shipped to you. I want to encourage everyone who is here not to miss this opportunity. You can go away with this and you can continue to build your library and build the level of intellectual contributions we make to our judgments in court as well as to academic papers. Thank you very much and have a wonderful conference.
This conference affords us the opportunity to review how we operate.
We should not toy with the independence of the judiciary.
With well over 12,000 delegates in this conference, this is by far the largest gathering of lawyers on the continent of Africa.
Dear learned colleagues, as we overcome these trying times and settle down to a new normal, Law Pavilion celebrates the resilience of our esteemed clients. We have unveiled a new ecosystem of legal service delivery in Nigeria, so you can harness the silver lining of opportunities that lie within this crisis. Introducing the new Law Pavilion Prime 5.0, now available online for mobile phone users. Fortified with court forms from all jurisdictions with pre-filled sampled forms. AI-assisted document review system. Microsoft Word plugin that enhances your legal drafting advantage right within your Microsoft Word. Manage your law firm remotely with our case management system. One more thing, get access to millions of potential clients through our new industry-leading lawyers and law firms directory. Experience the new normal in legal service delivery today. Visit www.lawpavilion.com/experience.
Hello, it's that time of the year again.
And we at Solo & Co are here for you.
What's more interesting is you can order in several ways. You can come to one of our stores in Abuja, 40 Dublin Street, Wuse 2, or in Lagos at the Law School campus or at Landmark Tower. You can also go online, www.solohan.com.ng, and place your order there. There's a wide range of products. All our products are there. You can order from there, or hit us a DM on Instagram or messages on WhatsApp.
When you order any of our products, we deliver to you within 2 to 4 working days. Or you can as well pick up at our head office in Abuja.
When you buy any of our products, we give you a complimentary photo shoot. We're saving you the time and the hassle of going helter-skelter trying to find a photographer. We have the best for you. Shop at Solohan.
Post-COVID-19, economies are being reset. And the true definition of wealth is now an intangible intellectual property. The required innovations for restarting the economy and governance rely on the maintenance of rule of law through equal and efficient access to justice. Law Pavilion, in partnership with Telnet, presents the following innovative solutions, redefining a new ecosystem for justice delivery in Nigeria. Law Rights. This is a mobile application that displaces the old practice of consulting.
Next session, a stimulating exchange on the state of the nation. On the panel today is Professor Yemi Osinbajo, Senior Advocate of Nigeria, GCON, the Vice President of the Federal Republic of Nigeria. Also on the panel is Right Honorable Femi Gbajabiamila, Speaker, Federal House of Representatives. And moderating this panel is Dr. Nduka Obaigbena, Chairman and Editor-in-Chief, This Day Media Group.
Bobo?
Yes, hello. We are welcome to the 60th anniversary of the Nigerian Bar Association Conference, and it's our privilege to discuss the state of the nation with the Vice President of the Federal Republic of Nigeria, an eminent law professor, Professor Yemi Osinbajo. It's also a privilege to discuss the state of the nation with the Speaker of the House of Representatives, the Right Honorable Femi Gbajabiamila. What is the state of the nation? The state of the nation today is under COVID-19. And for many, it's a new world. It's a new world emerging out there. And today, indeed, today, the 27th of August, marks the 6th month of the index case of COVID into Nigeria. So how have we fared as a country in managing the pandemic? Many say the pandemic has not had that devastating effect on Africa from perhaps the health angle. But the pandemic has indeed had major economic impact on Nigeria. Our key source of revenue, oil, is in shock. And it has affected the way we live our lives, the way we do business. It has affected education and affected a range of other issues. In responding, the government has put together the Economic Sustainability Plan headed by the Vice President. The National Assembly has put its own palliatives, as it were, and we are trying to cope. But in discussing the state of the nation, what is the state of the world? Where are we in the world? The world is in turmoil. There is the emerging Indo-American crisis, the US versus China. The world order, as we knew it, is no longer there. Europe is in crisis. South America is in crisis. Middle East continues to ravage. And everybody is trying to fit itself together. How do we respond? And what do we need to do as a nation to turn this pandemic or this crisis into opportunity, as the government said at the beginning? So my first question to the Right Honorable Professor Yemi Osinbajo is, have you succeeded in turning the pandemic, the COVID-19 crisis, into an opportunity for the people of Nigeria? Thank you.
Thank you very much. Nduka, thank you. And thank you very much also to the Bar Association, especially the leadership, for this honor of speaking to us all on the state of the nation. Regarding whether or not we have succeeded, I think it's too early, it's early days, to say whether we've succeeded in turning the pandemic into an opportunity. But I must say that the pandemic itself presents an opportunity. And we, as a government, have seen it as such, as an opportunity to do so many different things. First of all, even just in scaling up our medical response and our capacity to be able to respond to pandemics now or in the future. As you know, we used to have 4 molecular laboratories. Now we have 64 molecular laboratories. We have now capacity for far more ICU beds. We have, I think, now something in the order of over 300 ICU beds and over several now just in terms of other beds, bed space and hospital capacity that is also considerably high today. But we've also, in terms of just improving capacity and improving our ability to respond, just on the medical side alone, you will see that, you know, at a point, we were worried about just the capacity to provide oxygen. Now we have several facilities for oxygen, even oxygen production as in Nigeria. That today we are able to do much more, even with our capacities in the hospitals. We now have about, you know, just bed capacity alone, 7,190 beds. We have about 20,000 health workers that have been trained on infection and control. We have over 4,000 now oxygen delivery equipment and accessories nationwide, you know, and we've also been able to provide about a minimum of about ₦1 billion to each state just to improve their capacity. Lagos State alone had about 10 billion. So just in terms of improving medical capacity, a lot has happened. But then that's on the medical or the healthcare side. On the economic side, obviously, you've spoken about the economic sustainability plan, and this has provided, again, yet another opportunity of addressing some of the serious concerns that we have on the economy. I think for us as a government, you know, one of the key worries that we had was more for how this would affect jobs and job production and job sustenance. And I think that what we saw was a problem, a very big problem with the informal workers, you know, and persons who have to work day to day for their survival. And what we tended to see there was that people like, you know, just to take an example, tailors, artisans, caterers, event planners, decorators, makeup artists, hairdressers, barbers, tailors even for Ashwebi, printers, souvenir dealers, people like that, obviously were in trouble. And we needed to address the concerns that they had, because these people rely on an ecosystem that had collapsed with the COVID-19 pandemic. And that's aside from big industries such as hospitality. Of course, occupancy rates in hotels fell, in some big hotels below 10%. Even hospitals, even private hospitals, you know, experienced problems because people avoided private hospitals, same as aviation. And of course, we know all the problems associated with that. So we're concerned with saving those jobs, which is why we put in place what we've described as a survival fund, which will cater for artisans, 42,000 per state for a start, across the states. And that will be in the form of support for artisans. We also have a payroll support scheme, which will support persons, especially in, you know, private school teachers, for example, and then small businesses who employ up to and not more than about 50 persons. We also have some kind of support for them. At the moment, we're in the process, you know, of compiling that data, and the criteria has been set already. That committee is headed by the Honorable Minister of State for Industry, Trade and Investment, and the Vice Chair is Mrs. Ibukun Awoshika, the chairperson of First Bank. So they are basically looking at the criteria for giving out this payroll support, and also for several of the other support schemes that we have. So by and large, you know, we're tackling those issues. Of course, we're also looking at the bigger issues. How do we support aviation? How do we support the hospitality industry? And these are big areas where we're looking at support. Now, in the first place, you're probably aware that the CBN has already put in place several mechanisms for ensuring that loans that have been taken by companies and by some of these big enterprises in the sectors that I've just mentioned, that there is some succor for them in the form of restructuring of their loans, lower interest in some cases, in some moratorium is granted, and all of that. I'm just picking the headlines of some of these efforts. And of course, the Bank of Industry has also had to reduce interest rates in many cases and restructure facilities. So there is a wide range of issues. I'm sure we'll get to talk about them in some detail later on. But this is just to give you a broad, if you like, a broad framework of the kinds of efforts that are going on. And this is, of course, so I think I'll just hold on here so that I don't take on too much time. And I'm sure we might come back to these as we go along. Thank you.
Rising up to fighting the pandemic. But when we see the House of Representatives in a public hearing, it's about NDDC and people fainting. Mr. Femi Gbajabiamila, can the legislative branch do more for the people of Nigeria, and how?
Yeah, I'm sorry, Uduka, can you hear me?
I can hear you.
Okay, well, thank you very much. Let me also very quickly thank you for inviting me to this very important conference, and also at the same time commend the organizers and thank and congratulate Mr. Olumide Akpata and the new ESCO of the NBA for the new offices and the election, recently concluded elections. Going straight to your question, Uduka, it's what can the House of Representatives do for Nigerians? Is that what your question was in relation to the probes and the NDDC? I want to understand clearly what you're asking me.
Essentially, most parliaments are responding positively to the pandemic and putting things in place for their citizens. But our parliament is engaged in arguments over corruption in federal agencies. Can you do more to solve the people's problems and at the same time deal with the issues of corruption?
Well, let me try and unbundle your question. First of all, the Nigerian parliament, the House of Representatives specifically, perhaps was the first one to come out of this stable in terms of the COVID-19 pandemic. If you remember correctly, we almost immediately passed the economic stimulus bill, came out of the House of Representatives, spent some time in the Senate, but eventually came out of the Senate. And that had there were three segments to that addressed the issue and how it affected the people. It talked about moratorium on mortgages. It talked about lifting duties on medical equipment and several other aspects to it. So we were the first to do that. Secondly, the House of Representatives immediately forfeited two months of their salaries and sent to the PTF for onward distribution to the people of Nigeria. And we've been doing so much since then. Of course, the controversial infectious disease bill came out of the House of Representatives. Much as many might have gone against, much as many might have had their own personal opinion, particularly regarding the vaccine section of it, I think it was also a proactive move by the House of Representatives to do something to arrest what had become perhaps the most serious pandemic we had ever witnessed in our lifetime. But the issue of NDDC obviously had nothing to do with the pandemic. It's just something that we had to do. What you call arguing with themselves is something that happens in every parliament. We must investigate. We must hold people to account, and we must fight corruption, and probes are part of how you fight corruption. But let me very quickly say this, Nduka. I don't want to limit this, well, my own thoughts to COVID-19. Now, like the Vice President said, COVID-19 has actually helped us in that problem. We have been able to identify, it has amplified the problems in Nigeria. But when you talk about the state of the nation, quite honestly, unless we want to run a fool's errand or kid ourselves, the state of the nation today is the state of the nation 20 years ago. And until we understand that we've been stagnant, more or less, in the last 20 years, if you pick up the newspaper 20 years ago, you're going to find the situation about electricity as the same reporter you're going to find today. Talk about corruption 20 years ago, you'll find it on the front pages of the newspapers. And that's the same thing you're going to find today. Talk about hospitals. You find it 20 years ago in Daily Times. And that's what you're going to find today. So when you talk about the state of the nation, in whatever ramification, however you look at it, have we made progress from 20 years ago? The question is no, or rather the answer is no. What COVID-19 has done is to bring forth to the front where we're coming from and how far we've been able to move the needle, how far with the cards, which we haven't done. But I believe with what is going on today, all over the world, I believe the House of Representatives will continue to be proactive. The issue of economic reform, political reform, which dovetails into social reform, educational reform. Those are things that are already on the table in the House of Representatives. We have a legislative agenda, which we launched last year, but which we have updated and relaunched again about a month ago, in keeping with the times. Because when we launched our ninth House of Representatives legislative agenda, the issue of COVID-19 we were blindsided by that. Now we have updated that and tweaked it in conformity, or rather in within the scope of what the COVID-19 pandemic would allow us to do. And we actually tagged that contract with Nigerians. And why did that? We intentionally labeled that legislative agenda contract with Nigerians. If you followed it, you'll understand what I'm saying. Because we wanted Nigerians to hold us to account. So these are the things we have stated that we're going to do in the next 4 years. And so we want to be able to tick the boxes. It's a contract between us and Nigerians. And I'll be more than happy to send a copy of that to the Nigerian Bar Association for onward transmission to members of the bar. Thank you. I'll stop at that too.
Yeah, before I go to the Vice President, just coming back, since we're in the legislative branch, a number of the crises facing Nigeria is constitutional. If it's security, if it's policing, if it's religion, even if of economic growth, you have said it rightly, that the problems you met 20 years ago are still the problems today. Are you ready to have major constitutional reforms that will restructure the security apparatus of the country? So instead of calling for removal of service chiefs, why don't you use law to change the security apparatus of the country such that we have better governance?
Thank you very much, Nduka, once again, for a very deep question. The issue of reform, constitutional amendment, is something that's already on the table in the House of Representatives. We announced the names of members of that constitutional amendment committee, and they will set to work as soon as we resume on September 15. But prior to that, we have right now, as we speak, the Police Reform Act, which has left the National Assembly. I think it left a couple of days ago, and it's making its way slowly but surely to the president for assent. And that Reform Act is far-reaching. It actually encapsulates the issue of community police, the issue of the payment of policemen and their salaries, their allowances, and a lot of other issues that will make the policing environment a lot easier for them. On the issue of constitutional amendments, like I said, we're working on that. We're going to hit the ground running as soon as we come back. Delineation of roles. It will involve delineation of roles and responsibilities between the tiers of government, which we need to define the roles and responsibilities of the federal, the state, and the local government. We've all been mouthing federalism, but we're not actually walking that talk. And so this affords us an opportunity when we amend the Constitution to streamline what's on the exclusive list, what's on the concurrent legislative list, and what is residual to the state. And we all know that, I mean, in a true federal structure, you have very limited powers for the federal government, and everything else devolves to the state. Interestingly, I was at the Council of State meeting today, and the president alluded to something akin to that when we talked about the pandemic and COVID-19, and the president was very clear, that a lot of these responsibilities actually rest upon the states because they govern their states. But unfortunately, Nigerians, very broad strokes, are just federal government, and everything is federal government, and federal government becomes too top heavy, or rather, the country becomes too top heavy, and it makes it very difficult for you to determine, okay, who's responsible for this, who's responsible. Now, the Constitution, it's not a perfect document. There is no perfect document. The Constitution can be made even more perfect by delineating this thing clearly for those who govern and those who are governed to know whose responsibility, what belongs to the state, what belongs to the local government, and what belongs to the federal. Right now, the local governments are moribund, more or less. And if we're going to scrap them, let's scrap them. Some people believe in 2 tiers of government. Some people believe in three tiers of government. So it's for us to come together and determine what form of federalism or federal structure do we want to operate. Do we want to operate a vertical two level structure, or a 3-level vertical structure in government? I mean, we have to look at it within the ambits of our own country. But the goal must always, at all times, be to unite to the unity of our government. That's what I subscribe to. I know there's a reason why we're brought together. With some people, they believe that we're different ethnic nations, but I believe God in His infinite wisdom knows exactly why He brought us together as one country, and I think we haven't tapped into that into that yet. So for me, constitutional amendment, electoral reform, which is also going to be something that's going to be on the table as soon as we get back. Electoral reform, which is very key and very fundamental, because if you don't have electoral reform, nothing is gonna stand. But let me say this: when we talk about the state of the nation, we're talking about the state of the nation in almost in a vacuum. What makes a nation? You have to ask. We'll have to ask ourselves: what is the state of the people? What is the state? When we talk about the state of the nation, everybody points out the government, and I totally agree with that. The buck stops at our desk. But the question is that you cannot have the state of the nation the way we want it if the governed themselves do not play a role. We talked about COVID. I listened very attentively to the vice president, and he touched upon it. The government is doing whatever it can, and these are the questions we're hearing from you now. What is the government doing? What is the government doing? And the government is doing whatever. The question is this, and perhaps sometimes even more important than what the government is doing: what are the people doing? So there's some things you just cannot legislate. What are the people doing? You go out there, you see people banding together, like it never even existed. People are not wearing masks. I was in the streets yesterday, and I was shocked to my bone marrow. People were not wearing face masks. People were banding together like They never heard there was some disease out there. So how do you, so my point is that both the government and the government have a role to play. They complement each other, but the government can only do so much. The relationship has to be symbiotic for everybody to feed off of each other. Let the government know what it's supposed to do. Let the government know and listen to directives as put out there by the government. So there's the issues abound. There's so much we need to do. We're a country of almost 200 people. That's a very difficult number to manage. But if all hands are on deck, we'll complement our efforts. And going back to your earlier question and your allusion to NDDC, sometimes I read reports, I read the social media, I read reports from the people of Nigeria, and I wonder, you leave the main issue and you start chasing shadows. Now it's about the National Assembly and whether contracts were given or contracts were not given. But what was the issue in the first place? I mean, it's a clever way of distracting from the main issue, which is how is the NDDC run? Is there corruption in the NDDC? Are we getting good value for the money that comes into NDDC? For me, those are the main issues. Everything else and anything else is tangential. And so I'll leave it at that and wait for the next question.
Thank you very much, and thank you, the Right Honorable Femi Gbajagbiamila. Now it's a privilege again to have the Vice President of the Federal Republic of Nigeria. You are the chairman of the National Economic Council. And the pandemic, which is the state of the world now, has hit many economies. In the UK, it's a contraction of about 20% to GDP. In the US, at the point, it was 40%. In South Africa, the Parliament or the Central Bank governor announced today that there will be a 40% hit to the GDP. And Nigeria only had 6%. Will you say we have gone through the worst and that we should expect better? And after that, I will deal with the questions of governance. Mr. VP, thank you so much.
Thank you very much again, Nduka. And let me say first that, of course, in comparison to other economies, we have fared somewhat better in terms of the contraction to GDP. Just as you pointed out, several of the comparator countries or the countries that we compare ourselves to have, in terms of contraction, been much worse than we have. And so there's a sense in which we can feel happy, a bit happier with ourselves, I suppose. But again, we mustn't forget that economies like politics is local. So you have to concern yourself with your own problems and with your own issues. I mean, well, while it's helpful for us to say, well, in the UK, contraction was minus 20% of GDP, in France, minus 14, in Germany, minus 10, in Israel, minus 29, South Africa is even projected to be between 20 and 50%. Well, we can say so. And Nigeria is only minus 6%. The truth and the reality is what the people feel. Obviously today, there is a considerable anxiety. There's an economic decline of the sort that affects everyone. It affects services. It affects even lawyers. I mean, lawyers will tell you that they are going through very difficult times, let alone other people in different services and all that. So the truth of the matter is that our contraction of minus 6% is good, it's better than others, but it is still only part of the story. The real story, of course, is that we are experiencing a severe economic decline. We're experiencing a severe decline in domestic resources, in tax, etc. We're experiencing a severe decline in employment. So there are many, many job losses. So our response to that is really what I think is important. And that is, first, we are concerned with saving jobs, and we're concerned with creating other jobs. And the way we've chosen to go about this, and especially as part of the economic sustainability plan, is by ensuring or by insisting in the plan that we will focus on local industry, local production, using local resources. So for example, our mass agricultural program is one that we expect will bring in loads of jobs. We're looking at, in every state, bringing between 30 and 100,000 hectares of land under cultivation. And we're bringing in that many new farmers. As a matter of fact, as of today, we've registered over 5 million farmers, and we have actually attached them to their land. So we have GIS that shows who the farmer is, where his land is. And what we're doing also is that these farmers, these small farmers, are now aggregated under some of our partners who are more like anchors. So we have partners, huge partners like Bobangona, like Thrive Agric, like Thrive Agric, who are big partners like Olam, who already have big farms. Now, these big farm owners are already established, and what they do is that they act as anchors to the small farmers. So to some extent, they guarantee that the small farmers will produce and they will offtake what the small farmers produce. And we have quite a few of these huge farmers who are taking on the smaller farmers. And government then becomes the off-taker of last resort, or the purchaser of last resort. So in the event that some of this produce cannot be bought, government will buy. This is just to ensure that production continues, to ensure that the agricultural sector is well resourced. We're also, of course, concerned with losses, with losses in the cause of, especially in the value chain, all sorts of severe losses, as you know. Sometimes we lose up to 40% of production in the farms. So we're trying to ameliorate that as well as we look at the entire value chain. So we're concerned also with ensuring that the value chain is much stronger, so that jobs are created all along the line. Agri-production is a serious part of the work that we're trying to do. That is for agriculture. Then we have mass housing. This again focuses on local materials. We're looking at about 300,000 housing units, low-cost housing units. And we're thinking, and today we already have a plan, we already have a design that will be able to bring in a small 2-bedroom apartment for 2 million naira, or under 2 million naira. As a matter of fact, we're looking at between 1.8 million and 2 million naira. Now, how do we intend to do this? First is by ensuring that as much as possible, we use local materials and local resources. So doors, nails, window frames, etc., we will source locally. Of course, blocks and all of that will source locally. We have cement, all of those will be sourced locally. Each site would have, as it were, its own systems production unit, where people are making blocks, those who are making doors, making window frames, etc. We'll provide facilities in some cases for the production of some of these things. And our Family Homes Fund, as well as the Ministry of Housing, is actively engaged in doing this. We already have 11 states that have given up land for this purpose, and we're looking at getting more land from each of the individual states in order to be able to do this. But what I want to emphasize is that this is about local production. It is about local resources. That the contractors who will be building the land will be small businesses, that will register on, online in the different states. So these small businesses, these small building construction companies, not the huge ones, will be the ones who will be taking batches of houses and build, batches of houses across the country, so that we can actively engage young engineers, young surveyors, young builders, etc., who at this point may be out of work. Then we have a solar home system as well, solar home systems project as well. As you know, with the support of the World Bank, we are putting in 5 million homes, solar home systems in 5 million homes. Now that means a huge number of jobs. First, in the assembly of the home systems locally, before we begin any sort of manufacturing, we don't have that capacity yet. And then in the installation and in the running of the payment systems of these solar home systems as well. Well, so we think that this will also create an immense amount of jobs. So really, I think that our response to the pandemic is one that's, I believe, is robust. As you know, we're putting 2.3 million in terms of a stimulus package. And just to understand this 2.3 million, it's not all cash. It's not as if all of that cash is available. About 1.2 trillion of it is in the form of loans and facilities supported by the CBN to be given, for example, for the solar home systems project, for the housing project, for the agriculture project as well. These are loans directly to farmers, loans directly to manufacturers, and to provide offtake facilities as well. So here, I think our response is robust. We need to move quickly. We need speed. And I think that with what we have in place, we really can respond in the best possible way to this and not think that our circumstances are much better than other countries. As a matter of fact, we are in relatively dire straits, and I think that we must respond in that way. Thank you.
Thank you so much, Mr. Vice President. Just to dig a bit deeper, your government came with the mantra of corruption, fighting corruption. Why do you find it so difficult to fire or sack apparently corrupt ministers? And Mr. Vice President, can you carry out a forensic audit without forensic auditors?
Well, I'm not entirely certain what your last comment means. I'd like to understand it before.
No, the last question, you say you are doing an audit of NDDC.
Oh, I see.
Forensic audit. So can you have a forensic audit with no known forensic auditor?
Well, just yesterday, let me start with that question. Just yesterday, the Federal Executive Council approved forensic auditors led by Ernst & Young. Ernst & Young, as you know, is an international firm of auditors. And the auditors are led by Ernst & Young. There's a fairly long list of auditors that were recommended by the Auditor General, which, as I'm sure you know, is the law. When you want to audit a federal government enterprise, it is the Auditor General that makes the recommendation of who the auditors will be. Then it goes through the Bureau of Public Procurements and all that. But I can tell you today that as of yesterday, a team of auditors led by Ernst & Young will be auditing the NDDC. So that I think is the answer to that. The other question that you asked is one that I am not certain what sort of facts you have, but if you say that a person is apparently corrupt, I think that concrete allegations have to be made. Those allegations have to be investigated. So far, I'm sure you are aware, we've had several individuals within our government against whom allegations have been made. Those allegations were investigated, and in many cases, those who were accused were suspended while the investigations were going on. And then government resolved the issue one way or the other. I'm sure you're aware of the Secretary to Government of the former Secretary to Government of the Federation, the former DG of the NIA, and others such as that. So I don't think that there is any reticence in terms of reacting to allegations of corruption. I think that those allegations have to be properly investigated. There has to be fair hearing, and steps then have to be taken. So I don't think that our record so far shows any reticence on our part or reluctance on our part to live up to our own to live up to our own stated aspirations and stated objectives as a government.
Thank you, Mr. Vice President. Before I come to Femi, just one last question. You have been a professor of law. Now you have been a student of governance under the President Muhammad Buhari. At the end of his tenure in 2023, will you say you have been a good student to rise to lead the leadership of Nigeria?
Well, Nduka, let me just say that question appears to me to be loaded. And I'm not going to take the bait. Frankly, let me say to you that one learns every day. And I am learning every day, and I pray that God helping us, by 2023, I would have learned a great deal. But I will not, of course, as you know, today I'm completely focused on what it is that we're confronted with. We're confronted, as the Right Honorable Speaker has said, with possibly the gravest pandemic, the greatest public health crisis of our generation, and possibly the greatest economic decline, global economic decline of our generation. So we are challenged by these very significant issues, and we are in some senses privileged. And at the same time, we must approach it with a great deal of humility. We are privileged to be in service at this time, to be called upon to resolve some of these great issues. So that is where my focus is today, how I will learn, what I will learn. Of course, the coming years will be the only judge of that. Thank you very much.
Thank you very much. The Right Honorable Femi Gbajabiamila. The fight against Boko Haram, or the fight by the armed forces, is not as impactful because they have not been given the right resources. If you look at your budget, will you truly say you have brought or appropriated enough money to the armed forces to fight insecurity, or to the police to fight banditry, when the world is currently governed by technology? What are you doing to resource our security agencies?
Okay, sorry, I lost you for a minute. Yeah, thank you, Nduka. Yes, once again, a good question, very deep question. The issue of security is perhaps the most important leg of what is of the three legs upon which this government came into power. And if you look at it from the time the Buhari-led government came into power till date, a lot has been done, particularly in the Northeast. Now, that is not to say that it's Uhuru. No, it's not. There's so much more to be done, so much more. And funding, like you rightly observed, is perhaps one of the greatest drawbacks that we have. Why is that so? You can only spend what you have. And within the limited resources, dwindling all revenue and the rest of it, what is budgeted for, or what is budgeted from the executive is hardly ever touched by the National Assembly in trying to rearrange distribution of resources. The defense budget remains almost sacrosanct anytime it comes to the National Assembly. But what we're looking at now, and what I think needs to be done, and I think this is what is done in times of war in even more advanced democracies, is that you look beyond and outside your budget and your revenue, and you look for alternative sources of revenue to fight your war. If we agree that we're in war times, then we need to look outside the box if we do not have enough resources. And I think there's a bill right now on the floor of the House. I think it's first reading in terms of alternate funding for our military. I believe that will get speedy passage through the House and the Senate, and go to the president for assent. Yeah, for assent. And I totally agree with you. Funding remains very key. We are in an IT world. We need to move from the bricks and mortars and bow and arrow conventional warfare to IT, technologically driven equipment and warfare, and that's what we need to fight Boko Haram. Boko Haram is an unusual organization. I mean, it's like the more you look, the less you see. The only way you can fight them, in terms of because they're even a more advanced guerrilla warfare. The only way you can fight them is through technology, and technology is very expensive. And we need to look at foreign aid. We also need to look at the issue of there's the Leahy Act in America and some other legislation in the United States that actually makes it difficult for us to actually get arms from the United States and some other advanced democracies. Some pin it on our human rights abuse, but I think it's something we perhaps through the back channel, the legislative arm of Nigeria and the legislative arm of the Congress of the United States need to talk about in terms of either exempting Nigeria from this Leahy Act, which stops them from working with us in terms of purchasing of arms, and that's what we're looking into. If our human rights abuse record, quote and unquote, I do not believe rises to the level where we should be affected by the Leahy Act. But these are areas that we'll look into. We cannot successfully fight Boko Haram, and I'll be the first to say so, if we do not equip our military, if we do not boost their morale, and if we not do what is supposed to be done for men and women who stake their lives every day, who put their boots on ground, and sometimes pay the ultimate sacrifice just to protect you and I. I think it's very important. I think it should be priority because if you don't have it, it's only a secure nation that can thrive economically, politically, socially. So I totally agree with you. And these are the things we're doing. Perhaps most importantly, the new bill that is just going through the first reading in the House of Representatives to find alternative means of funding. I said earlier that the Police Reform Act has already just left the National Assembly, and in that act is embedded resources and distribution and emoluments for the police, men and women in uniform, to enhance their pay and their conditions of service.
Sorry, just a quick question on your Police Reform Act. Does your Police Reform Act have provisions for regional security outfits to be armed so they can help the police?
Well, for us, the policing is right now disconnected from the people. There's a structural disconnection. So much so that the Nigerian police force is now almost like an occupying army in many places across the country. So we have started experimenting already with what you call community policing. But two things are already missing from that effort, and that is accountability and partnership with the community itself. So to have regional police, as you put it, I personally believe you will need a constitutional amendment because that goes to the very structure. You will need a constitutional amendment, and the process of constitutional amendment is totally different from the Police Reform Act, which just passed the House and the Senate. So what we did was a shortcut to recognize community policing, and perhaps we will escalate it when we start on our constitutional amendment next month, and then that will involve everybody. It will involve public hearings. It will involve the people. It will involve states. It will involve governors. It will involve emirs. It will involve obas. It will involve a constitutional amendment, which will involve all stakeholders in Nigeria.
Thank you very much. Thank you. Mr. Vice President, there are two issues that should interest you. One is the new law called KAMA, which requires maybe churches, if they fall foul of the law, to be taken over, is it by trusteeship? And then there's the issue of the killings in Southern Kaduna. As Vice President, what's your take on those two issues?
Okay. Let me just, in order of importance, because of the, in my view, because of the fact that lives are involved, you know, I want to say that the mindless, callous killings in Southern Kaduna are heartbreaking. And again, we must condole those who have lost loved ones and those injured or who have suffered loss of property. Now, these tragedies are completely unacceptable and they are avoidable. I've been involved since about 2001 through the work of the Macedonian Initiative, an NGO that focused on relief materials, giving relief materials to displaced persons, you know, since 2001 in Southern Kaduna and several other places, especially in the north central part of Nigeria. But the deadly violence in Southern Kaduna has continued over the years. You know, there have been judicial commissions, etc., you know, all sorts, but the problem remains. So there is a need to address the underlying issues. There's a need to address those. I'll come to that in a moment. But what are we doing? What is the government doing? First, is the improvement of security in Southern Kaduna. Now we have a military base there for the first time. We now have a military base. We also have a lot of Air Force surveillance. We have about 500 conventional and mobile policemen in Zagun, Kataf, and Kawara local government. And then the combined military teams from the Army, the Navy, who are also on ground 24 hours. That's basically to just take care of the volatile situation there. The president has also had several Security Council meetings. I've attended all of those where the issues have been discussed. And you know, the possibilities of engagement have also been discussed. I've also engaged with community leaders in Southern Kaduna and also have engaged with the governor to look at what peacemaking efforts are possible. What can we do to ensure that these killings and this disgraceful human condition there is dealt with? And you know, some of the peacemaking efforts have been fairly successful. Recently, I'm sure you've heard of the rapprochement between the Dagon Kataf community and the Hausa Fulani community. And we hope that that will develop into something that not only will be permanent, but will be a template for making peace in the future. But I think we must address also the fundamental issues. We can't sweep those issues under the carpet. Justice, you know, the cries of economic marginalization, the fact that we must prosecute persons responsible for these murders, otherwise the impunity will worsen, and also support to those who have lost their properties and breadwinners. I think some of these issues must also be addressed as we go forward. And what we've been trying to do, the president, of course, has taken several steps aside from the engagements with the governor and also with the communities there. We're also working, you know, and of course one cannot disclose all of what is going on for reasons of confidentiality and security. But there's also a lot of work going on to ensure that some of these fundamental issues are addressed. And it's an evolving situation. But it's something we simply cannot afford to ignore. It is, and it's gone on for far too long in my view. And it is redressable, it is possible for us to resolve this issue. That is on the Southern Kaduna issue. The other point you made, the other question you asked was with respect to KAMA, which is the Company and Allied Matters Act. Let me say first that, as you know, the Companies and Allied Matters Act is a very huge legislation, has over 800 70 sections or so. There's a massive legislation that covers a wide range of issues of companies, all sorts of issues on companies, general meetings, appointment of directors, etc. Now, there's a small portion of it called the Incorporated Trustees section. That small section of it is the section that regulates charities. Now, churches and mosques and such organizations are regarded as charities. So it is the Incorporated Trustees section of the Companies and Allied Matters Act that has become controversial. And because churches are charities, the provisions in the Incorporated Trustees Act obviously affect the churches. Now, what the churches are concerned about is a provision that says, I think there are about 2 or 3 provisions, but the main one is the one that says that in the event that some wrongdoing is found by or perpetrated by the trustees of the particular organization or church, the Registrar General can go to court, get an order to appoint interim administrators or interim trustees for the church or for whichever organization, whichever charity that may be, and then, as it were, manage the affairs of such a trust. Now, the concern of the churches is that it could lead to a situation where practically anybody could be appointed as a trustee to oversee a church, and a church obviously, or a mosque or a religious organization is obviously a spiritual organization. And if you are not, if you do not belong, if you don't share that faith, or you simply do not even have any faith at all, you may be the wrong person, and the wrong person may be appointed and create more trouble than was initially the matter before the trustees were appointed. Now, my view, what I have also suggested to several of the groups that I've spoken to and the leaderships that I've spoken to, is that we have a process by which this can be redressed. The Right Honorable Speaker of the Assembly is here. The Right Honorable Speaker of the House of Representatives is here. We have the President of the Senate, and we also have the President. What can be done is that whatever the proposals for amendment may be, whatever the views of the church leadership may be regarding the question of how the trustees and where there are interim trustees or whatever can be managed, that should be put into proposals that can be brought before the National Assembly, before the National Assembly leadership, for a consideration of amendments to the law. That is a process which is entirely open. And I believe that that's a process that ought to be pursued. Where citizens or groups have concerns, where they have serious concerns, we are in a democracy. There's a process by which this can be done. And that process is one where we bring forward amendments to the National Assembly. And the National Assembly, I'm sure, will do whatever is considered needful in the circumstances. So this is my position. I think that yes, the controversy is one that has generated a lot of fervor, but the solution to me seems also to be quite evident. Thank you.
Well, thank you, Mr. Vice President. We just have about 2 or 3 minutes, but just to dig deeper, yes, an amendment can be made, but why are pastors refusing to be accountable? This same law is on in England. 2 or 3 Nigerian churches have been indicted in that process. So are pastors afraid of accountability? That's one. And the final question to the Vice President, so that you can wrap up, is what do you see Nigeria becoming over the next 5 years, given where you sit, and what's your prognosis for the future?
Okay, thank you very much. First, let me say that as a general position, I do not think it is right to say that pastors do not want to be accountable. As a matter of fact, as you know, I'm a pastor. So I know that that question is also partly directed to me. But I must say that is not the case. I believe that several Christian organizations and pastors are willing to be accountable. But I think that the problems that they may have are with ensuring that processes are not abused in such a way as to compromise the entire organization. And I think that if all that is required is some process of accountability, I think it would be easier for organizations to accept that. Or where there might be a takeover of the management of the organization, I think that they may, I think the fears, there may be fears as to whether such could be abused. And really what needs to be done then is to put in place checks and balances to ensure that there is no abuse in the event that such provisions are activated in any way, or even to modify those provisions to allay everybody's fears. But I don't think that is a matter of pastors being fearful of accountability. I think that all of us are subject to law, and we must accept that the laws of Nigeria govern all of us, and we have no choice but to submit to those laws. But fortunately, we're in a democracy, so that we can also advance our own views and opinions, even after the law has been passed for possible amendments. So where do I see Nigeria in the next 5 years? I must say that we've seen all of the challenges. We know that in the next 5 years, our population is going to increase. The number of young people looking for jobs will increase. There will be greater pressure on our resources. But I also strongly believe that we are in the best possible time in our history. We're in the best possible time in terms of the opportunities that are available. And we must make those opportunities available. First, as government, it is our role, and I think the government's role is particularly important. As government, it is our role to create the enabling environment for business to thrive and to prosper. And that means ensuring that we remove whatever the hindrances are to doing business in Nigeria. Some of those encumbrances, for instance, tax. We've done quite a bit with tax. If your turnover is less than 25 million a year as a company, it's a zero tax policy. If you are between 25 million and 100 million, you are paying 20% tax, 10% less than it was before. So we need to clean up the tax environment. We need to ensure that multiple taxation does not occur. For example, just here in Abuja, I know that the Minister of the Federal Capital Territory has been working very hard, alongside all of us, in ensuring that those who do business here are not exposed to multiple taxation and all sorts of other hindrances that are put in people's way. We've been working with NAFTA. NAFDAC is an organization that registers products, but sometimes it takes too long to register a product. So I want to put my product on the market, because obviously several people all over the country are bringing forward their products. It can take forever and a day to be able to register a product. Now, if I don't register my product, I can't sell my product in the supermarkets. So products that are coming in from Ghana, products coming in from elsewhere in the world that have already been registered in their own countries are on our shelves in our supermarkets, where our own manufacturers are having difficulties. So we're tackling this with NAFTA. Obviously, they have their constraints, and we're trying to resolve those constraints as we move forward. So we want to be a manufacturing hub for the rest of Africa. We've signed on to the AfCFTA, the free trade agreement. We've signed on to that. So we want to be the hub, and we can be the hub of manufacturing. We can be the hub of agriculture. We have the men, we have the resources, we have the land. So that is one. We can also be the technology hub of Africa, and indeed for many parts of the world. Microsoft has already announced that it will be setting up its facility here, its Africa facility here. Several countries are interested in technology and the potential. Now, on our part as a government, we're also working hard to ensure that we do not overregulate that space. So fintech companies, for instance, we're ensuring that the central bank doesn't overregulate them, allows them to perform, allows them, to blossom. And the same thing we're trying to do with the creation of hubs, with the support for technology. Just about a couple of weeks ago, the Ministry of Youth and Sports got a 75 billion youth fund. Now that youth fund, a substantial amount of it will be devoted to technology. We believe that we can be the technology hub of Nigeria. Frankly, I am convinced that we have everything it takes to be the kind of country that we all dream of. But we have our constraints, and we're Nigerians. We know what our constraints are. Petty corruption, grand corruption. Everybody standing in the way, trying to put a toll gate in your way to prevent or to take something off you before you're able to do anything. But we can resolve those issues. With more technology, it can become easier for us to get passports using technology, and which is what we're investing in. We're investing a great deal more in technology so that there is no human interference in doing a lot of what you want to do. So you don't pay, you don't have to go and see someone before you can get a passport. You don't see someone before you can get a license or any kinds of approvals. The more technology we introduce, the easier it is for people to do their business without the obstacles that are all over the place. And finally, I think that one of the critical problems, one of the critical issues for us is infrastructure. This government has devoted tremendous resources to infrastructure. The railway, for example, was the railway from Lagos to Kano, starting from the Apapa port, in order to be able to clear the Apapa port so that we can move goods out of Lagos. And the busiest port is Lagos. The roads, the Lagos-Ibadan Expressway, etc., and several other roads, Abuja, Kaduna, so many of the different Abuja, Kano, and so many of the different road networks across the country. We've been lucky that we've had the National Assembly supporting in ensuring that this infrastructure is built. We need infrastructure, we need to build infrastructure, but we need to fund infrastructure also, and we don't have the resources, which is why we're doing so many different things. Of course, we're lending money, and we're putting our money in infrastructure. If you lend money, if you put it in infrastructure, that is profitable because it means that your business environment is improved. So I see a great Nigeria. I think that we have more than the potential to go where we please, and we mustn't in any way allow people to talk this country down. We can't allow that, because if we do, this will be the biggest drawback for us. So I believe very strongly that our country can be great and will be great. And I see that in the next 5 years, despite the challenges we see today, the future is certainly very, very bright. Thank you.
Thank you so much, Mr. Vice President. Just a quick question for Femi Gbejamiamila. You say that there will be electoral reform that will guarantee free and fair vote, and the last word for the NBA. Thank you.
Well, yes, thank you, Munduka. Definitely, you can take that to the bank. There will be electoral reform. We do need electoral reform, not because we want to, we must have it. It is upon that everything else can rest. For the NBA, I say, once again, congratulations, and I wish you all the best, the new ESCO and the new president in all your endeavors. If I may just piggyback on what the VP said about where do we want Nigeria to be, I think he has covered the whole gamut. But let me just speak in broad strokes and in general terms. We have a national anthem that speaks to one nation bound in freedom, peace and unity, where justice shall reign. This is the vision that we believe that we should all commit to. A country where power is exercised with accountability. That's what I see, that's what I want, and that's what I hope Nigeria will become. Where today's glaring inequalities are just a footnote, or at best historical anecdotes for the future. So it's important that we all, again, I keep stressing this, that we all put our hands together. I don't think you can show me a country where that has a country that has a combination of a population of 200 million, intellectual prowess, and material resources like we have in Nigeria. I don't know that there is one. So it's not that Nigeria will be great or can be great. I believe that Nigeria is great. But unfortunately, I think we have not tapped into its greatness. Our multicultural, our multi-religious, our multi-ethnic makeup should be our strength. And other countries wish they had it. But we have it and we're not using it to our best advantage. I say country, and I hope for a country where we can bridge the gap between the rich and the poor. There's no country that does not have class structure, rich and poor. What makes Nigeria different, and unfortunately so, is that that gap is so wide, and there's no middle class, so to speak. So I look for a country where that gap can be closed, and everybody will be everybody's keeper. Every child will have the same right as the other child. Equal opportunity for every single one, and this is the kind of things that we hope for. These are aspirations. These I believe that we can achieve. But Nigeria is so blessed. All over the world, you hear of feats. I want a situation where you go to Nigeria and or you are somewhere in the world, and right now, if something terrible happens, I mean, we've heard about hush puppy. Somebody will say, "Oh, you must be a Nigerian," just because they've ascribed that nefarious activity to you. No, what we want is a situation where you'll achieve a feat and somebody will say out there, will say, "Oh, you must be a Nigerian." And that can be done. We just need to hunker down, put our heads, our hands, our minds and everything together and achieve the greatness, the greatness, the potential greatness that God has given us. And thank you once again for inviting me to this conference.
Thank you so very much, the Honorable Femi Gbajabiamila. Thank you so much for the privilege of having the Vice President of the Federal Republic of Nigeria. Thank you, NBA. Just my footnote is the NBA should remain a champion of free speech. No matter how you are uncomfortable with anybody's opinion, whether it's a governor or otherwise, you must give everybody free speech. Thank you very much. It's been a pleasure.
Thank you.
Day, and that's a symposium on the rule of law, a grand symposium featuring global perspectives on the rule of law. Today's panelists are Brian Spears, President of the Commonwealth Lawyers Association, Professor Patrick Lumumba, founder PLO Lumumba Foundation. We also have on the panel Mr. Henry Odeyin Ajumogobia, Senior Advocate of Nigeria and former Minister of Foreign Affairs and State for Petroleum Resources and founding partner Ajumogobia and Okeke. Moderator for this event is Professor Ayodele Asenua, Dean, Faculty of Law, University of Lagos. She's right here on the stage. Over to you, Professor.
Thank you very much. Welcome to the NBA Symposium on the Rule of Law. My name is Ayodele Asenua, as I have been introduced, and I have the honor of moderating this session. And I have with me a stellar panel that certainly will do justice to the discourse of the rule of law. I dare say that what we are focused on during this symposium is really at the heart of the NBA, with the motto of the NBA itself being the rule of law, about the rule of law. So it's like asking the question again, what exactly is it that we're about? Are we getting it right? Do we understand it in the current context? Is it responding to the aspirations of the now? Is it being reshaped? How is it being reshaped? And these are the questions that the panelists who are here with me will be trying to answer. What is the rule of law? In its original formulation, we thought it was all about limiting government in terms of like the rights of the individual, but it's evolving. It's evolving in such a way that we begin to talk about the rule of law and economic development. Today, we begin to talk about COVID and the rule of law. So many things. I dare say that the panel that we have today are more than well suited to address the multiple dimensions. Do we need reforms? If we need reforms, what kind of reforms do we need? These are the issues that we will be looking at this afternoon. And I have the pleasure to introduce those who are on the panel for this afternoon's symposium. We are all set to go. We have Mr. Brian Spears, who is the president of the Commonwealth Lawyers Association. Mr. Spears, before his appointment in 2019 as the president of the association, had spent many years in the executive committee as well as the council of the association. He has traversed the world focusing on the issues of rule of law. As I searched in preparation for this symposium, I realized that only as recently as July, there was a seminar on the impact of COVID and the rule of law. The average lawyer who flashes their mind back to what they know or what they first of all knew about rule of law will possibly imagine, we all know the rule of law. What more can we learn about the rule of law? Mr. Spears will be here sharing with us. Is there anything evolving? Are there any changes? Do we have contextual understanding of the rule of law so that he will be able to share with us from the experiences in various other jurisdictions? We also have with us today Mr. Odein Ajumogobia, Senior Advocate of Nigeria, who is the founding partner, one of the founding partners of Ajumogobia and Okeke. Mr. Ajumogobia has been a minister in the Federal Republic of the Nigeria. First, he was Minister of State for Petroleum Resources, and then he was Minister for Foreign Affairs. Clearly, when we talk about rule of law, there's an international law dimension to it. And I am sure that Mr. Ajumogobia will be drawing on his experience as a former minister, how rule of law played out at that level, and the interpenetration of international law and into domestic law, just as he has indicated that he will also be very glad to speak, focusing significantly on the intersections, the linkages between the rule of law and economic growth, economic development. Professor Patrick Lumumba. Professor Patrick Lumumba is the director of the Kenyan School of Laws. He was one time the Czar of the Anti-Corruption Commission in Kenya, and he is the founder and the executive director of the PLO Foundation. I guess everybody knows Professor Lumumba because he is renowned for speaking truth to power. And if you Google him online, you will see that he has been able to advance scholarship that is designed to change how we think, the questions we ask on the African continent. We have a fourth speaker, one that is very dear to me, someone that we all probably know. If you didn't know her by name or if you didn't know her by face, you definitely know her by name. And that is Mrs. Aisha Oyebode. Mrs. Aisha Oyebode she is a lawyer. She is also a development practitioner and a social activist. And I did say that if you didn't know her otherwise, you definitely would have known her by name. That is because she is the co-convener of the Bring Back Our Girls movement. And she has been on the front lines with regards to this for many years. She has indicated that she has some thoughts on how we ought to be thinking when we're talking about the rule of law. How do we measure the rule of law? what indices should we be looking at when we want to measure the rule of law? What frameworks have been advanced hitherto? And what do they contribute to how lawyers should be thinking about the rule of law? So once again, I say a very big welcome to you to this symposium on the rule of law. And we will go this way. We will have our speakers speak to us for about 10, 15 minutes each, and then we will open the floor for discussions. I'd like to invite you to please drop the questions in the question and answer box. I have my own questions for the speakers, but we would like to make this as interactive as possible. So I hope your questions will overwhelm the box and I will not need to recurse to my questions. Thank you very much. So without much ado, I am only supposed to be a moderator. I'm not supposed to take over the speaking. Let me invite the very first speaker, and that will be Mr. Brian Spears. Mr. Brian Spears, what do you have to tell us about the rule of law? You've traversed the world.
Well,
you have 15 minutes.
A great pleasure to be here. And can I first of all congratulate the Nigerian Bar Association on a really brilliant event held virtually. I really wish that I had the opportunity of being there in person. One of my predecessors attended the NBA conference and spoke of over 10,000 lawyers in attendance. So I have been watching proceedings from my office in Belfast, Northern Ireland, and have been hugely impressed. Congratulations to the NBA. Can I also commend the theme of your conference, Stepping Forward, from what I have observed, and to borrow from the moon landing, this hasn't just been a step forward, it's been a giant leap forward in my understanding of events in your jurisdiction, but also we have learned of their applicability to many others. I must confess to being slightly apprehensive at present because I have listened to amazing contributions from very senior figures and I'm on a panel with what I absolutely know to be amazing contributors. So I hope my contribution, based upon some of my experiences as president of the Commonwealth Lawyers Association, will help. I always feel in my work as a commercial mediator that it's good to get to know who you're dealing with or who is speaking. So I come from Belfast in Northern Ireland, which is one of the 4 countries that make up the United Kingdom. But I wouldn't want to be tarred with everything that is English or British. We have a distinct identity of our own in Northern Ireland. It is the home of C.S. Lewis, the author of the Narnia books and Lion, the Witch and the Wardrobe that some of you will be familiar with. It is the location of many of the scenes in Game of Thrones that some of you will have seen and not all of you will have realized was filmed in Northern Ireland. And until recently, we had the #1 golfer in the world, Rory McIlroy. And some of you who are at least my age will recall the best footballer in the world, a certain George Best. Northern Ireland for 30 years experienced what we call the Troubles, where we had a period of social and political unrest and disruption, bombings, shootings, property and lives lost. And then we had a resolution achieved by what we call our peace process. During the Troubles, we had our own rule of law issues. There was, for example, internment without trial. There was diplock courts where criminal trials were held without juries. And there was a spate of what were called supergrass trials, where people gave evidence who had been involved in the criminal gangs and were then giving evidence. And all of those brought about a whole host of rule of law issues. And that, if I can say, is part of the UK. No country is immune from rule of law challenges. Today, I'm speaking to you wearing the hat of President of the Commonwealth Lawyers Association, an organization of practitioners sharing a commonality of language and law across the Commonwealth. And the CLA is pledged to uphold the rule of law and has undertaken a number of projects, including, as Mrs. Oyebode might be interested in, a survey of the laws across the Commonwealth on child marriage. We are about to start a project on Indigenous land rights. And I was taken by the comments made by your president in his remarks read on your opening day, where he referenced the scourge of gender violence, which of course feeds into our child marriage project. The CLA, and it's relevant to my remarks on the topic in question, also was a participating entity for creating the Latimer House Principles and the Commonwealth Principles on Freedom of Expression. We have 4 regions, and the Vice President for our Africa region is Linda Kasonde from Zambia. And Nigerian lawyers have been great supporters of our CLA conferences over the years. Were present in our last conference in Zambia in April 2019. And we hope that numbers of you will attend our next conference, COVID permitting, in the Bahamas in September 2021 on the theme of sustainable justice. Not only have Nigerian lawyers attended our conferences, but in Boma Alabi, one of your contributors at a session that's just finished, we had a former president of the CLA, and our council member from Nigeria is Mia Essien, who will be well known to many of you and has been a contributor to your conference. Indeed, a couple of weeks ago, Mia and I were part of a panel considering COVID and arbitration practice run by the Port Harcourt chapter of the Chartered Institute of Arbitrators. While humanity has shown to be connected and unified in its exposure to COVID, and the universal language of distancing, hand sanitizing, lockdown, working from home, furlough, clusters of infection has been part of our common vocabulary. There are rule of law issues arising from COVID that I hope this panel will have the chance to discuss. The CLA is very concerned that the rule of law is upheld even in, and perhaps especially in, times of emergency. We have a concern that laws passed to deal with an emergency become fixed rather than the temporary position. It's what I might call normalizing an emergency. We should not allow emergency laws to become part of our day-to-day arrangements. So turning to the structure of this session, what is the nature of the rule of law? And the World Justice Report identifies 4 elements. Governments and citizens are accountable. Laws are clear and applied evenly to protect human rights. The process by which laws are enacted and administered and enforced is accessible and fair and efficient. And justice is delivered by a competent and ethical independent representative making up the community it serves. But there is another list found in Lord Bingham's famous work where he described laws needing to be accessible, intelligible, clear, and predictable, legal rights resolved by the application of law and not discretion, the law equally applicable to all, ministers and public officials exercising their authority in accordance with the law and reasonably and not exceeding their powers, protecting fundamental rights, and the state being under an obligation to provide a mechanism for resolving disputes. And the rule of law also requires compliance with international obligations. And just to pause there momentarily, the president's speech read by your vice president mentioned how legal rulings had become over-technical and not blessed with common sense, which seems to me to reflect Lord Bingham's first point about laws being accessible, intelligible, clear and predictable. We all know that no one is above the law. And I was struck by your Chief Justice's remarks about the importance of obedience to court rulings. And I particularly made a note of that to reference in my remarks. If the state has an obligation to provide means of resolving disputes, is that accessible? Is it affordable? Is it without delay? And are there alternatives to a court-based system, such as arbitration and mediation, a topic in which I have a great interest now with enforceable cross-border mediated agreements as a result of the Singapore Convention? Only today we have in the United Kingdom a comment made by our UK government about the role of lawyers in the crisis involving migrants coming across from continental Europe, and they are referred to as delays occasioned by allowing activist lawyers to delay and disrupt the return of migrants. And this has created a great storm, because to refer to lawyers as being activist lawyers, as if somehow that is a problem, was seized upon by the president of the Law Society of England and Wales, who said to describe lawyers upholding the law as activist lawyers is misleading and dangerous. We should be proud we live in a country where legal rights cannot be overridden without due process. And we should be proud to have legal professionals who serve the law. And a former chief prosecutor said, activist lawyers ensure that humans have rights. They ensure our laws are followed. So this business of the rule of law is current, and it requires lawyers to be eternally and regularly vigilant. But it also requires trust between the citizen and the institutions of government. The session requires us also to consider its relationship to development, and the World Justice Project on the Rule of Law mentions very clearly that GDP per capita is higher in those countries which score higher on a rule of law index. The rule of law aids healthcare and inward investment. Infant mortality is lower in countries which score higher on the rule of law index. And economic growth is enhanced where there is a stable government, a stable system for resolving disputes, and a recognition for the rule of law. The session requires us to consider context. And I was struck by listening to the session just recently ended at your conference on what is it to be a Nigerian, that there is a multi-ethnic diaspora, there are traditional and customary laws, the great religious faiths are represented. So are there variations, therefore, in the rule of law? And my conclusion is that there are some immutable, unvaried elements of the rule of law, such as the law applies equally to all, that there is fair process, that government and people making decisions must be held to account, that it does not matter whether the context is the Caribbean or Canada or New Zealand or the United Kingdom or Nigeria, that there are immutable elements to the rule of law. I am intrigued by the next question of public and private. And by public coming from a commercial lawyer practitioner background. The rule of law seemed to me to be always about human rights and judicially reviewing government decision makings. And I've come to realize that that is wrong. The rule of law applies to doing business, to having fair contracts upheld, to having the functions of a transactional legal world fulfilled by the organs of state, a functioning land registry, an efficient company registry, probates being processed, vulnerable people having their rights upheld in courts of protection. So I say that in the private law field, it is interesting that the TikTok representative who are bringing proceedings in America referenced they have no alternative other than to challenge the decision of the executive order in the United States to ensure that the rule of law prevails and that our company and users are treated fairly. So the private application of the rule of law is important. Can politicians be trusted? Well, if they respect the rule of law, if they get its importance for the good of the people, if they get its importance for the economy of the country, then maybe so. But too many politicians see lawyers as being in the way. Too many politicians see lawyers being an inconvenience, and they should be reminded about the Latimer House principles of good governance, which in 2003 were adopted in Abuja by the Commonwealth heads of government. And there, those principles talk about an independent, impartial, honest and competent judiciary is integral to upholding the rule of law, engendering public confidence and dispensing justice. And these principles also say that there should be adequate parliamentary examination of legislation and zero tolerance for corruption. So to sum up my initial remarks, we must appreciate the importance of the rule of law. We must cherish it as citizens, but especially as lawyers. We must recognize that it is not inevitable, and the growth of executive orders and the convenience of avoiding parliamentary scrutiny by declaring emergency means that we must remain and stay vigilant, and that the rule of law is not inevitable. And an independent legal profession is vital to upholding, protecting the rule of law, challenging decisions that are made, and holding everyone to account equally under the law. The opportunity for technology to enhance accessibility and the opportunity for a technology to widen what we understand by access to justice, by using technology for virtual hearings, for appeals, for arbitration and mediation, all excite me enormously. And I hope that those remarks at least set the scene, and I'm very happy to respond to questions from other contributors, but my time is done and I will now stop. Thank you.
At this point, going over Ode Najumogobia, Senior Advocate of Nigeria, to take the conversation from that point forward and let us know, how critical is the rule of law when it comes to economic development and other perspectives that you think is really important for us to get a grip on. Thank you very much. Learned Silk, the floor is open. I think you're muted.
Thank you very much, Professor Enua. It's a pleasure to be part of this panel, join you in this discussion on the rule of law, on the theme stepping forward, or the step forward. It's nice to be celebrating 60 years of the Nigerian Bar Association, and I think it's an appropriate way to do so. As Brian Spears said, the rule of law has traditionally been associated with human rights and the restraint of arbitrary and capricious power. But my remarks, I'm going to concentrate on a broader compass of how the rule of law is essential to growth and development in Nigeria. And when I talk about Nigeria, I think this probably applies across sub-Saharan Africa that have the same development challenges. The United Nations in 2000 instituted the MDG goals as a broad framework for development across the world. They were replaced in 2015 by the Sustainable Development Goals, which sort of broadened the ambit of the MDG goals. It's interesting that neither the MDG goals nor the SDG goals have the rule of law specifically as one of the goals. And I suspect it's as a result of the challenges that I hope we'll be discussing in the course of this symposium. The rule of law is overarching and affects, as we heard just now, everything from healthcare to education to infrastructure. It really covers everything. And I think the focus of my presentation is to highlight how that is to be taken seriously by government. Now, one of the most eloquent descriptions of what I'm about to say was in the General Assembly on the UN, the rule of law of the national and international levels, 2012. And I'll just read it. The advancement of the rule of law at the national and international levels is essential for sustained and inclusive economic growth, sustainable development, the eradication of poverty and hunger, and the full realization of all human rights and fundamental freedoms, which in turn reinforce the rule of law. There's another, the UN Commission on Legal Empowerment of the Poor, its final report stated that the rule of law is not a mere adornment of development. It is a vital source of progress. It creates an environment in which the full spectrum of human creativity can flourish and prosperity can be built. Now, policymakers across the continent have routinely talked about the rule of law and focusing on institutions that promote the rule of law, access to justice. Most ministries of justice in Nigeria now have a Department of Access to Justice to try and support the rule of law. I served briefly in an administration that made the rule of law the fulcrum of its policy formulation. But it's in implementation that we fall short. And I think that's where the challenge is for the developing countries. We understand the importance of the rule of law. I think there are few people who would question the fact that both the rulers and the ruled governed and governors should be subject to law, that the law is supreme. But in practice, the challenges emerge. It's perhaps not self-evident, even if widely assumed, that a failure of the rule of law inevitably leads to the impoverishment of an economy. Why is this? Because the legitimate expectations of honest, hardworking people diminish as a result of arbitrariness and oppression. Incentives for production and enterprise are thus undermined. Now, Nigeria is the largest economy in Africa today, with a population of 200 million people. Its economic prosperity or decline therefore reverberates not just within the ECOWAS region of 15 nations, but across the continent. Now, at the one end of the spectrum of development, we have states that have been classified as failed or fragile states. It's a sad irony that Nigeria, with the largest economy on the continent, by some indices is classified as a fragile state. And this is as a result of the failure in many parts of the country of security, law, and order. I suspect that the classification of the 2019 Fragile States Index and the 2020 Global Conflict Tracker of the US Council on Foreign Relations that ranks 178 countries according to these various indices has listed Nigeria as number 14 or 15 on that list on account of the insecurity challenges that the government faces in many parts of the country. The Boko Haram insurgency in the northeast, banditry in several states, kidnapping for ransom that's prevalent in many parts of the country. All these undermine the basic stability that enables an economy to grow and develop. Today, Nigeria has 2.5 million internally displaced persons, massive refugees moving away from violent areas of violence. And I think this is perhaps the starting point in a discussion on the rule of law in development. Coupled with this, Nigeria's cost of governance is probably one of the highest in the world. Now, as the Vice President said in his remarks yesterday, this presents a huge challenge for development, where you have these huge challenges, infrastructure, a huge infrastructure deficit, insecurity, and a high cost of governance. But it also presents opportunities. And I think that's where this discussion ought to take us. Now, I won't go over the definition of the rule of law, which was very, very succinctly summarized in the previous presentation. But it is really about the ordering of society's relationships, state and citizen, societal relations, the management and regulation of institutions that are charged with the responsibility for ensuring that governance is effective in its goals. Now, what's the link to development? The strict application and enforcement of the rule of law is what enables the environment, and it creates an enabling environment for development to take place. This contrasts with arbitrariness, where laws are not predictable, the outcome of cases are not predictable, the timing, and this goes into an issue that I'm sure will take the floor in the course of this discussion. It all begins with the Constitution of the Federal Republic of Nigeria, 1999, and the body of subordinate laws and regulations. Talking about the Constitution, I mean, one of the challenges we have is the fact that although the preamble of the Constitution begins with a declaration that we, the people of Nigeria, gave ourselves this Constitution, there's still huge controversy more than 20 years after about whether the Constitution serves the goals and aspirations of all the people. And therefore, we must confront, as a first principle, confront the challenge of ensuring allegiance to that supreme and fundamental law. That's really the starting point. And some of the challenges in insecurity that we experience in this country stem from that lack of allegiance to this fundamental law. We have in Nigeria a dichotomy of religion. The Christian South and the Muslim North, that also needs to be addressed in the Constitution. I'll just mention a case to illustrate the point about, and this relates to discrimination against women, which is one of the fulcrums of development covered by both the MDG goals and the SDG goals. Equality of women, which is the fifth goal of the Sustainable Development grounds. Now, the case of Amina Lawal versus the state comes into focus. This was a case which challenged the notion of equality of women. If I can just briefly highlight the facts, even though the outcome of the case was satisfactory, it threw up a residual prospective challenge to the supremacy of the Constitution vis-a-vis Sharia law, now applicable in 12 states of the Federation. Now, what was interesting in this particular case and why I highlight it was counsel for the convicted appellant contended that the accused should not have been convicted under the provisions of the Penal Code, as the commencement date of the law showed that the infringing conduct took place 6 months before the applicable law was passed. Now, that's a basic constitutional principle. However, counsel for the state effectively argued that the Islamic penal system law provided the judgment should be based on the Quran and the Sunnah and not on the 1999 Constitution that was cited on the accused's behalf. Fortunately, the court allowed the appeal, but on other grounds, and did not discuss this issue, which remains moot, even though in several other cases, there have been conflicts between laws under the Islamic code and the Constitution, and the courts have upheld the Constitution. But this is just to illustrate some very fundamental issues that 60 years after independence, Nigeria is still grappling with and must confront and put into perspective. The time allocated for this presentation doesn't really allow one to give too many examples. So suffice it to highlight the fact that across conflict-affected countries such as Nigeria, crime and violence are cited as amongst the top constraints to productivity and growth. Therefore, it seems reasonable that strengthening the armed forces, the police, the criminal justice institutions towards improving security and law and order, including attending to the needs of victims of crime, must be amongst the most urgent priorities for us to enable development. Other impediments to the rule of law in development include the untold delay that we've always talked about in the administration of justice itself, which can only be improved by a review of the rules of practice and procedure to further eliminate bottlenecks in the tunnel of cases and controversies that come before our courts, including innovative procedural reform. Strengthening accountability and legal checks on power, and of course, zero tolerance for corruption, nepotism, and rent seeking, which affects costs of economic actors through legislation-driven institutional checks on public and private accountability. I think this would clearly promote a fairer allocation of services through credible mechanisms that will shape the provision of public services and the quality of public infrastructure by promoting investment and economic growth. The rule of law cuts across development endeavors from road building to port building to the provision of basic infrastructure, electricity. How over $30 billion could have been spent on less than 3,000 megawatts of electricity, and how the quantum of consumption of petroleum products could suddenly double, or the amount spent on the wasteful subsidy of petroleum products could double or triple in a particular period, are all matters of rule of law. They're not seen like that. They're seen as sectoral issues. But at the end of the day, if the rule of law is strengthened, then some of these challenges will be addressed, and resources that are being wasted can be used towards development. A legal system that fails to confront such glaring contradictions cannot serve a nation's development aspirations or outcomes. I think that the whistleblowing policy is therefore a step in the right direction. However, comprehensive whistleblowing legislation is probably still required to give teeth to the policy. The rule of law is also important to any notion of sustainable development in protecting our environment and natural resources. Here, I would single out continued gas flaring as a particularly egregious infringement of environmental laws and regulations that fail to protect or advance the right of people to health and to a balanced and healthy ecology and economic rights in the Niger Delta in particular. These examples that I've given are obviously not exhaustive, but give an insight into the possibilities as we step forward under the theme of the rule of law on the 60th year of the NBA. Let me therefore just simply conclude my introductory remarks by saying that the rule of law applies in a complex, multi-dimensional space of political and social change that's tied to governance reform, and that requires some innovative rethinking of what the rule of law is and what it must be made to be for development to be enhanced. I'm sure that at the end of the other presentations, there will be specific questions that have arisen from my brief remarks, and I look forward to a healthy discussion on the subject. Thank you very much.
That has been issues, but I will not begin to speak to those issues or take any questions immediately, because we need to take our colleague, that is Professor Lumumba from Kenya. I understand that right now at Kenya there is a curfew, which implies that he has to come through very soon, and so he can get home in good time. I am very sure that Professor Lumumba will be able to show us how the fact of the curfew itself, which is probably an issue around security and safety, you know, how the rule of law is implicated in that. It'll be really insightful to get a sense of that. But like I said earlier, he is one speaker that is known to speak truth to power, and I'm really excited that he's able to join us. Professor Lumumba, please share your thoughts with us on the rule of law, where we are in that regard in Africa. Is there an African context to the rule of law? Does it need any adaptation? Is the model that we seem to have borrowed from the West, from England in particular, is it sustainable, or is there something else that we should be doing? Thank you very much. You have just about 15 minutes. Professor Lumumba, can you check that you're not muted? Can you check that you're not muted? You're not. The sound isn't coming through. We can't hear you. Can you check your audio? Can you just check your audio? Okay, maybe you can start now. Let's see. It's still not coming through. It's still not coming through. Prof, is there anyone who might be able to just check that your system? We can't hear anything at all. Okay, so while we're trying to have that sorted out, I will just invite Mrs. Aisha Oyebode to share with us her perspective. She particularly indicated that she thinks that she has perspectives on how lawyers should move the rule of law discourse forward, as well as the rule of law aspiration. So, Mrs. Aisha Oyebode, can you please just share with us?
Okay, so good evening, everyone. Can you hear me?
Yes, we can hear you, but we need.
Can you hear me better now? Is it louder? Now I can't hear you anymore. So I think it might be the network or something. Oh dear. Okay, so basically what I wanted to talk about with regards to the rule of law is usually when we talk about it, we tend to talk about the fundamental principles, we talk about liberalism, we talk about democracy, we talk about the principles of the separation of powers and legality, recognition of individual freedom and equality, judicial review, law and morality. Those are, so we tend to look at it in terms of lofty, overarching goals, which are important. But I think sometimes it's important to bring the rule of law down closer to what it is that we can relate to. So I'm a member of the senior working group on Nigeria that advises the United States Institute of Peace. And one of the partner programs that the United States Institute of Peace has is with the World Justice Project, and it's on the rule of law. And basically is to see the ways in which we can measure the rule of law. And that, in fact, has actually been touched upon. Oh dear. Can you still see me?
I think she is frozen. Do we still have Professor Lumumba on? I think Professor Lumumba himself is gone off. Okay. Well, maybe what we'll do is maybe we take what we'll do then is we break the session into two, and maybe we take some questions directed at the speakers who are still on, and hopefully other speakers will get a chance to come on, and then we can listen to them and then direct some questions at them. Okay, you are back? Yes. But you're muted.
Okay. I'm not sure where I stopped, so I might have repeat a little bit of what I'd said earlier. So what I'm talking about is how I started talking about the World Justice Project as part of the partnership with the United States Institute of Peace, of which I advise as a member of their senior working group on Nigeria. Now, what's really important about the World Justice Project is that it gives you indices which you use to now measure the rule of law. So it gives you more sort of like tangible things with which you can say, okay, you know, these are the things that we can do differently that can affect the rule of law. So, but before I start talking about the indices, the first question, which is one of the questions that they try and answer with the World Justice Project, is the issue of why is it important? Why should it matter? You know, and I think both Mr. Spears and Mr. Ajumogobi had actually mentioned it when they talked about fragility. If you're in a state that has fragility and you have no rule of law, then it means that that's a recipe for violence and extremism. And we're seeing that in Nigeria right now. We've seen that with Boko Haram insurgency. We've seen that with the agitations in the Niger Delta. We're seeing kidnappings, including of the Chibok girls. We're seeing a lot of extrajudicial killings where, you know, recently, about a month ago, there were, actually, it's a bit longer than a month ago, a couple of, maybe 2 months ago in Katsina. And, you know, part of it is the brutality that we also see of the killings when babies were being thrown into live fires in front of their mothers. You know, there's the Fulani herder conflict, the herder farmer conflict. You know, so so there's that whole issue around fragility and insecurity. That's one of the issues. The other issue, which Mr. Ajumogobi had touched on a little bit, but I just would like to talk about it a little bit more, is that when you do have effective rule of law, as is being measured by the index, it reduces corruption, it combats poverty and disease, it protects people from injustices. And more importantly, it's seen as the foundation of communities of justice, an opportunity for peace, underpinning development, accountable government, and respect for fundamental human rights. So it matters because we will see growth in the economy, as Mr. Ajumogobi has said, we will see socio-political development and even human development. If we have rule of law, our GDP will be higher, and we'll have you know, better democracy, peace, better education, and health outcomes. So how then do we then measure the rule of law? Brian Spears had talked about the 4 universal principles. I'd like to repeat them. So there's accountability. And so that talks about the government as well as private actors are accountable under the law. There are just laws. The laws need to be clear. They need to be publicized. They need to be stable. They need to be applied evenly. And they need to protect fundamental human rights, including the security of persons and contract property and human rights. Then there's open government, the processes by which the laws are enacted, the way in which they are administered, enforced, the way in which they must, you know, enforcement must be accessible, it must be fair, and it must be efficient. And of course, accessible justice. Justice must be delivered in a timely, competent, ethical, independent manner. by representatives who are neutral and who are accessible again, and have adequate resources and reflect the makeup of the communities in which they serve. So these are the 4 universal principles. Now, beyond the 4 universal principles, they talk about 9 other factors which make up the rule of law index. And I'm going to try and see if I can just share my screen. I hope that's okay. Okay. So these are the way in which the indices, the rule of law index measures, whether or not countries are complying with the rule of law. As is usual, Nigeria ranks towards the bottom of the index. Overall index, Nigeria is 108 in a total of 128 countries. That's not good. But more importantly, if you go down the 9 factors and you start to look at constraints on government powers, okay, so Nigeria ranks probably, we would say, 68. Absence of corruption, we rank, I believe, in fact, we rank 109 on the absence of corruption. I think we've done much better on open governance. We're now at 94. Fundamental rights, 99. Order and security, we're 127. We are the second to the last country before Afghanistan. Regulatory enforcement, we are 99. Civil justice, we are 75. But the one I really want to talk about is criminal justice. Even though we appear to be at 76 in 128 countries, if you look at our criminal justice indices in respect to where we are, even in relation to the rest of the African continent, we rank pretty low. And I feel that that's one area, where I think that lawyers really need to be thinking about. So I'm not just looking at it from the macro or the meso level. I want to bring it down to the micro level. I think that that's where we need to begin to say, what is it that we can do differently? We are the guardians of the law. How is it that we can do things differently that will impact the criminal justice system? Because I feel that, so we've got all these 9 factors that make up the rule of law. But at the same time, I feel that there are some that are clearly very, very distinct. And I'll share a personal story very quickly and then tell you why the personal story is relevant. In 1993, my younger brother, the one who is immediately after me, was shot at point blank range by a friend of his, and he was killed. And the matter went before the young man was arraigned. And then because his father was a prominent politician at that time, the matter he just disappeared. All the documents and everything disappeared from the courts. For 5 years, we petitioned the Office of the Attorney General to see if anything could be done about it. Until today, nothing has happened. But you see, my brother is just one in the thousands of Nigerians. And I'm sure many of you would remember prominent Nigerians like Dele Giwa, Alfred Rowani. Bola Ige at that time was Attorney General and Minister for Justice. He used to be former governor of Oyo State. The shock killed his wife, Atinike Ige, and left his children orphans, Funshaw William, Kudirat Abiola, Ayodai Ramola. Even last week, we were talking about Chidinma Ajoku, and Chima Iwaipe was in the news. A container fell on them on their way to work. Chidinma was 27, Chima was 29. Just recently, Hajara Ismail is a woman who in Bauchi was, her son was brought to her in the back of a police truck because he had stolen chickens from a former policeman who had, a former police, I think he was a police boss. Anyway, the long and short of it is that I think that if we as lawyers, after so many years, are still not able to deal with the impunity in the criminal justice system, then I really wonder whether, we can then hold ourselves up and talk about all the other elements that make up the rule of law. Our criminal investigation system is ineffective. I'm actually going back to the sub-factors that we use as a rule of law, that the World Justice Program uses as an index for measuring our effectiveness in terms of criminal justice. So criminal justice investigation system is not effective. Criminal education system is not timely, nor is it effective. Our correctional system is not effective in reducing criminal behavior. Criminal justice system is definitely not impartial. We now see that our police think that they are judge, they are jury, they can be executioner. It's certainly not free of corruption, and criminal justice system is not free of improper government influence as well, and due process of law and rights of the accused are definitely not permanent. So that brings us to the culture of impunity. Once our criminal justice system is failing, it's clear that what we are now seeing that seems so normal is that we have now developed a culture of impunity. But unfortunately for us, we are still not able to relate that impunity to what it is that we think we do on a daily basis. We see impunity as something that somebody else is doing. We other, A-O-T-H-E-R, we other responsibility for impunity. We think it's somebody else's responsibility. So we do not concern ourselves with the fact that the police are improperly trained. We do not concern ourselves with the fact that the police think that they are actually minions to government officials and those who rank high in society. All of those are things that we see as separate from us. But these are the things that determine whether or not we have a criminal justice system that is effective. Now, so if we then say to ourselves, okay, let's leave the criminal justice system aside. If you look at all of the other factors, I have them listed here. If you talk about the constraints of government power, the sub-factors, and I won't go through all of them, is, so there's 6, of which 5 out of the 6 are actually, again, within the control of us as lawyers. Government powers are effectively limited by the judiciary. Government powers are effectively limited by independent auditing and review. That's what is measured. Government officials are sanctioned for misconduct. Government powers are subject to non-governmental checks. Transition of power is subject to the law. It's the same with regards to the absence of corruption. It's the same with regards to open government, fundamental rights, order and security, regulatory enforcement. We've done well with regards to civil justice. We've actually gone up on the index, so which means that people are getting better access and affordable civil justice, and some elements of it are becoming freer of discrimination. Civil justice, well, it's not as free of corruption as probably it should be, but at least relative to the criminal justice system, it's believed that civil justice system is free of corruption. It's also freer of improper government influence, is not subject to unforeseeable delays. The delays are now being minimized, and it is arguable, but it's thought that civil justice is effectively enforced. and also alternative dispute resolution. And I think that's probably why our indices have gone up, is because alternative dispute resolution has become more accessible, has become more impartial, and has also become more effective.
One of the challenges of the IT world, the speaker seems to have dropped off. Maybe she will come on. But while we're waiting for her to come on so that we do not take too much time waiting, and I just have a couple of questions for the first two speakers, and we'll see whether Mrs. Oyebode is able to come on, and then we can take off from where she stopped and then still add some questions later. Mr. Spears, when we talk about the Commonwealth, we're talking of countries that span, various cultures. In your experience, I know that the Commonwealth is trying to come up with basic standards, that is generally accepted. But would you say that the rule of law permits in any wise of any perspectives that is rooted in society's culture, its history, its politics? Basically, I'm asking, can we have different types of rule of law? Can we have different? You must have encountered some of these arguments. How have you confronted them? How have you responded?
It's a good question. I think I have mentioned in my opening remarks that so far as I personally am concerned, there are elements of the rule of law that are immutable, unchangeable, whether in the Caribbean or the Pacific. That the fairness of the system, how laws are made, the independence of judges, and the fair application of law to everyone is, I think, just non-negotiable. What I have encountered are changes that are influenced by ethnicity and religion. And these are areas that somehow have become difficult to discuss without being accused to be either intolerant or racist or in some way have a prejudice. But the fact of the matter is, in my report on child marriage across the Commonwealth, what I discovered, or what the Commonwealth Lawyers Association discovered, was that across all of the now 54 countries in the Commonwealth, there are laws. There are adherences to international conventions that say the marriage of a girl child as a child should not take place. It is against the law. And yet, many countries have experience of precisely this event happening. And it is justified on the basis of either customary or traditional practice or law or religion. And this seems to me to be trying to place an individual or sector-specific or religious-specific context on the rule of law that simply should not be acknowledged or accepted. So from my point of view, there are immutable, unchangeable norms that should apply. There are, of course, individual areas within this very broad reach of a subject that will result in different laws in different countries. And provided that they are brought about by a rule of law compliant process, there is, of course, nothing wrong with different countries having different laws. In the United Kingdom at present, it is surprising, perhaps, but there are different COVID-related laws as to the wearing of masks, as to the age at which protective face covering should be worn, as to the return of children to schools, as to local lockdowns that are different in Belfast and in Edinburgh, and are different in Edinburgh to Cardiff, and different in Cardiff to London. So if laws are made appropriately, then changes in what the law means and how it is experienced can be acknowledged. But the underlying principle is, how are laws made? Are they made by a properly elected and fairly elected government? Are the laws scrutinized by an independent parliament? And are the application of the laws carried out by officials who are acting reasonably and not exceeding their powers? And are lawyers entitled to constrain and challenge the application of laws? So my thinking is that there are immutable aspects, but there will be individual changes according to each country passing legislation applicable to its individual circumstances. Maybe that will kickstart a conversation, Professor. I seem to be the only one unmuted. I see Mrs. Oyebode, are you going to come in?
I'm back, but unfortunately, I didn't hear the question. So if I can hear the question again, I'll speak on it. I didn't hear the question.
It was about whether the rule of law changes according to the context in which you are in. And therefore my answer was saying, I don't think so, but individual countries might make individual laws differently.
I agree with you totally. I think the standard the basic immutable standards that the rule of law, wherever it is you make laws, must apply. And that will not change, shouldn't change irrespective of which country you're in. And I think that's actually the whole basis of us trying to have a universal standard for the rule of law, so that, we can then, and being able to measure it also allows us to see those that are falling beneath it and those that, beneath that standard. So there are very basic principles, the issue around safeguards for everyone, accountability, clarity, evenness of application, and then even the process for administering and enforcing laws, and most importantly, justice must be impartial and accessible. I think that's important. Yes.
I wonder, without taking over the moderator's role, does Mr. Ajumogobia have a thought on this interesting?
Yes, I think I'll be a little contrarian here. I think we obviously inherited, our inheritance was British common law, statutes of general application. We've developed our own laws since independence. And therefore the Anglo-Saxon model has been to focus on individual rights, the protection of individual rights. And so when we talk about access to justice, we talk about equal protection of the law, it's about the individual. It's all about the individual. Government is to provide welfare and security for the individual. The individual has rights to challenge things that happen in society, et cetera, et cetera. Now, there are really two models, if you like, with regard to good governance, which is what we're really talking about, the rule of law that promotes good governance, promotes development. And I like to think about China as an example. Nobody would, instinctively, when you think about China, you don't think about the rule of law. Because the focus is on the development of the state at the expense of the individual. But there's no question that China has scrupulously enforced laws. They have, their development has been enabled by by the rule of law. Now, it's then therefore becomes a matter of definition, whether the limitation on rights of the individual that is clearly constrained in countries that don't practice democracy in the way that we do, or we try to do. But if we're talking about, in the context of my comment, my earlier remarks, that I think what we're lacking in a lot of developing countries, and on the continent especially, is the lack of enforcement of law. It's not the existence of law, it's a lack of enforcement. And if you can enforce laws and therefore the environment is predictable, then you will have the sort of development trajectory that China has experienced.
Yes, that's very interesting in the sense that one of the conversations that I have had recently revolves around Hong Kong, which is a Commonwealth jurisdiction where Chinese law has been passed in the manner that Chinese law normally passed, and now applies to a jurisdiction which had, of course, an experience of the type of rule of law, individual entitlements that you have just described. So that is certainly a source of tension. But what you're maybe asking is it the law that is changeable and the adherence to the law is not changeable, but that our laws are crafted in different ways for a different purpose? And I do think this clash between China and Hong Kong at present is a really interesting but pretty treacherous challenge. You'd also—
Can I come in? Oh, okay, sorry. No, go ahead. Sorry.
I mean, you can of course come in, Mrs. Oyebode, but I was going to then slightly expand the discussion into compliance, because we have a great deal of treaties and declarations. And I've referenced the Latimer House Principles signed in Abuja itself by all the Commonwealth heads of government. And so one might think that the Commonwealth countries would be soaring on the rule of law index because they have, in theory, signed up to the rule of law principles as we understand them. But sadly, so many Commonwealth countries are not yet soaring up the table. And therefore, to me, it becomes not just an institutional and government and state approach. Individuals must change, hearts and minds must change. And this message that Mr. Ajumo-Gobea has got out about the benefits for commerce is really vital to continue to emphasize, because we are not going to achieve prosperity, fairness, equality, and adherence to the rule of law simply by signing up to treaties and declarations. We need to comply with them. Mrs. Oyebode.
Yes, no, I wanted to go back a little bit about the conflicts when we're talking about rule of law in countries like China, and when we compare it to standards that we think are the standards that we are used to. But in real terms, so I can bring it back home here. There's always that, argument about, is it rule of law we want or rule by law, which means that, the fact that you make these draconian laws and you can enforce them, is that what the standard that we want? And if you look at even, for example, take the Boko Haram insurgency, where they demarcated territory and they claim to apply their laws. And some of these laws are pretty brutal and they're pretty vicious, and they don't conform with any standards of law as we know it. So I start to worry about, where do we then draw the line for that kind of situation? Because then there's a risk. And if we don't, if they're universal standards, and those universal standards are I'm looking at Mr. Ajimogobia, and those universal standards can be altered, then I worry. So I don't know whether, Mr. Ajimogobia also talks about that.
Thank you very much, guest speakers. I think, thank you for the conversation. Thanks for taking it and making it smooth. But I'd just like to zero into something, which is, we've talked about the ideals. The challenge is, so what makes for, we just need to enforce. So why have we not been able to enforce? What is the problem? I know that Mrs. Oyebode was alluding to that when she was speaking about the legal profession and how we seem to be very critical players in the areas where we have the lowest score on the index. So the question is not just to the issue is not just to be able to identify the challenges, but to ask ourselves, it's about stepping forward. So how are we going to move forward? And that reminds me of the case study presented by Mr. Ajimogobia, when he said, when you have a challenge to the Constitution itself, which law then are you living by? Which law is ruling? But you know, it's not just in good, it's not definitely not good enough for us. And this time I'm directing the my questions to the Nigerian lawyers on this panel. How do we go forward? What practical steps? I have seen the questions. People have asked about executive lawlessness. And the question is, how do we break it? How do we just stop what seems to be the norm so that we're able to move forward?
Well,
so I will start with Mr.
Margarita, just so that I'm not,
so that we will really be able to go forward. We've identified the problems, we've identified the challenges, but the issue is, so we know us, we know what the challenges are. How do we step forward, especially as lawyers, as a bar association?
Can I start? Let me, for the avoidance of doubt, make clear, advocating that we adopt the Chinese model, that I do believe that the rule of law and protection of individual liberties are essential ultimately for sustainable development in every nation. And I'm a firm believer that even if you look at, I gave the example of China, but even if you look at China, individual liberties are slowly growing. I mean, the number of Chinese who travel abroad every year and go back, it wasn't always like that. And I think that it's probably a time. Having said that, I think the answer to that, my answer to that is institutions. We need to strengthen institutions. The set of institutions that I would highlight, and also referring to, this relates to what Mrs. Oyebode said about where do you draw the line? I mean, we are impliedly talking about the rule of good law, whatever that is. I mean, if you go back to the philosophical underpinnings of the rule of law, the debate gets very interesting, because you had, apartheid in South Africa, where laws were enforced, but most people would agree that those laws did not meet the essential criteria of being good law. Now, the institutions are obviously the government itself, the executive, the presidency, of the governors and MDAs, the police and law enforcement agencies, the Electoral Commission. How's leadership selected? What's the process? How do we ensure that we don't have, as the Vice President said in his remarks yesterday, you're not in court for 3 years, challenge a 4-year term, deprived of. The media, we had, there were noises about passing a social media bill to try and restrict activity in social media. The central bank, I mean, these are the institutions that I think are the core of our development, where they must be insulated from interference. The laws must protect their objectives and ensure that they're not manipulated by people who would wish to abuse their offices. And of course, in a context of a dearth of security or insecurity, the armed forces, strengthening the armed forces, equipping them, and ensuring that the basic security, which is what creates stability for all these other institutions to be able to function effectively. And I think in Nigeria, we really face the challenge of addressing all of these at the same time.
Are we still on? Oh.
I'm unable to hear the moderator.
Okay.
We have also the issue of corruption. What linkages, how do we ensure that we do not have, that the rule of law does not get manipulated and subverted when you have capture of the state and corruption, because this time we're trying to shape the agenda.
So was that, again, I'm sorry, I heard half of the question, but I'll piece it together and add it to what Mr. Ajimobobia was talking about earlier and, answer it. And if I'm not going the right way, you can bring me back. So I think the problem we have, and the only way we're going to go forward, is that we have to have zero tolerance for impunity. We have an entrenched culture of impunity that has made so there are no consequences for actions. I talked about murders. It seems as if I talk about that a lot. But if there's a breach of your most fundamental human right, is when you take someone's life. People are killed and there are no consequences. Threats, attacks, all of that. And whether the crimes are economic or financial, when you break the law, when you abuse the law, when there is a zero, there's a total culture of impunity. So the first thing is, I think we need to develop a zero tolerance for impunity. I think that's the first thing, because it's already been said earlier that the issue is not that we do not have laws. The issue is that the laws are not being enforced. And I believe you me, if we start to have a zero tolerance policy on impunity, a lot of things, all of those 4 principles, the 9 objectives I talked about will all start to fall in place. Just think about it when you have a quiet moment and you think, if there's total and absolute proper application of the rule of law, what kind of country would we see? The other issue is a culture of personal responsibility. I'd mentioned it earlier. It even has to do with corruption. We think corruption is something that is lurking out there in the background and has nothing to do with me or us or anybody else. It's the same thing with everything else that is important with regards to how we uphold the law. We think it happens to somebody else. We think it's okay if that policeman allows us to drive down the one-way road because we're in a rush to go somewhere. We think it's okay for policemen to stand outside and guard our parties, all of the things that each and every one of us is responsible for. There has to be personal responsibility and accountability. I need to be able to say, this thing is wrong, and I will not do it. It's very difficult because again, we have, it's become entrenched. But my view is that there's no culture of impunity that is invincible, no matter how entrenched. So those are my answers to questions. I hope I answered.
We're gradually coming to the end of our symposium. I think it's really important for us to begin to sum up now. Clearly, from what the speakers have said, we have immutable principles or elements of the rule of law. Whereas the rule of law has capacity to accommodate contextual variations, maybe because of the differences in people's culture, but there are certain aspects that are non-negotiable and that should never be varied. But it would appear that there are quite a number of things beyond law's reach. And yes, I always say to my students, there's a limit to what law can do. Law is not self-enforcing. Law assumes, or law has to be enforced by people who believe in it and and that's what the last two speakers have spoken to. But I will say that what we need to do is start small and start with ourselves. The question is, how disciplined has the legal profession itself been? The indices that were read out to us concerning the criminal justice system, where we are key players, suggests that we play a very significant role in manipulating the system and occasioning all the complications that seem to make us score extremely low on that level. Now you can imagine that if we score that low, little wonder that the citizenry have no confidence in the criminal justice system. And when you consider that for the citizenry, in their mind's eye, the criminal justice system symbolizes the whole of the justice system. So when they have such low esteem, low confidence in the criminal justice system, it's little wonder that their attitude to law and justice is basically, we do not have the public confidence to support that we need to give strength to the justice system. I dare say then that the agenda is cut out for us. The agenda is cut out for the incoming executive. The bottom line is that we need to start with ourselves. Maybe we need to look at how prepared are we to enforce even our own internal laws against our own acts of indiscipline, our own whatever. And hopefully when we begin to start that way, we will begin to circumscribe what's acceptable, the impunity that characterizes the society. So at this point in time, I just want to say a very, very big thank you to our speakers. Thank you, thank you, thank you for the conversation. Thank you for helping us understand that we can't ever close the chapter on what we know about the rule of law. It's always there. It's something we continue to engage with. And I believe that it's really necessary for us to push forward even the conversation that we've started to have today. Unfortunately, with a lot of IT disruptions, we didn't get the best, especially because we lost one of our main speakers that we were looking forward to. And so I will urge that at the earliest opportunity, some group of us, maybe the broad MBA platform, maybe some section of the MBA, maybe the academia, we definitely must look for another opportunity to reopen this discussion, reopen this conversation, so that we at that meeting are better able to identify the key things that we need to do to take the issues forward to address some of the problems and the factors that we have identified. I can't say enough thank you to you, my stellar panelists. Thank you very much, Brian Spears. Thank you very much, Mr. Odena Jumogobia, SAN. Thank you very much, Mrs. Aisha Oyebode. And of course, a very big thank you to Professor Patrick Lumumba, even though we were unfortunate and we couldn't even hear him say one thing. And thank you very much to the participants, when I looked at it, I think we had close to 500 participants at the last gaze and the number of participants. You've made it all worthwhile. Thank you very much and have a good evening. I wish us good success as our conference proceeds towards the end. Thank you.
Thank you.
Thank you so much, Professor Shenwa, for that. Another very enlightening and interesting symposium, this time on the rule of law. We're now moving into the last two activities for today, and they're both training sessions. The first is on building a digitally fit business. And this will be facilitated by Olushola Adewale, partner at PricewaterhouseCoopers. He holds a master's in human resources management from the Fisher College of Business at the Ohio State University, Columbus, Ohio in the US, where he was until recently on the teaching faculty. In the last 24 years, Olushola has led successful organization effectiveness projects for leading African and multinational organizations across all major industries. He's a partner and territory leader of PwC's Global Digital Upskilling Initiative. That's the New World, New Skills. He leads the firm's people and organizational advisory practice in Nigeria, Ghana, and Liberia, with a focus on digital workforce transformation. And today he will be assisted by Samuel Akinlotan, management consultant at PwC. After that, we'll have another training session, the PCL COVID framework, managing employee well-being in times of uncertainty. This will be facilitated by Rob Taiwo, managing director of Philips Consulting. He has over 20 years international experience working extensively in leadership positions for the FTSE 100 companies and leading multinationals across the UK, Europe, and West Africa. His specialties include business strategy, corporate strategy, leadership development, transformation and change, operating model development, performance management, and cost benefits optimization. And he will be assisted today by Nwaji Jibuno. Thank you.
The chairman section on legal practice, and may I take a little bit of your time to inform you about one of the foremost publications we have in the field of legal practice in Nigeria, produced by the Nigerian Bar Association. And I'm speaking about the Nigerian Bar Association section on legal practice journal. This is both a professional and an
Okay, good evening everyone. I'm not sure if you can hear me. Can someone tell me if they can? Great, you can hear me. All right, thanks. That is very helpful. Great. Okay. Good evening, everyone. My name is Shola Adewale, as was announced. I am privileged to speak at this great conference that started yesterday. I lead PwC's People and Organization Practice, which is short for HR Consulting. And I'm going to be speaking to you over the next 30 minutes or so on building a digitally fit organization. I want to be sure that my screen is up. Okay, great. Okay, So I'm going to be speaking to us across three main topics. One, I will be speaking first of all on the whole conversation around digital disruption, which has led us to new world, new skills. We say there's a new world, and in order for you to thrive, to succeed in any business, and as a lawyer, you need to have a new set of skills, or you need to build new skills into your organization. And secondly, I'm going to be talking about digital fluency. Okay, so what is the language of this new normal, and what does that have to do with the legal practice? I'm going to be sharing with us a few trends that PwC and many organizations have done some research on and found out how technology is changing the legal profession right before our eyes. And then I will round up by talking about the building blocks of digital fitness. How do you build digital fitness as a person and as an organization? So let me start off by talking about digital disruption and how that has brought us into a new world of work. So first of all, I think the most important thing I want to say to establish, to get things started, is simply that this digital disruption is changing entire industries, and no enterprise is immune. One of the most popular things that we've all done in this last few weeks or months of the lockdown is binge ourselves on Netflix videos. But all that brought Netflix was a disruption of the good old video rental world. Okay, so there was a time when you had to go to the video club or something before you could watch a movie. But right before our very eyes, through the use of artificial intelligence and internet streaming, you can have access to almost limitless numbers of audiovisual content. So you can imagine what has happened to the blockbusters of this world, and what is likely to happen to even the cable TVs of this world if they don't disrupt themselves. So failure to adapt is really failure to survive, as it were. So what exactly is this digital disruption is all about? Okay, some people regard digital as a website. So if you ask the average person whether they have technology or whether they were digital, they will say, oh, we have a website, have an app, we have a network in the office that connects us from what you're doing to your printer and so on and so forth. But digital is much more than that. Digital is about new ways of solving your client problems. As a lawyer, for example, thinking digital is about new ways of providing expert legal service to your clients. It's about creating new experiences for your clients and for your employees, right? So if you think about the fact that in this new world of work with the changing demographics that we have, most organizations find themselves now hiring increasingly large numbers of younger people. Now, these are people that we call, from Gen Zs to millennials, we call them digital natives, the people who are born into a world of technology. So if you're going to attract talent that helps you to reinvent yourself as an organization and have some longevity in the practice, then you've got to be speaking the language of digital. Otherwise, you won't be able to attract them. But the biggest thing about digital is that it not only solves problems, it not only creates unique experiences, but it helps to accelerate the performance of the organization. Digital is about data. The very bedrock of digital is the fact that we can use data. We can acquire data about our clients, and we can use it to provide them service. Okay, it's about flexibility. It's about being agile and not be stuck in your old way of doing things. If I might just take a deep dive into that, I always like to give an example of how just before COVID-19, even in some of the most elitist offices that you can imagine, there were conversations around whether people could work remotely or not, and whether people would be productive if they were working Then it wasn't even about working remotely. It was more about working flexible, like working 3 days a week and working from home other days. And we've had senior leaders who have challenged this, and because they were stuck in their old ways, they couldn't see how people would be effective if they decided to be that flexible and have three-day weeks. But COVID-19 struck, and now everyone, whether you're old school, new school, we now all have to work remotely for extended periods of time. And now we've discovered that we can actually get it done. So digital disruption is simply about a new world, and it's demanding a new set of skills from us, from agility to data analytics. But I'll talk a bit more about that. And then now let me go to the next part of my presentation, which is around how this digital disruption is impacting the legal practice. So PwC every year conduct a survey of law firms across the world. So last year, and it's driven from our UK practice, the PwC UK firm. Okay, last year, as at the end of 2019, this was 2-3 months before COVID-19 came up. We found out that 8 out of every 10 firms that we surveyed identified technology as the key challenge, the key hurdle that they need to cross to grow their businesses or their firms in the next 2-3 years. We found that 100% of the law firms that we had surveyed in 2019 have suffered some form of a cybersecurity breach or the other. So we had, from phishing, people trying to get your client data, trying to get access to the pretty confidential information that lawyers keep for their clients. And we found out that artificial intelligence, which is simply the ability to learn from experience and from human experience and translate that into service for your client, is the most likely technology to disrupt the legal sector in the next 3 to 5 years. So that is speaking from an organizational point of view. So you have a practice, you want to make sure that cyber attacks and the absence of artificial intelligence in your business does not steal your lunch. But now let's speak to the lawyers on this call who don't have big practices. They're probably just starting their careers, or they're probably just building their practices as independent, literally from a briefcase. The World Economic Forum also last year, flowing into even the beginning of this year, found out that jobs, among the top jobs that were at risk as a result of this digital disruption, is actually the job of the lawyer. Okay, so data entry clerks, accounting, auditors, and then lawyers. Okay, so this conference probably has thousands of lawyers who are a part of that. But we are finding that if lawyers don't acquire digital skills, if they do not become digitally fit over the next 10 years, that role, that job as we know it, may be totally disrupted. 90% of the jobs that exist today will require digital skills in 10 years. And so I'm sure that the question that must be on your mind and anybody's mind is, what are these skills? Okay, what are these capabilities that I need to thrive, either as an independent or as an established law firm? Okay, so as a part of our study, these are some of the concerns that the top 100 law firms, for example, in the UK, feel will disrupt their business. The first one, as I mentioned earlier, is artificial intelligence. And I'm going to speak a bit more about how that works in a moment. Process automation, blockchain, the ability to have a central repository of records that is consistent, so that you don't have one set of documents with one with the lawyer and another one at the land registry, for example. DNA, data and analytics. These are all just the kinds of capabilities, or if you like, skills that we need to have if we're going to play in the new normal. So what are some of the trends that these different disruptions are bringing to the legal profession? Let's start from cloud computing. I haven't been to court many times, but I do remember the once or twice that I have been near a courtroom. I have seen, maybe you watch the lawyers coming out of a big case, some of these political cases, and they're carrying huge loads of files around. I know there were entire organizations built up from the scratch, whose job, whose main mission was to do print legal publications. Now, cloud computing is changing all of that. So if I was a lawyer and I was going to go to a court case in Aba, for example, I don't need to anymore carry a suitcase load of legal books or legal text. Just by uploading my files into the cloud, which for many applications now is literally automatic. As long as I store my things in the cloud, when I get to Aba, I can just open my email or open my file and download everything that I have put in there. Pretty much like if you have an old iPad and then you buy a new one, all you need to do is sign in and all your data is back, okay? Artificial intelligence uses big data for pattern recognition in human behavior. So that is going to totally change the way we think when we think about criminal cases, for example. So we can actually identify patterns of human behavior by storing pieces of data about this particular case. I've mentioned about a blockchain that maintains a central repository of the same record. So your records in your college in the US or in IFE or UNILAG is centrally coordinated with, the same record is maintained with the government where you work with different firms. So you will not have situations where people have false records in one place. If anybody tampers with one part of the blockchain, it automatically affects the other. So you can easily raise an alarm. Cybersecurity, I spoke earlier about how data breaches or your breaches into your network has cost you a lot. In the survey that PwC did, we found out that 100% have experienced it. But in the US, we found out that 80% of the very large firms have experienced a specific malicious breach, not just phishing, but a targeted attack at their systems, okay? Virtual law firms as well. Who would have known, for example, the extent to which COVID-19 would affect what we do? I bet that there were many lawyers and many practices that were significantly challenged or limited by the inability to engage. I know the courts could not meet for a while. But with technology, now we can have large teams of lawyers. I mean, if I use my profession as a consultant, for example, now I can have meetings. I mean, even at this conference, we've had people dialing in from all over the world and speaking, saving us, thousands of US dollars in business class tickets, flying people from all over the world to come and speak or to come and take a court case. Now that court cases, even court appearances are also going virtual, we can have legal teams from across the globe. Now that has serious implications for the legal profession here when you think about competition. Okay, so all I need to do is to begin to explore what are the licenses that are required for me to operate, for example, in Nigerian bar. And then you can have, trust the elite in any country, engaging the best lawyers from anywhere in the world without having to fly them here. And then you have, solutions like customer relationship management solutions that are also disrupting our world. I mean, nothing pleases a client more than your ability to update and provide insights into their files before their big meeting. So one of the greatest applications that you can use at this time is Salesforce, for example. So if I have a meeting with you, if I have a consultation with the client as a lawyer, once I put it in my calendar that I have a meeting with you, Salesforce speaks to my calendar and pulls out every information available online about this client that I'm meeting. So I know about the client even before I see them face to face. So all kinds of things are happening that are changing our world. Now, the challenge for us in all of this is that the role of the human as we know it is changing. Now, I know there is a lot of concern, there are a lot of doomsday analysts who think that all of these disruptions I've talked about will rob them of their livelihoods, their jobs, and stuff like that. But that is true for significantly. Quite a large number of jobs will change. And what the language we like to use is that they will change. They may not all be totally wiped out, but technology will significantly change jobs as we know them. So what is the message here? There is a dire need to retool yourself, your organization. And you can't stop because technology is changing literally by the hour, okay? And if you don't change, if you don't retool yourself and equip yourself, then you will not say that you are disrupted. You will say you took no action, okay? So now, what are some of the challenges that we have as I begin to think of becoming digitally fit as a person or as an organization? The first big one, of course, is skills, okay? So big challenge is that those skills just don't exist, and they don't really exist in huge, in large volumes anywhere. So it's not a case of, oh, I'm going to import people from Kenya, I'm trying to remember some of the countries from China or from Russia to come and do that. Everybody is on a learning curve as far as technology is concerned. The good news, obviously, is that there are nodes of this where there's a bit more traction and they've gone a bit ahead, but we'll come to that. Another big challenge is leadership. Now, most of the leaders in many organizations, particularly even in the law profession, many of the senior lawyers are not exactly digital natives. So if you're a senior advocate of Nigeria or you are a senior partner in the average senior practice, or large practice, you are not likely to be a digital native. So you had to learn technology as you grow. Now that whole technology is also changing. So how do we make sure that the leaders who are supposed to transform or lead the organization into digital fitness also become digitally savvy themselves, okay, so that they can help their workforce to think in a new way. And then, of course, processes. I was speaking to, I think, some bankers a few months ago, and they said, Shola, part of the problem part of the challenge in our digital journey is simply that, the Central Bank of Nigeria still expects to see a lot of these things in paper form. The same thing with legal contracts. I still know that there are legal contracts or documents that you get where they say, we're going to cite the original. So all of that are challenges that are in our faces as we try to transform, but they're not insurmountable. So in this new normal that we find ourselves, building a more digital workforce from the top to the bottom and embedding that in your culture is the greatest enabler you have to be innovative and to grow your practice. You've got to make that investment in your people, in your leaders, in your processes, so that you can be relevant and you can grow going forward. Now, what is the return on investment, so to speak? What is the outcome for your law practice? Okay, if you invest in a more digital workforce, either for yourself or as an independent lawyer or as a firm, you would exceed your client expectations. So imagine if you embarked on this journey and every time you are engaging with a new client, because you've invested in capabilities around artificial intelligence and all of that, you are able to profile your clients. I read something a few days ago about a lawyer having a new client, and this is supposed to be a client, and you say, oh, hello, how is your wife? But if you had employed your digital capabilities, you will have, through machine learning, found out that this new client of yours was divorced or widowed, 3 years ago, 5 years ago. But just having access to that information before time gives you an edge. Innovation is a totally different ball game as well. Having a culture of innovation in your practice will totally change how you go forward. Indeed, in the legal industry in Nigeria, some of the more avant-garde firms that have gone ahead are the ones who have unlocked innovation and done things differently, obviously elevated their profile in the workplace. So what is the journey to becoming digitally fit? Okay, now you know that the world is disrupted, needs new skills. The legal practice itself is being disrupted. What is the journey? Okay, so if you think about this slide that talks about the building blocks, okay, so there are 5 major building blocks. Just things to bear in mind, if you like, call them the touchstones or the milestones as you proceed in the journey. The first one is that you've got to assess your current environment, your current practice, and identify whether you have the skills gaps for the new world that we're in, okay? And then secondly, from a leadership point of view, you've got to have a future-proof skill strategy. And what do we mean by that? Technology, digital is growing fast, but it's not all of it that is relevant for everyone. So you've got to determine what are the capabilities that will impact my ability to deliver business value in my practice over the next 6 years or 5 years or 3 years. And then thirdly, you've got to lay the cultural foundation. Personally, this is the area where I like to encourage leaders to think about, because the traditional way of doing things is totally opposed to what is required to go fully digital. So if you still run a very hierarchical organization where the junior partners or the junior lawyers cannot challenge things, or they cannot show you new ways of doing things, then your digital workforce transformation journey is already threatened before you start. So assess, build a strategy, create the cultural environment, because as they say, that culture eats strategy for breakfast. And then you can deploy specific upskilling initiatives. So if, for example, you want to become more digitally driven, more data driven. So very clearly as a baseline, because data is a currency for digital, or is the lingua. So the first thing you want to do is you want to roll out a company-wide digital, a firm-wide digital data and analytics capability program that helps people to even begin to think about data visualization and sources of data and so on and so forth. And then, of course, because we are running the practice as a business, we've got to measure how that is going in terms of return on investment, okay? Now, so PwC has a central research center that spends quality time looking around things around leadership, culture, and digital fitness, and we call it the Katzenbach Center in New York. And they found out that there are 4 building blocks or pillars on which digital fitness rests, okay? Skills, mindsets, relationships, and behavior. So if you take relationships, for example, if you run a law practice that is not very collaborative, where people don't engage together as one firm, then you have a challenge of harnessing the capabilities that exist in your organization. If people are very closeted and behaviors are wrong, people are not used to doing things in an agile way, okay? Then that itself gets in the way. I gave the example earlier about leaders, even at the beginning of 2020, who did not believe that we could work from home. Now we are all compelled to. Mindset is another big one. So skills, mindset, relationships, those are the big pillars on which digital workforce transformation rests. Okay, so what is our approach, or what is our methodology that we recommend for anyone who wants to grow a digitally fit organization or who wants to be a digitally fit person? Four steps, and I'll begin to close from here. Assess. So the first thing is that you want to assess your digital capability of fitness. You've got to determine where are you as a person or as an organization in the digital journey. How far are you from reality? There are people who don't even know the difference between machine learning and robotics. I didn't know until recently the difference between robotics and robotics process automation. Well, some of my younger colleagues who had attended the program that the firm was running, quickly corrected me and I took the correction, okay? So assess, advance. Now, once we've assessed where we are, then we've got to move forward. We've got to act on the data that we have. The third thing that organizations also need to do is to inject new talent. Sometimes you will find that you don't have those capabilities in your organization. You've got to inject new talent. In PwC, as we embarked on our own digital journey, we found out that there were certain capabilities that we needed that we didn't have. One of them was data and analytics. In the last 2 years, PwC has hired more people with data analytics. Now we are hiring PhDs who belong in universities who understand these things better than most, okay? And then of course, acceleration. And accelerate simply means getting people actually in classrooms. I'll unpack all of this very quickly. So assess, like I said, is about having a clear understanding of your digital fluency as a person and as an organization. Okay, now, one of the things that PwC has done in the last 12 months is to create a solution that helps you to assess that digital fitness per person or per organization, okay? So it's a simple app, which I believe has been shared in your conference bag, but even if you don't have it, I'm going to show you, it's going to be on the screen. It's a free app. It wasn't always free. It cost $15 a month up until recently. But at the advent of COVID-19, we thought, how can we help society to navigate this? So we said for the next year, we're going to give it out for free and give everyone an opportunity to assess their digital capability and also grow at a very, very rapid level their digital fitness. So that's what the digital fitness app does. The second thing you want to do is to advance, okay? So there are all kinds of learning content available to help you to advance your learning plans. One of the beauties of the digital fitness app also is that it contains literally thousands of snackable content that on your phone or your iPad or your desktop, you can acquire new learning on literally everything on the surface of the earth about digital fitness, okay? So whether it is data and analytics, robotics, even about sustainability, about machine learning, about drones, everything that you need to know is here. The good news about it is that you have it in video form right there on your phone. You have text, you have articles, you have gamified things that help you to grow. Now, if you see a score on the screen, one of the things that you find there is that it gives you a score and it tells you as you complete new knowledge, it grows your score, pretty much like a credit rating. So one of the ways that organizations have used this, some of our clients have used this, is to make sure that everyone in the organization downloads this app. One of our clients actually turned it into a competition. They wanted to find out which part of their departments were dragging them down as far as digital fitness was concerned. So these are a selection of some of the topics that you will find on that app. So learning the digital world, design thinking, blockchain, even social media, things around augmented reality, virtual reality, and so on and so forth, okay? The third step, obviously, is to inject new talent, okay? Now, more than ever before, we are finding out that no organization can employ fully on their payroll all the digital skills that you need. Even if you could afford them, even if you're one of the biggest law firms, you could afford them, this new talent don't want to work for any organization full-time. So they're willing to give you 2 weeks or 2 days of their time in a week, and you pay for that. I always like to give the example of one of our clients who is in a similar industry as yours, who decided that they were going to deliver on a digital platform. They found one young graduate, fresh graduate, they were going to hire. And this young lady said to them, I want to make $1 million every month. I'm fresh out of university, but because I know the value that I'm bringing to your digital platform, that I want to make $1 million Naira every month. I thought that my client was going to say no, but they opted to hire this young Turk because she was bringing valuable skills, and she wasn't going to work for them for 5 days a week. She said, I'm going to do 4 days a week. The last day of the week, I want to go and rejuvenate and get inspired. They hired her. So you might need to inject new talent if you're going to transform your business in that area, okay? And then the last point is accelerate, okay? So, and this is taking it to another level. This is where we go beyond the snackable content that you can get on an app, okay? So you assess, you provide knowledge, but then we have what we call digital labs, digital hubs, okay? Where the good news now is even with the virtual world that we're in, you can access serious intentional content on robotics. I built my first robot late last year, and it's amazing that it is possible. But I never left my house. I did everything under the guidance of my tutor online, and I posted on LinkedIn that, hey, I built my first bot. So it's a journey. It starts with assessing where you are. So the question I want you to ask yourself as a senior partner of a law firm or as an independent lawyer is, what is my digital acumen as a person? What is the digital acumen of my organization? Okay. Once you establish that baseline, get some baseline information from the app, then you can begin to outperform by exposing your people and yourself to digital academies that teach all of these things, pretty much like you will go to law school or you will go to a business school, as it were. Okay, so these are examples of ways in which you accelerate your capabilities. So you can go through an immersive program in data analytics, in robotics process automation. You can have people in your organization who are your digital champions, who are rolling out new knowledge on digital almost on a regular basis. So in conclusion, as I begin to round up, investing in your digital workforce transformation journey will lead directly to an increase in client satisfaction and superior performance. Our research has found out that design-driven companies consistently outperform others by up to 228% because you simply just multiply your breadth of service that you can provide. And we find out that this has a direct implication also on the productivity of your people. So in this new world of work, top talent are being very selective of the digital capabilities of your organization. And we found out that if you are not a digitally savvy organization, great people don't even want to work for you. Most people want to work for the firms that are offering the best opportunities as far as digital is concerned. And then, of course, we found out that these kind of firms are more likely to multiply their financial performance above the others. So I'm going to close by showing you a little video. I hope this works. That simply just talks about the digital fitness app. It's just a 1-minute video. And then right after that, I'm going to flash on the screen how you can access this digital fitness app for yourself. All right, thank you very much. I hope that was helpful. On the screen, you'd have an invitation that offers you the digital fitness app. It's free until June 2021. It's our contribution to solving this big problem in society of a lack of digital acumen. Thank you very much. I think we can take a couple of questions at this point.
Thank you very much, Ola. Thank you very much. That was a very, very insightful session. The comments have really shown how this has really brought newer insights into how this body structure is changing labor services. So thank you very much once again.
Samuel, I'm not sure that it's my audio or yours. Your voice is sounding very digital.
Okay, I don't know if you can hear me clearly right now. This is better.
No, I can't hear you. It's breaking up, but
okay. I think I'll just try.
Maybe it's your headset. I don't know.
Okay.
Okay, I don't know if it's from my end.
Yeah, it's much better now. It's better.
Okay, great. Yeah, great. Thank you very much, Lord. That was a very, very wonderful presentation, and comments, as you know, really shared feedback on how this conversation is really how we need to rethink how digital is changing the legal industry. So we have some questions here, but the first one I want to start with is the one that speaks to the slide that we have up right now. The question says, how do we get the invite code for the Digital Fitness Assessment app? How can they get the invite code for the Digital Fitness Assessment app?
Yeah, thanks. It's right there on the screen. If you see it, it's there. It's LRNALL. It's on the screen right there. It's right there on your screen. If you are in the session, then you can see the screen. Is L for Lagos, R for Roger, N for Nigeria, A for Alpha, and then Lagos.
Great. Thank you very much. So I'll move to the first question here from Ujuolape Famuibo. The question says, what are some examples of software for cloud computing?
Thanks. So first things first, I'm not an IT guru. So I think that the moment you decide that you want to go into the cloud, then you need to talk to your tech people. You need to talk to tech consultants. I do know that even basic applications like your Google Suite is cloud-based technology. Yeah. I do know that the Salesforce that I spoke about earlier, which is a customer relationship management software, is cloud-based. Oracle, I mean, name it. I'm not sure there's any software that is what its name, that is what the name software now, that is not a cloud-based software, because everything really is going into the cloud simply from a storage point of view and from a security point of view.
Great. Thank you very much for the response on that. So the next question here, as we're rounding up, says, as digitalizing a law firm, maintaining it, and also keeping all your confidential information secure can be very capital intensive. How can smaller law firms who might not be as buoyant digitalize? So the question is focused around cybersecurity. If they are maintaining their information in cloud, this could be capital intensive. How can they manage it, considering how capital intensive it will be?
Yes, thank you very much. I think one of the most disruptive things that all of these digital solutions have done for us is that they've cannibalized that whole huge investment requirement. So there's something now that we call the software as a service. that you pay pretty much like a pay-as-you-go, and there are all kinds of packages. So if you went to Microsoft, for example, and you wanted a particular set of a bundle, they would give you a bundle for small businesses. Because more than ever before, each of these software houses are finding out that the growth area is actually with the small and medium businesses. So software as a service, if you just go Google software as a service, and you will find a whole bundle of versions of every software that you require that you can pay as you go for, to get together.
Great. Okay, so one more question here, which says, how do we manage blockchain and crypto-based transactions? This question is from Achema Abutu. How do we manage blockchain and crypto-based transactions? You know, during one of the slides, you mentioned around how cryptocurrency or blockchain poses a new business area for legal professionals. Yeah. So this person is asking, how do we manage blockchain and crypto-based transactions?
Well, I mean, you know that as far as cryptocurrencies are concerned, there are currently regulations around all of that in Nigeria. So I'll speak more around the blockchain. Already, there are organizations in Nigeria who are exploring that. I know, for example, that the land registry in some states are actually heavily investing and considering using blockchain to store land registry documents so that there's consistency. There's the risk of having fraudulent documents in storage is reduced significantly. So I think, again, like I said earlier, it would significantly help if you speak to tech advisory, tech consultants, and they will help you. I do know that there are many organizations who are exploring blockchain as a way of storing records. Even in the educational sector, I know that some of that is happening at the federal government level as well. So that is what I know about that for now.
Okay, great. Thank you very much, Fola, for the insightful responses to the questions. So I think one of the participants is asking if they can get a slide to this presentation.
Well, I do know that you can take a screenshot of this slide that is here. I would leave it to the organizers to decide how much of this they want to share. But we're happy to share in an uneditable version of what we're allowed to. Thank you.
Great, thank you very much, Shola, for this session. This is pretty enriching, and there's a lot of feedback from the comment section from participants. Thank you very much, everyone, for joining this conversation, and thank you very much, Shola, for making this conversation really, really meaningful as well. Thank you once again. Bye.
Thank you. Thanks. Bye.
Training session on building a digitally fit business. We're now moving on to another training and our last activity for today. It's PCL COVID titled the PCL COVID Framework, Managing Employee Wellbeing in Times of Uncertainty. And this is being facilitated by Rob Taiwo. Rob is the Managing Director of Phillips Consulting. He has over 20 years international experience working extensively in leadership positions for FTSE 100 companies and leading multinationals across the UK, Europe, and West Africa. His specialties include business strategy, corporate strategy, leadership development, transformation and change, operating model development, performance management, and cost benefits optimization. And he will be also assisted today by Nwaji Jibuno. Umaji is responsible for the classroom training division at Philips Consulting. He's a business leader with over 18 years experience in developing learning intervention strategies and leading teams across several functional areas to deliver optimal client-focused training retreats and psychometric assessment. He's done this in the US, the United Arab Emirates, South Africa, and Nigeria. Umaji is a head of training for Philips Consulting Limited. Thank you.
In 1987, the late Alawa Kabasho was elected as the president of the Nigerian Bar Association at Premier Hotel in Ibadan. Following that, in 1988, I was privileged to be elected as the chairman of the Ilorin branch of the association. Events went on very well.
Can you see us now? Okay. All right. Good evening, everyone. We hope that everyone is doing very well. It's been a very long day, and I'm sure that you guys have been part of a very wonderful session. So we'd just like to thank everyone at the MBA conference for this wonderful opportunity, and also good luck to all of you who have signed in from all over the country and also all over the world participating in this very interesting conversation. So one of the things that we wanted to do in this particular workshop is just to have a very casual conversation, somewhat of a fireside chat between my managing director and myself. So just to quickly introduce myself once again, my name is Waji Jibodon and I head training at Philips Consulting.
And my name is Rob Tyrell and I'm the managing director of Philips Consulting.
And we're going to be talking about three specific things when we begin to look at managing employee well-being in times of uncertainty. And we're going to be looking at it from the focus of people, because it's all about people, especially as you move towards the second curve, this second curve of business growth. And then we're also going to be talking about the role of corporate culture and people improvement, because culture and people improvement are intricately connected together. And then we're going to look at leadership characteristics and how that now begins to drive performance in the organization. So these are the things in which we're going to be talking about today. But one of the things I think we should just get started on, you know, especially as we know the situation that we are in now with COVID and the pandemic and the lockdown, even the mere reasons why we are having these particular conversations and why we are having this virtual conference is because of the environment that we find ourselves in. So my question to you, Rob, as a business leader, is when this whole thing started, especially looking at it from the top view, what was your thinking and what were your thoughts?
Okay, thanks for that, YG. So I think the first thing was just actually really trying to anchor it. When I mean anchor, just trying to understand what exactly were we looking at. As you can imagine, it was strange and uncertain. And there was no language for it. I mean, if I asked you a few months ago, you know, what was a COVID? Right. You know, you'd have no clue.
Zero.
Or exactly, or sort of, sort of coronavirus, nobody had a clue. So I think the first thing was just trying to frame it and just trying to understand what exactly were we looking at. I think it was also very important to understand the human story, because actually, first and foremost, you're talking about humans. And there's a significant impact, there's a health impact. And that mustn't be lost in the discourse. So the first system was trying to frame it, how do we keep people safe? Following on from that shortly, it was just trying to understand, I guess it was taking a step back from a sort of research analysis perspective and trying to figure out where has this happened before? What are we seeing? And With that in mind, it was taking a quick look at what I told the World Health Organization. They kind of did, it happened in 1918, as you can imagine. It is a big thing about, the Spanish flu. And it's very interesting because there's a trajectory. And the trajectory, if you just, slide please, yeah, this trajectory. And the trajectory, if you look at it in terms of numbers, there's something happens at the beginning. In the beginning, if you look at number 1, that's kind of when there's human transition. So it's moving from person to person. The second thing that happens is it's almost like the second phase, and that's sort of when you get to peak. And if you can imagine what happened here in Lagos, that's when we actually had a lockdown. And then it moves to the next stage, and the next stage is kind of called post-peak, and that's kind of probably the space that we're in now.
Right.
And then you move to sort of post-pandemic. The difficult thing is that, and this is a trajectory we've been on. The difficulty is, if you look, sort of, there's a red blob, is that it can happen again. And so if you think about what's happened in Australia, for example, they've had a second lockdown.
Right.
So I think even if organizations haven't particularly framed yet or haven't anchored, said, what are we looking at, and haven't sort of dimensioned it, it's not too late to understand the trajectory. So I think the trajectory is one thing. And then the second thing is saying, what does it mean from a business perspective? And the same way that that if you look at it from a health perspective, what they've done is they've dimensioned it into 4 phases. Same thing you can do from a business perspective.
Of course, right.
So what we did at PCL, so once we'd framed it and we kind of understood what the trajectory of the pandemic would be, and we kind of understood what the human story would be, and this is actually about people, it's not about business, it's about people. We then decided to look at it from a business perspective, and I guess there's 2 elements to it. One is trying to figure out what is the problem today as you see it. And the second point is kind of thinking about, second part is sort of thinking about what does the future look like? How do I protect myself against the future? 4 stages. So the first thing we did was we said, what are the components of our organization that we wanted to retain? And so if you think about it from a perspective of people, process, technology, heavily driven towards people, but that's when you're sort of looking at crisis management, business continuity plan, a lot of risk assessment. And essentially in that first phase, what you're doing is you're sort of unplugging the organization. So imagine almost like taking an engine out of a car, you're unplugging it. And then you're saying this engine is going to operate somewhere else. And this engine has to be sustainable in its new environment. And that's the second phase, which is sustain. It's quite interesting because that time, everybody's working from home, so there's lockdown. And some of us, many of us are still working from home, there's a lockdown. So you're actually looking at the sustainability element of the engine. And you're sort of looking at your processes, so it's your people.
And that's also following a curve as well.
Following the curve, right. Following the curve. So you're looking at your people processes, your IT processes. You're looking at cost optimization. How can we reduce cost in non-value add areas? But more importantly, staff well-being is absolutely critical. In the staff well-being component, I think there was an interesting study that we sort of did right at the beginning of this pandemic, and I'm sure its numbers will show up a little later on. And we found out that 97% of employees were suffering for some kind of psychological stress. So at that point, and there's a number of different reasons why that would happen. Obviously, I think one of the things we're starting to appreciate now as staff is just human interaction and the ability to collaborate, and all that went out the window. And you've got anxiety, there's obviously anxiety as well because you're dealing with health impacts and you're dealing with people. So that's sustainability. How do I keep staff motivated? And also there's a governance aspect to that as well. How do I ensure that everybody's accountable and staff are still doing the things that they're meant to be doing? Then you're thinking about post-peak and reboot. And the reboot side is, so you have a set of products and services. And also there's different kind of customer relationships that you're in at that point of the lockdown. And your thinking is, how do you accelerate quickly? So how do you keep it going? So how do you keep those conversations going while there's a lockdown or while things are uncertain? I remember a head of our digital technology consulting practice turned to me during the meeting. His name's Jason. And Jason said to me, he said, well, by the end of all of this, how are you certain that that clients are going to come back to us? And he was talking about disruption, and disruption from a little known company somewhere that's not on our radar, that we've used this as an opportunity in order to leapfrog. And I thought it was a very valid point. So the point is you've got to keep yourself relevant, and Reboot is around it's about being able to accelerate quickly as things normalize. And at the same time, as I said, making sure that sort of you're front and mind in the consciousness of your clients and your stakeholders. And then there's recovery. Recovery is where you're thinking outlandish things. You're sort of, what does the next couple of years look like? And now it's time for me to think ahead. And you know all about this because you're head of the recovery team. Right. And it's about how do you sort of identify the products and services for the future? And once you've identified those products and services, how do you sort of deploy them quickly to reduce that time to market? And also, how do you put processes as well in place just to ensure that you can sort of, as I said, drive that?
And part of those processes is governance structure around making sure that you consistently deliver on these recovery components as well.
Exactly, exactly. And I think the key thing is driven by people. And what I mean by that is, if you think about it, the first two teams, retain and sustain, they're what I call, let's deal with the issues of today. So that's looking at operational issues of today. The reboot and recover team are sort of what I call the think ahead teams. So those ones are sort of looking into the future and saying, this is what's going to happen. Each team, and we've adopted what I call a task force approach. So each team has a leader, has members of that task force. They are self-accountable. They're full accountable, self-accountable. They're fully autonomous. They're agile. They can take quick decisions. They don't need to boot up to a leadership every 5 minutes to say, what do we need to do? So that enables you to sort of be in that moment.
Okay.
Back to this point I made earlier on, which is about framing. One of the things we sort of, I think we launched it today.
Yeah.
Was our, today, yeah.
Yesterday.
Yesterday, we launched it yesterday, was our sort of CEO report. So what we did is we spoke to 100 CEOs. And with those 100 CEOs, we pretty much tried to understand, sort of how was it impacting them? What do you think was going to happen in the future? A bunch of questions. And it was made for some really interesting insights, which I think are cut across sectors. And just to pick out a couple of things, I think the first is around ICT. So when we asked the question to the organizations, the response was that ICT, 86% of the organizations feel that, or CEOs feel that there's going to be significant impact in the ICT space, and that's the first thing. So as we can see, there's an acceleration of technology adoption. The second thing was equally interesting was layoffs. So you can almost imagine, if you think about where there's sort of been events of this magnitude / recessions in the past, immediately organizations are thinking about layoffs.
The first thing to lay people off, right?
What we've seen is that in this particular instance, 78% of organizations are saying, no layoffs, which is very interesting. And I tell you why that's interesting, because you're kind of seeing a shift from shareholder value to stakeholder value. So in the old days, you'd say, well, if I look at an organization from a shareholder perspective, I'm looking at, the investors and the owners, et cetera, and they're front of brain. Stakeholder perspective was where you're saying, I'm expanding the remit. Who are my stakeholders? Employees, my suppliers, my customers. So you're taking all of these into consideration as you're making your choices. And for me, this is an interesting shift. And the other telling thing is what's happened in Nigeria, and that shift, I believe, that we're seeing subtle shift from shareholder value to stakeholder value is also being mirrored globally. Right. So the numbers are pretty much the same. The other thing is remote working. And I think remote working for many has been the game changer. I mean, who knew? Here, 83% of organizations have sort of started remote working in some shape or form. Again, that mirrors global numbers, which is very interesting. If you'd asked maybe pre-COVID, asked the question about remote working.
Numbers have been very low.
Numbers would have been low, number one. And number two, some would have argued it's not competitive because nobody's doing it. So why should we be the first? And there would be big concerns around governance. Will people at home do the things that they're meant to do?
That was always the fear anyway, that people worried about with governors, will people actually do the things that they're meant to do?
Exactly, right. Exactly. And I think this has shown that it can work. One last thing I'll say about this, which I think is very interesting, is that I think what organizations are doing is they're saying, what are the value add areas of the business? Because if you think about ICT, and we're seeing technology adoption in the ICT space, what that tells us is there is investment coming from somewhere, right? And we know revenues are down.
Right.
So what that tells me is that organizations are sort of saying, what are the sort of non-value add areas? So we've seen a reduction, for example, in business travel. What are the non-value add areas? Let me save money there. Let me spend money.
And this is what you
value
call
areas.
natural cost savings.
Natural cost savings.
Right, that's what you call your term natural cost savings.
Natural cost savings.
Right.
And then you sort of move it into the high value areas. So I think that's what we're saying.
All right, cool. And it's interesting that you bring that up, Rob, because I think it positions us to what the pandemic has actually done. You know, it's kind of forced us and forced many organizations, Philips Consulting in particular, you know, to explore new areas of business growth. You know, you talked about recovery and you talked about reboot, and you know, being part of one of those teams is that we've really had to think about, going back to the point that you made about Jason, about what is business going to be like? Will our clients come back? And one of the things that we really had to do was truly reimagine and repurpose a lot of our services. So I'll give a classic example with training, training that we have been doing for a very long time, where we ran multiple sessions in multiple locations, Lagos and Abuja, or sometimes in other countries where we had physical interactions. But given the shutdown where those physical interactions could no longer happen, we now had to really, really begin to think, how can this particular service still remain relevant? And it's now talking about business growth and creating a new service. And it's what gave birth to our virtual platforms, you know, services like our micro courses and everything else. And that's when you now begin to move into the second curve of business growth. And I think that's the real important thing when you now begin to ensure that your people are engaged, is making sure that they are continuously on the cusp of innovation, because it's through that innovation that you will now begin to get the business growth that you're looking for. And I think we have an interesting video that speaks to business growth that we'd just like to quickly share.
The second curve is an embarrassingly simple notion. It's based on a book I did about 15, 20 years ago, actually now. And the notion is very simple. The argument is that most businesses in most industries are going along quite nicely on the first curve, which is the business they know how to operate on a daily basis. It's where they make all their profit and revenue. But they have a sneaking suspicion in their gut that that curve is going to decline in absolute or relative terms. So the first curve coming down might be not a reduction in revenue, but a reduction in growth rate or a reduction in margin, if you're speaking in a business sense. And the argument is that that anxiety is really about the replacement of the first curve by a second curve, a new business or a new way of doing business that is radically different from the first. Now, the dirty little secret of futurism is that we cannot actually predict the future. And there's a natural human tendency to overestimate the impact of phenomena in the short run and underestimate it in the long run. So what you do is you commit two types of strategic errors. You panic and you walk away prematurely from that first curve, only to walk away from all the profit and revenue. Conversely, if you don't start building that second curve, you're not going to be around later on in the 21st century.
So,
fantastic video.
Fantastic video and a lot of food for thought. I think I'd like to go back to what I said before and the point I made about framing and anchoring. And the truth is, there's not many things new under the sun. COVID-19 was new, but some of the underlying elements and impacts, I'd say almost from a management theorist perspective, you've kind of seen some of these things before. What do I mean? So in 1942, there's an Austrian economist and it's called Georg Schumpeter.
This is during the World War.
Yes. So Georg Schumpeter, and Georg Schumpeter coined this phrase, creative destruction. So creative destruction, essentially what he was saying was that some new phenomena comes into a marketplace. And as new phenomena comes into a marketplace, the markets are disrupted. And some businesses will be destroyed and some new value will be created. So that's the sort of interesting phrase, creative destruction. And I feel that's what we're kind of experiencing now, an element of it. So in some sectors.
So run that back again. So basically you're saying that in as much as COVID is new, so to speak, but the underlying effects of it with regards to the disruption is not new.
It's not new.
Okay.
It's not new.
Right.
And there are good, as I said, good lessons to be learned from history. So Schumpeter's argument was basically this. He said, for any organization, I think this applies now, and I think it applies definitely to the legal industry. For any organization now, there's two things they need to do. One is they need to be in the exploit space, and the other element they need to be in is the explore space. So the exploit space is where you're kind of looking at your existing business. So what do we do at the moment? I mean, if you look at the video, you said you don't want to destroy value. So what do we do at the moment? And let's sort of work and invest on these quote unquote operational matters. Let's work on invest in our existing products and services, and let's push those things into the marketplace. And what do you need to operate in that environment? So you need, it's highly efficient, it's highly systematic, it's low uncertainty because you know exactly what it is you're selling and what you're investing in. And in terms of management, it's managed, you know, traditional, old school, those terms that we know, planning, control, coordinating. And interesting enough, it focuses on profit for today. So coming back to what I said right at the beginning, and I talked about, you know, reboot, and I talked about recover. This is pretty much exploit. Schumpeter's talking about reboot, where he's pretty much focusing on today. Today. Exploit is where recover. That's what you're doing. So you're looking into the future,
right,
and you're figuring out what is that next curve going to be, just to ensure that we don't miss the second curve. And exploit, you require it's a different animal. So what are the components of it? One, you've got to be prepared to fail. Two, you think about uncertainty, and it's high uncertainty. It's calculated, but at the same time, uncalculated risk. You need a different kind of manager. You need somebody who can sort of navigate and understand the big picture, somebody who can understand randomness, and somebody who can understand patterns. And more importantly, it's focused on profit, but profit for tomorrow. One of the questions that boardrooms need to ask themselves up and down the country is, what is that ratio of investment going to be? So when I think about exploit, when I think about explore, so if I have 100 now, 75 now, I might spend on exploit, 25 now, invest in the future, in the explore space. But it's a conversation that needs to be had.
And it's a function of your individual ambition, pretty much with things you're trying to accomplish.
It is, because if you focus entirely on
exploit,
exactly, profit today, then essentially you could miss the curve and lose out on profit tomorrow.
Yeah. Okay. So you wanted to talk about technology, because I know that's one of the things that we cannot avoid when having this conversation. I know we've seen a lot of sessions where digital came up, but I think it's important, especially as we're connecting all these conversations that we are having about people to technology.
Yeah, so you can't avoid technology. And I think there was an interesting study and basically said, I think by 2025, machines are going to be doing more work than humans. And that has a variety of different impacts on the future of work, for example, etc. You know, so what skills do we need to have in the future? And as I said, that's been discussed. I think one of the open questions, obviously, is always, when you think about it from a local Nigerian perspective, what does that mean? I think Africa is more complex, Nigeria is more complex, it's more nuanced. And so therefore the trajectory is going to be different. I wouldn't say slower, it's just going to be different. So for example, if you think about banking, we've leapfrogged some so-called quote unquote other Western spaces. But if you look at manufacturing, it's probably going to be a little bit slower for a number of different reasons. But the interesting thing is it's not slowing down. Technology adoption isn't slowing down here in Nigeria. Case in point, if you look at GDP, for example, in Q1 2020, with all the different challenges that were involved, ICT GDP was still, I think, was number 2 on the list. You know, in terms of, I think, 14.1% exactly Q1. Strong GDP contribution in 2019 as well. Very interestingly, there was a list that was kind of recently released, and it kind of looked at the number of global internet users. Nigeria came 6th on the list.
Right, I saw that.
And we beat a lot of so-called quote unquote
developed countries,
more developed countries.
Right, yeah.
126 million users.
Incredible.
If you look at what we showed before in terms of sort of adoption of working from home, I think it was 83%. What you can see is collaborative technologies are being used aggressively in Nigeria. Sort of your Zoom, your Teams, your WebEx, et cetera, et cetera, et cetera. These collaborative technology tools are being used. So it's not slowing down. I think it's here to stay. I think it's a fallacy if we turn around and say, well, what we're seeing, so these predictions around the future of work, where we're saying 133 million jobs are going to be created and 75 million jobs are going to be lost. If we're saying that doesn't apply to Nigeria, then we're not being realistic.
And it's interesting because, especially as we're on this particular MBA conference, I think it's important that that adoption and that level of conversion, even in the legal industry, and you trained as a lawyer, didn't you, Rob?
I was hoping you wouldn't bring that up.
One of his little secrets.
One of my little secrets.
And it's interesting because, especially in the legal world, when you begin to do the research and the data, which some of what we've done, you see that adoption is going to take off. It's not where it should be right now, but hopefully with a lot of these different things that we're seeing, and also with COVID, there is a hope and anticipation that that particular industry will now, or the legal industry will now begin to have a lot more adoption.
Well, the thing is, just to touch on that, it's already happening.
Yes, it is.
So, so COVID has, it's accelerated technology adoption.
Right.
It's accelerated the digital conversation. There's a lot of conversations around virtual hearings.
Yes.
And as we know, there was a Supreme Court ruling recently.
Virtually.
Yes.
Yeah.
Ruling recently that basically said, virtual hearings are not unconstitutional. So that opens the space for that to happen.
Yeah.
Bit slow adoption. We're slightly behind in adoption when you compare us to maybe some couple countries in East Africa, and maybe when you compare us to sort of what's happened in some sort of so-called developed countries.
Right.
But the conversation is going on. And if you look at some other areas, so if you look at the labor courts, for example, where 90% of trials are kind of document-based, it's been actively virtual, has actively been used, in those spaces. So it's happening in pockets.
And that's good. Ultimately, because technology is going to transform the way you do business. It's going to transform the way you provide services and everything else. And I think this wonderful video on the impact of technology, specifically on how it transforms business across many sectors, is very relevant.
Well, in the coming years, computer chips will cost as little as a penny. That's cheaper than garbage, cheaper than scrap paper. So computer chips will be everywhere and nowhere, including our contact lenses. So when we put on our contact lenses and blink, we will go online. And who were the first people to buy internet contact lenses? College students taking final examinations. This means that my students will blink and they will not have to memorize all the things I've been talking about. This is going to revolutionize education because we cannot force students to memorize things that they can simply blink and get. And then if you feel sick, you will blink and see RoboDoc. RoboDoc is artificially intelligent, talks to you in plain English or Russian or whatever, speaks any language, accesses the entire internet for sound medical advice, almost for free. This is going to revolutionize the medical establishment. We'll still have doctors, but doctors will use RoboDoc as an aid. And if you're in a car accident in a foreign country, you don't speak the language, you'll talk to your wristwatch and talk to RoboLawyer. RoboLawyer understands the law in any country, in any language. In fact, I personally believe that artificial intelligence, the robotics industry, will eventually become bigger than the automobile industry of today, because your automobile will become a robot. You will talk to it. You will argue with it. You'll have discussions with your car about the best route to take. And when you want to park the car, you simply tell your car, park yourself, and the car parks itself. This is going to revolutionize urban economics when you don't have to worry about parking anymore. And then the next organ to be digitized is the brain. You may not know this, but 2 years ago, scientists were able to upload the first memories. Memories can now be uploaded and downloaded. This makes possible BrainNet. BrainNet could be the next step in the evolution of the internet. Instead of zeros and ones, instead of text, you'll put emotions, feelings, sensations, memories. Teenagers will go crazy. Teenagers put happy faces at the end of every sentence. Why bother to do that when you can put the emotion of your first dance, your first kiss, your first whatever right there on the internet? And so in the future, when you walk into a room, you will mentally command the internet. You'll take dictation mentally. You'll turn things on, turn things off, communicate with other people. People will think of you as a wizard of some sort, mentally communicating with everything around you. That's BrainNet. And then biotech is being digitized now. We can create a human body shop. We can create from your own cells, so there's no rejection mechanism. We can create skin, bone, cartilage, noses, ears, blood vessels, heart valves, bladders, complete windpipes can be grown in the laboratory. The next organ to be grown, by the way, is the liver. So for all you alcoholics in the audience, take heart. We may be able to grow your next liver. So even the economy is now being digitized into something I call perfect capitalism. You see, capitalism is based on supply and demand, but you don't know who's cheating you when you buy something. You don't know what the profit margin is. In the future, your contact lens will scan everything in a store, tell you who's cheating you, tell you who has the best product, what is the profit margin on every single thing that you can scan with your contact lens. And so capitalism becomes perfect supply and demand. This means that there are winners and losers. The losers will be middlemen. Because why did Amazon become so big? Why did Airbnb? Why did Uber become so quickly so large? Because they digitized the middlemen. So I tell my friends, if you want to become a billionaire, take an industry, take any industry, write down all the places where there's friction, where there is middlemen, where there's obstruction, where there's frustration. List all the places in any industry, digitize it, and you too could become another Amazon founder.
Thank you, Professor. In good futurism, that is a future with both inspires and terrifies. So thank you.
And you know, Rob, I've seen this video so many times, and it gives a lot of hope, and it gives a lot of anticipation, and also going back to the point that you made about how quickly things are happening, the acceleration, how quick technology is coming up. But then going through the research, a lot of employees, a lot of organizations are still not ready for this digital transformation. And the studies have shown that 26% of digital mature businesses, right, are more profitable than competitors. Okay, but at the same time, in order for you to become a digitally mature business, it has to now be positioned, especially as we're going into this recovery stage, by leaders, by the people. But then you still have 70% of business leaders who do not have the skills to now be able to transform their organizations to digital companies. So how, isn't that mind-blowing when you now begin to think about that? And what does that now begin to point towards the different things organizations need to do?
Okay, so I think there's a number of things which organizations need to do. I think the first thing is just framing it as it's a people issue. So if you think about digital transformation, overwhelmingly what happens is they focus on the technology. But I've long said that it's not transformation. Digital transformation is a technology conversation. The technology will take care of itself.
Yes.
Actually, what it is, it's a people conversation. I'll tell you something interesting. So if you think about Kodak, people say Kodak missed the curve, and they'll talk about how they were disrupted. But the interesting thing about Kodak, they owned 30% of the global digital patents, 30%. So it wasn't that, from a technical perspective, that they were behind the curve. One company on 30% of the digital patents. So they weren't behind the curve. The challenge was people and the aspirations of people. So you had a huge company, highly structured, a lot of hierarchy, number of different divisions. And the people were focused on—
They had like 26 or something?
Exactly, 26 divisions. So the people were focused on, how do I go up the ladder? They weren't focused on the bigger sort of organization.
There was no nimbleness to them, a lot of no agility.
Yeah. Nimbleness, agility, but also focus. What were they focused on? Are you focused on the technology transformation and digital that's happening in your space? Or are you focused on, or the people focused on going up the corporate ladder? So I think that's sort of where the challenge was. And the other thing I'd say is, it's not easy. And let's not fool anybody. Digital transformation is, by any regard, in any regard, it's complex. Some of the points I believe has been, it's been adequately covered during the session, but it is complicated because you're dealing with aspects of resistance, change, training, process evaluation, new technologies, and the list goes on and on and on and on. If I go back to what I said before, between the difference between exploit and explore, so if I'm sort of a leader and I'm being judged on results today and profit today, why would I spend a portion of my time and resources focused in an explore space, which is uncertain and might not generate the returns?
I feel like you're avoiding a C word here. To speak to all these different things that you're connecting. What does it have to do with that, with culture?
It does.
Okay.
Culture is, so I think a simple definition for me, culture is what you do when nobody's watching. And I think that's, for me, that's kind of it. I remember, there's CIPM did some research a few years ago. And the research basically said 75% of the workforce, are not connected to the goals and aspirations of that organization. And that is a number you think is quite high, but it's actually very consistent.
Right.
A French executive once said, my people turn up in order to go home.
Right.
Culture is very important. Culture impacts people, and people impact transformation and change.
I think this video, I absolutely love this video. It now begins to speak to the how culture really is at the heart of employee commitment. And I just want to quickly play it, just so you point.
I was asked to chair a conference by HSBC Bank. Big, safe, secure, slow. But they have a wholly owned subsidiary called First Direct. Fast, brilliant with their customers, the most expensive bank to bank within the UK. They started off as a 24/7 telephone bank. They morphed into the 24/7 internet bank. For 4 years on the trot, they've won Financial Services Company of the Year over here in the UK. They have the lowest churn of any bank. They're very expensive and no one leaves them. I needed to know more. They're very different to HSBC. They're not global. They're only based in Britain. I was chairing a pretty feisty exchange between the finance function of HSBC really coming down hard on the top team of First Direct to move to IVR, this automated voice response for your telephone service. Well, First Direct were resisting it. They said, one of the things we stand for is when you dial First Direct, within 3 rings, you'll get a human voice. It's absolutely imperative to what we do. So Chris Pilling, who was the chief executive of First Direct, I was really pushing. And I could see that I was tempting into the quicksand with HSBC, the parent company. But he told this fabulous story. He said, on the tragic day of 9/11, there was a First Direct customer in the second tower. When the second plane hit the second tower, some machinery fell on top of her. She was losing consciousness, but she had her mobile phone. And she had the wherewithal to make one call. And that one call was First Direct. When she called them, The operator answered, and she said, I'm in the second building, some machinery fall on top of me, I'm losing consciousness. Can you get my husband and my children on the line? She said, my colleague's calling your husband as we speak, and another one of my colleagues is calling your children. The operator noticed she was drowsy, she was losing consciousness. She kept her talking for a further 45 minutes, because a third one of her colleagues had emergency services. And in 45 minutes, she was rescued. Now, I think I know what First Direct stands for. What do you stand for?
What do you stand for?
Right. It's about culture.
Yeah.
And culture breeds behaviors.
Yeah.
And I think, as we move into that second curve and we take into consideration all these elements we've spoken about, employee well-being, it's about changing behaviors, isn't it?
Yeah. And I know it's a bit of a cliche, but unfortunately, it starts from the top, right? And I think part of the challenge we have is when you just think about sort of where do our leadership, you talk a lot about leadership philosophy. And the question is, where do our leadership principles, where do they come from? Where do they start from? Where do they emanate from? Where do we learn them? And the truth is, if you go back to sort of and understand sort of leadership theory, if you go back, a lot of principles we have now were started about 100 years ago.
Right.
Exactly. For a chap called Henry Fayol, and they sort of coined it as Fayolism. I hope I'm saying that right, Fayolism. Anyway, the point is, when you think about the tenets, planning, coordinating, control, authority, manage subordinates, telling them what to do, etc., etc. For many organizations, that's where we still are now, let's be honest. And if you go back to culture, we say there's two spectrums. You have almost an autocratic culture and what I call an adhocratic culture.
Right.
Autocratic culture is where you're that's leadership for that space, is you're in that traditional space. Maybe autocratic, authoritarian. The converse being an adhocratic culture, where you're starting to move towards openness, inclusiveness, empowerment of people. And all of these things impact well-being.
Let me just ask you, just in line with that, you're looking at all the social revolutions in the world, right?
Yeah.
That are taking place, things around, the racism issue that, Black Lives Matter, and then the Say No campaign and everything else. How do you think the generation of the future, or the generation of now, connects to this adhocracy that you're referring to?
Well, it's mirroring that. So if you think about it, the argument is a lot of the charges being made and taken by young people.
Yes.
People our age, the old fogies.
Right. Well, we don't have a say more or less, right?
We're following.
Yeah.
We're following.
We have to. Yeah.
We have to. And it's back into that space. And now these, if you think about it, those people who were sort of leading the revolution you just talked about, what are we talking about? We're talking about the workforce.
Yes.
We're talking about people.
Right.
And essentially, what are organizations? Organizations are living systems.
And those are the people we have to lead.
Exactly.
Right.
And they're living systems. Organizations are living systems. And leadership is important because leadership sets the tone and it defines. So what you need to think about is, how do we move away from the Henry Fayols into this new space? And there's a new space, I wouldn't necessarily call it a new space, but it's a different kind of leadership that we sort of move towards. It's a leadership where employees are being challenged. There's a focus on aspiration. You're sort of painting an exciting vision and picture for the future, and all of these things add to well-being, and I'll tell you why. Challenge. Studies have been shown, have demonstrated time and time again that, and I know there's Maslow's hierarchy of needs and all that, but the point is, people don't actually work for money. I know that sounds surprising,
but it's very true.
And I know it sounds controversial,
right.
But actually people work for challenge. So if you want to, so moving away from the fluffy stuff, if you want to impact well-being, you want to impact your workforce, challenge them, allow them to contribute, allow them to feel included in the conversation. Case in point, fantastic bunch of pictures. One element to pull out is Satya Nadella. So he's the current CEO of Microsoft. And I think it'd be fair to say he was a bit of a wild card. He came behind, well, his predecessors were Bill Gates and Steve Ballmer. And, the argument is to suggest that, very technical environments under Bill Gates and Steve Ballmer, very focused. And I wouldn't say, I don't want to use the word, autocratic, but it was a tougher environment. Nadella, he kind of shifted the conversation. He shifted it away from, to say the harder technical elements, still very important, but he focused on people and he focused on culture. And I think that's as a result of his background as well. Very strange, if you think about it, especially in this kind of, you can imagine the rough and tumble world of technology and how kind of cutthroat it can be. But let's look at the results. So when he took over, Microsoft worth, circa 300 million. Now it's over 1.2 trillion. And I'm sure that's a known number. It's probably even higher than 1.2 trillion. Yeah. Share price has gone up by 300% by focusing on people and focusing on culture, because that's what drives the results.
It's just fascinating, because I think I wouldn't say that what a lot of people don't realize, but maybe what a lot of people don't connect is that people do make the difference.
Yeah.
And making sure that your employees are well taken care of, and you create systems around your employees and you allow them to really flourish, it directly connects to the bottom line.
Yeah.
There is an intricate, connection between those two things. You cannot argue against it. And I think the Microsoft example is a wonderful example of that, because by the time you now begin to focus on people, but you build that on a foundation of very strong systems, then you now begin to see the results you're looking for.
100%. I totally agree. And I think it's just, how do we kind of move the argument, and how do we shift the needle, and how do we move from failures, which you're talking about sort of traditional form of leadership, where you're talking about, you can tolerate stress and you're highly intelligent, very conscientious, and it's the kind of leadership we know and love. And quote unquote, maybe the leaders, time gone by, we might celebrate.
Right.
We might celebrate.
The old guys.
The old,
right?
well. And how do you move towards a more transformational type of leadership? As we kind of showed in some of the figures we showed before, Obama's, etc. How do you move to more transformative type of leadership? And in that kind of model, you're listening, you're persuading, you are rolling up your sleeve, and you're kind of getting involved, and you're taking people on a journey. And it's a journey of change where they kind of feel included and they feel part of that journey. You can take it a step further, which is servant leadership. And there you're thinking about, how can I build communities? But also, more importantly, the leader sees himself as a servant. The role of a leader isn't, I know this will sound counterintuitive, but the role of a leader isn't necessarily always to lead. The role of a leader is to unlock leadership within the organization. Everyone's a leader, but how can you empower? And the thing is, we're not saying it has to be an either or. So sometimes the argument is, well, traditional elements of traditional leadership are still required, and that's true. You still need to plan, you still need to coordinate, and do all the harder stuff.
You can't walk away from those.
You can't walk away from those things. But as you move towards a space of uncertainty, where you're taking people on a journey, where impacts will be at various levels, with various levels of intensity, you have to almost like pick and mix. So it has to be a combination of the three, of transformational, of servant leader, but also picking key components from traditional leadership as well.
Okay. Well, I want to show a slide. I really hope that there are not any, well, I'm just going to let you handle this, right?
You want me to?
I do not answer any questions of such. I know what you're about to ask me.
You want me to offend all the Magnanites?
Offend away, offend away.
Okay, so I think the only thing I will say is, Jose Mourinho. The only thing I will say very quickly is Jose Mourinho. And when you sort of think about one of the complaints basically was that he wouldn't change with the times. Very true. There's a fantastic bit of research by a lady called Amy Edmondson. I encourage everybody to look at it. 1999. And what she did, she sort of did an analysis of 3,000 teams, and basically was saying the high-performing teams, psychological safety. That's the thing that they look out for, psychological safety, which is back to the point I was making earlier on, which is about inclusion. Employees perform when they're included.
Okay.
Guys, you can have 5 more minutes.
Okay, we're going to wrap up. We're going to wrap up now. Thank you so much. Okay, let's go back to the... Here we go. All right, thank you so much. Just to quickly wrap up, we just have one more video just to show that more or less captures about this transformation. Right, Rob?
Yes, so I mean, it's, again, I think everything that we've discussed as a case in point comes into it. I think if you think about it, we've talked about the importance of people, we've talked about the importance of culture, we've talked about the importance of vision, and we've talked about how you take people on a transformational journey. And this is a short video where it pulls all of those three elements together. Short speech, JFK in 1960.
One of the best speeches ever made.
1962 Vice Stadium.
We meet in an hour of change and challenge, in a decade of hope and fear, in an age of both knowledge and ignorance. The greater our knowledge increases, the greater our ignorance unfolds. No man can fully grasp how far and how fast we have come. But condense, if you will, the 50,000 years of man's recorded history in a time span of but a half a century. Stated in these terms, we know very little about the first 40 years, except at the end of them, advanced man had learned to use the skins of animals to cover them. Then about 10 years ago, under this standard, man emerged from his caves to construct other kinds of shelter. Only 5 years ago, man learned to write and use a cart with wheels. Christianity began less than 2 years ago. Printing press came this year. And then less than 2 months ago, during this whole 50-year span of human history, the steam engine provided a new source of power. Newton explored the meaning of gravity. Last month, electric lights and telephones and automobiles and airplanes became available. Only last week, we developed penicillin and television and nuclear power. This is a breathtaking pace, and such a pace cannot help but create new ills as it dispels old. So it is not surprising that some would have us stay where we are a little longer, rest, to wait. If this capsule history of our progress teaches us anything, it is that man in his quest for knowledge and progress is determined and cannot be deterred. We shall send to the moon, 240,000 miles away, a giant rocket more than 300 feet tall on an untried mission to an unknown celestial body, and then return it safely to Earth. But why, some say, the moon? Why choose this as our goal? And they may well ask, why climb the highest mountain? Why 35 years ago, fly the Atlantic? We choose to go to the moon. We choose to go to the moon. We choose to go to the moon in this decade and do the other things, not because they are easy, but because they are hard. Because that goal will serve to organize and measure the best of our energies and skills. Because that challenge is one that we're willing to accept, one we are unwilling to postpone. And therefore, as we set sail, we ask God's blessing on the most hazardous and dangerous and greatest adventure on which man has ever embarked.
I still get chills every single time I watch that video. It's truly transformational.
Consulting. Many thanks to Rob Taiwo, Managing Director, Philips Consulting Limited. and Nwaji Jibuno, Head of Trading at Phillips Consulting Limited. Now, with that, we've come to the end of activities for today. We'd like to thank all our guest speakers, our panelists, our panel moderators, and of course, our delegates who have made the 60th Annual General Conference of the Nigerian Bar Association a success. Now, of course, activities continue tomorrow between 9 a.m. and 11 a.m. tomorrow. We'll have the section on business law annual general meeting. We'll also have the section on legal practice annual general meeting. Also the MBA section on public interest and development law annual general meeting. And of course the MBA Women's Forum annual general meeting. I'll now hand you over to George Etomi, founder and principal partner at George Etomi and Partners, for his vote of thanks.
Our great members of the greatest law association on the continent, it is my pleasure to bring this conference to a close and to give our appreciation to a number of people. But before I go into the appreciations themselves, I'd like to give you some interesting statistics about the conference. First, as you already know, this is the first virtual conference of the Nigerian Bar Association. We recorded 25,371 registered persons, 18,306 unique visitors, and on the first day alone, we had over 140,000 page views. This is by all means a record in the history of the Nigerian Bar Association. Now, all these have been made possible by the sterling leadership that has been shown in these very difficult times by Mr. Paul Usoro, the outgoing president of the Nigerian Bar Association. We were very concerned at the beginning when the COVID pandemic hit the world, if this conference was going to happen at all. But we remained dogged and we stayed the course. And today, you're all witnesses to history. I want to start our thank yous. First, by acknowledging our President of the Federal Republic of Nigeria, His Excellency President Muhammadu Buhari, GCFR, who has always, since he assumed office, partnered with the Nigerian Bar Association in different fora. I recall very vividly in 2018 that he came personally to declare the conference open. This year, he did the same, but albeit through the Vice President, our very own Professor Yemi Oshibanjo, Senior Advocate of Nigeria, GCON, Vice President, Federal Republic of Nigeria. I would also like to thank the Vice President himself in his own right, because he has always been part of the Nigerian Bar Association story. We jump at him at very short notice and is always there. And I remember when I saw him in his office, just before the conference started, I told him, you know, we're going to be jumping on you again. And he says, just let me know when. Thank you. I'll also want to thank another member of the family, this time the Speaker of the Federal House of Representatives, the Right Honorable Femi Gbajabiamila, for also being so true to his word that he will support the NBA whenever called upon to do so. He has graced activities of the sections. He has also graced activities of the parent body. I expect no less from him, but I have learned in life to appreciate gestures like this because they mean a lot to us. I want to also thank the Chief Justice of Nigeria, Honorable Justice Tanko Muhammad. Again, he has been a faithful partner and ally of the Nigerian Bar Association. He's there with us, and in his opening remarks, he pledged his continuing desire to work with the bar to bring about desired changes that will move the legal system forward. Thank you, sir. And I'd also like to thank the Honorable Justice Monica Dogba-Mensem, President of the Court of Appeal, who has also sent goodwill messages to the Nigerian Bar Association. I want to thank the Honorable Attorney General and Minister of Justice, Mr. Abubakar Malami, Senior Advocate of Nigeria. And even though he couldn't be here personally, he ensured that he was fully represented and actively participated in the 2 days. I want to thank Dr. Isa Ali Pantami, the Minister of Communications and Digital Economy. Again, we jumped on him. He was there for us last year, again this year. I want to thank you, Honorable Minister. I want to thank His Excellency, Governor Nyesom Wike, the Governor of Rivers State, who, although he couldn't be here in person, was represented by his Attorney General, Professor Zacchaeus Adango, who truly gave a good account of himself. I'd like to also thank His Excellency, the Governor of Lagos, Governor Babajide Sanwo-Olu, because he too, even though he's not a lawyer, we've actually inducted him into the profession because of the manner in which he has supported everything we do. We call on him, he's there. He gave a very, very enlivening speech, and we know that Lagos State continues to lead the way in justice reform. Thank you, Your Excellency. I'd also like to thank the Honorable Justice Bibi Kanyib, the President of the National Industrial Court. I'd also like to thank Mr. Dayo Akpata, Solicitor General of Federation, His Excellency Peter Obi, former Governor of Anambra State, Mr. Tony Blair, former Prime Minister of the United Kingdom and Executive Chairman of the Tony Blair Institute for Global Change. I'd also like to thank Mr. Henry Odin Ajumogobia, Senior Advocate of Nigeria, former Minister of Foreign Affairs and Minister of State for Petroleum Resources, and founding partner Ajumogobia and Okeke. My thanks also goes to Lord Angus Glennie, QC, Senator of the College of Justice, Principal and Commercial Judge in the Court of Session, Scotland. I'd also like to thank Honorable Dame Linda Dobbs, BBE, Terry A. Mazur, Chair of the New York State Bar Association, Mr. Brian Spires, President of the Commonwealth Lawyers Association, Professor Patrick Lumumba, founder PLO Lumumba Foundation, Mr. Olawale Fakpohunda, Attorney General of Ekiti State, George Donko, President of ECOWAS Bank for Investment and Development, Dr. Obi Ezekwesili, former Vice President of the World Bank's Africa Division and co-founder Bring Back Our Girls, Mrs. Salamatu Husseina Suleiman, immediate past ECOWAS Commissioner for Political Affairs, Peace and Security, and former Minister of Women Affairs and Social Development. I'd also like to thank our keynote speaker, Mrs. Ibukun Awushika, the chairman of First Bank of Nigeria. She continues to do this nation proud in all her endeavors. I don't want to take for granted our anchors, Mrs. Mo Abudu of Ebony Light TV, who conducted the interview with Mr. Tony Blair. And I'd also like to thank Dr. Nduka Obagbena, Chairman and Editor-in-Chief, This Day Media. Nduka, thank you very much. You have always been so supportive of everything we do. And I'd also like to thank Paula Hodges, QC, partner at Herbert Smith, Free Hills, Professor Gitu Muga, former Attorney General of Kenya, Dr. Femi Ilasa, UN Assistant General Secretary and Visiting Professor of International Law, Queen Mary University of London. I want to thank, when we come back to our own, all the past presidents of the Nigerian Bar Association. Your stories were very rich. History is what defines the future. And you were there to let us know your time in office. We thank you for the time spent with us. I want to thank the section, especially section chairs, sections of business law, section on legal practice, and the section on special public interest, SPIDAL, for the programs you richly donated to this conference. As I mentioned in one of the sessions, the NBA feeds off its sections and fora. And when we plan conferences like this, they give us the content with which you see we serve you the rich menu that you all got during this conference. We want to thank the numerous bar associations globally who identified with us. But we have to give special word to our sponsors. Our headline sponsor, the Rivers State government, who, not just because His Excellency Nyesom Wike is a lawyer and a life bencher, but because of the demonstrable interest he has taken in the legal profession and all that concerns us. At very short notice, we go to him and he's there. He's doing it for the bar. He's doing it for other elements of the legal profession. Again, thank you very much. We thank all our friends, all our platinum sponsors. And in this regard, I thank in particular the prestigious Access Bank, that's rapidly becoming one of the largest banks indigenous to the continent of Africa. In particular, my good friend and brother, Dr. Herbert Higwe, the CEO, under whose direction the bank continues to grow from strength to strength. I want to thank our telecommunications partner, the MTN, everywhere you go. When I spoke to them about sponsorship, they did acknowledge the hard times, but they said for the NBA, we will do anything. They provided data which we freely distributed to the young participants that enabled them enjoy this conference. Thank you, MTN, and God bless you. We also like to thank the following law firms who have also shown big support to all our efforts. In particular, I want to mention Paul Usoro and Co., Aluko and Oyebode, George Etomi and Partners, Alliance Partners, Banwo and Igudalo, Templars. All these have in the gold sponsorship category. I also want to mention Zenith Bank too. They've also been one of our biggest supporters. We would also like to thank the Nigerian Law Publications, Law Breed, and DSC Publications, who are all using the event of the Diamond Jubilee Conference to showcase exciting products and new publications. And we encourage delegates to navigate the website for more information on these exciting opportunities. We want to also recognize Lotrella, Philips Consulting, PwC, Microsoft, TaxAid, Sparkle, DCL, SCL Corporate Services Limited, Glimpses Legal Training, and the Nigerian Law School class of 1989 for partnering with us for this very unique conference. I want to also thank our media partners, Channels Television and CNBC Africa. You've done wonderful and given us your exceptional coverage as you've always done. If I have left anyone out, I take personal responsibility for it. But most of all, I want to thank all you delegates, over 25,000 of you, who stayed loyal and faithful to our association. When we started the planning, we were thinking about 10,000, and we even thought that would have been a difficult number to attain. But we saw the numbers climb, and between yesterday and today, we had over 3,000 new registrants join us for this conference. It goes to attest to the fact that indeed you have all stepped forward in this journey to change and reinvigorate our country. All the discussions will come out in a communique, and representations will be made to the appropriate quarters so that we can work together with government to forge a partnership to make this country even greater than it is already. Finally, on behalf of the chairman of the TCCP, Professor Koinsola Ajayi, and all the great members of the TCCP. In those good old days, I would have called everybody to the stage to come and take a bow. I know you can't do that, but all your efforts are so appreciated. You've been so wonderful. We've had our difficulties planning because we were all in uncharted territories, because this was the first time a virtual conference was going to be planned. But you stayed the course, you stayed faithful, and we delivered. So on that note, I also want to thank our wonderful crew, Cogito, DKK, Crystal Digital, every one of you. You guys went beyond the call of duty. I know we negotiated you to bare bones. Lawyers don't blackmail everybody, but we kept reminding you that you are traditional partners, and from time to time, you must stand by us in time of need, and you did. And when the times are good, I promise you will stand by you as well. But you did a first-class production, because our concern and our worry was how could we deliver a first-class conference, and you guys all came through for us. God bless you. And as we bring down the curtains for the 2020 Annual General Conference, first virtual conference, in 2 days' time, the Paul Usoro administration will be bowing out with their, we call it bowing out, but they're actually leaving with their heads high up. They're living in a blaze of glory. And we're looking forward to the administration of the Olu Akpata-led executive committee. We look forward to the bar stepping out, stepping forward, and doing what it knows how to do best: promote the rule of law and protect the rights of the citizens. Thank you, and see you in 2021.
My name is J12. Step forward, MBA. Step forward, step forward, MBA. Step forward. MBA at 60. step forward in style. The largest bar in Africa, step forward in style. Happy anniversary, step forward in style. Happy anniversary, step forward in style. It's not easy to be 60. Okay. We've passed through a lot of hardship. We have courage to keep pushing. It will always end in victory. Excellence and integrity. Professionalism always. Hey. MBA at 60, step forward in style. The largest bar in Africa, step forward in style. Happy anniversary, step forward in style. Happy anniversary, step forward in style. MBA at 60, step forward in style. The largest bar in Africa, step forward in style. Happy anniversary, step forward in style. Yeah, happy anniversary, step forward in style.